first ever simulated convention of states. We're in Colonial Williamsburg. My name is Rick Green. We're here with Mark Meckler. He's the president of Citizens for Self-Governance, and also with Ken Clark. He's one of our regional directors for Convention of States. Guys, what an exciting day, what we're about to see happen behind us.
Yeah, it really is exciting, and for those of you who are online, there's a lot of time and effort that lead up to this day. Pretty extraordinary 3 years to get us to this point, to get here to Colonial Williamsburg. And this is the real deal. I mean, this is kind of the precursor to the real Super Bowl. It's sort of a dress rehearsal, right? Folks from, as you said, delegates, commissioners from all 50 states have come here, traveled away from their families across the country to try out that process given to us by the founders in Article 5.
Why is that important to have essentially a practice run, to do this in a simulated version first?
Look, it's never been done before in American history. The founders bequeathed us Article 5. They said to us, if the government ever becomes a tyranny, we're going to give you this gift. You get a chance to get together, get your commissioners together from all over the country and restrain that tyranny. But because it's never been done, we wanted to see it done. We want it to be tried out so people understand, how does it work? What kind of rules are there? What will be an interplay between commissioners? You know, when you're going to do something this important, it's important to practice.
Right. This is kind of putting the meat on the bones. You know, Ken, you've been working in a regional capacity. How cool is this to now see them from all over the country coming together and it actually happening?
You know, it's amazing. And I want to thank the millions of volunteers that we have nationwide, because without them, this wouldn't have happened. And so we've got state directors in all 50 states. We've got state level teams. We've got district captains. We've got volunteers that helped put all this together. So this is a culmination of work from just hundreds of thousands of volunteers all over the country. And it's because of them that we are here and we were able to do this. And so we really need to acknowledge them.
Well, it's a great point. And folks at home that are watching may want to know what they can do as they're watching today. So make sure you check out conventionofstates.com throughout the day to find out how you can get involved. Why Colonial Williamsburg? Mark, why don't you pick here to have the simulated convention?
Well, you know, if you read your American history, oftentimes we read about Philadelphia and Independence Hall, we hear about Boston, but the reality is most of the founders came here at some point to Colonial Williamsburg. It was the original seat of government here in Virginia. Virginia was the biggest and most prosperous colony, so it was just a natural home for the development of the ideas that led to this great American experiment. And so literally the debates that took place in some of the public houses, like we had dinner in last night, places like that, that's where the American Revolution
Well, you set the bar high. Patrick Henry spoke to him just a few minutes ago.
Incredible, absolutely.
Well, it's time to get started.
Commissioners, good morning. Well, let's try that again. Commissioners, good morning. Good morning. That is much better. Much better. Welcome back for day 2. Thank you for the work that you've done in your committees. I've had the opportunity to discuss with a number of you what went well, and repeatedly it was to see the process work, to see people come together from so many different places, different ideas, and work in their committees and have proposals come together. It was exciting. Thank you for being back. Let's start our day this morning. We're going to have our secretary call the roll. If you would please announce present as your state is called.
Thank you, Mr. President. We'll call the roll in alphabetical order, beginning with the state of Alabama. If a quorum of your state delegation is present, would the state delegation chairperson please indicate that the state is present? Alabama. Alaska. Arizona. Arkansas. California. Colorado. Connecticut. Delaware. Florida.
Mr. President, the Sunshine State is present accounted for, looking forward to another bright day.
Georgia. Hawaii. Idaho. Illinois. Indiana.
Hoosiers are here.
Iowa. Kansas.
Great state of Kansas is here.
Kentucky.
Kentucky is present, but without a quorum today.
Louisiana.
Present.
Maine.
Present.
Maryland.
Maryland, you'll find seat this year.
Massachusetts.
Present.
Michigan.
Here.
Minnesota.
Present.
Mississippi.
Back on the station.
Missouri,
Show me state is present. Very we shall.
Montana, Nebraska, Nevada,
Nevada's president, after listening to Patrick Henry, the battle for our state is ready for business.
New Hampshire,
Present.
New Jersey,
Present.
New Mexico, New York,
Present.
North Carolina,
Present.
North Dakota,
Present.
Ohio, Oklahoma,
Present.
Oregon,
Present.
Pennsylvania,
Present.
Rhode Island,
Present.
South Carolina, South Dakota, Tennessee,
In War of 1812, we were called on for 3,000 volunteers. We sent 36,000. That's why we will forever be known as the volunteer state. We are present.
Texas,
Our state is present.
Utah,
Utah is present.
Vermont,
The Green Mountain State is present.
Virginia,
Here.
Washington, West Virginia, Wisconsin, Wyoming. Mr. Chair, we have 49 of the 50 states present with a quorum. We have a quorum for the body.
Thank you, Mr. Secretary. With that, we will proceed to honor God and country. We have the prayer first from Michael Ferris, and then I will be pleased to lead you in the Pledge of Allegiance.
It was a privilege for me as the founder of Patrick Henry College to greet Patrick Henry this morning, and he seemed fittingly pleased that a college had been named in his honor. Let's pray together. Gracious God, our Father, I thank you so much for the men and women in this room who take the freedom, justice, and what is right so seriously. Lord, I pray that you would bless the efforts of today. May it light a fire that fans out throughout the nation. And may people who stand for what is true and what is right and what is good catch the vision for what is possible through this process. Lord God, I pray that you would deliver our nation from those who wish to enslave us. Lord, I ask you that you would indeed preserve the legacy of self-government and liberty under one nation, truly under God. Lord, I thank you that you have intervened in our lives in so many ways and give us so many countless blessings. We count it a great blessing that we live in the greatest land of this world. Thank you so much for the opportunity we have to lead and to participate and be good, faithful citizens of this country and of heaven. I pray all this in the powerful and matchless name of your Son, Jesus Christ. Amen.
Amen. Please follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you, Commissioners. You may be seated. You should have on your desks in front of you the minutes from our activity yesterday and also the proposals that came out of the various committees. If you've had an opportunity to review the minutes, I would entertain a motion on the minutes. Motion from Delaware. Do I have a second on the motion?
Michigan second.
Michigan second. Any discussion to the motion on the minutes? Hearing none. All in favor, please say aye. Aye. Any opposed? Thank you. Our minutes are approved. We will next move to our committee reports. We have our committee chairs. May we have them all? Let's see. We've got our committee chair first. Let's go to our chairman of the Fiscal Committee, Senator Lundberg from Colorado for the Fiscal Committee.
Thank you, Mr. President. I move the committee report from the Fiscal Restraint Committee, which includes 3 proposals. The first one deals with debt limitation and balancing the budget. The second one deals with the repeal of the 16th Amendment and the acknowledgement that the Congress has the power to levy a tax on the sale of goods as the alternative. And the third one deals with a line item veto. And I ask that the report be approved and that these measures be considered later in the course of our business today.
Thank you, Commissioner. The motion is to adopt the committee report from the Fiscal Restraint Committee and to set these matters at the appropriate time for debate before this body. Have a second to the motion? Have a second. Any discussion of the motion? All in favor, please say aye. Aye. Any opposed? That motion is approved. We will next move to the chairman of the Federal Legislative Executive Jurisdiction Committee, Commissioner Rob Standridge from Oklahoma, for the committee report.
Thank you, Mr. President. First, I'd like to applaud our committee and subcommittee chairman. It was just such a great process and experience yesterday, and I want to applaud every member of our committee. And we have 3 proposals. I'd like to move that we accept the committee report on these and debate and adopt at the appropriate time. First proposal submitted by subcommittee by Chairman Caldwell is dealing with the commerce portion of our discussion in our committee. Unfortunately, the best part, the preamble, was left out. I think in honor of one of our senators here, we got rid of all legislative intent in our bills. I think we decided to do so in our committee. But anyway, that report or that proposal is there for your perusal. The second one is Commissioner Casper, as chairman of that subcommittee, is the abrogation, which is the reactive part of getting rid of laws, regulations that are onerous to states. The third proposal, Chairman Holman, has to do with this is the rules subcommittee drafted this. I'll leave it to the commissioners to read these, but would submit this committee report for adoption and move so and debate at the appropriate time.
Thank you, Mr. Chairman. The motion is to adopt the committee report and set the proposals for debate at the appropriate time. Any second to the motion? Second from Arizona. All in favor, please say aye. Aye. Any opposed? That motion is approved. We will next go to the committee report from the Term Limits and Federal Jurisdiction Committee. Chairman Vance Wilkins, Virginia.
Mr. President and members of the Commission, we have 2 resolutions. One is concerning the limitation of terms for Congress, and the other is the overturn of judicial decisions by the states or by the Congress. I move the adoption of the committee report and request that debate be scheduled at the appropriate time. Thank you, Mr. President.
Thank you, Mr. Chairman. Motion is to adopt the committee report from the Term Limits Federal Jurisdiction Committee and to move those proposals at the appropriate time and order today. May I have a second to the motion? Second from North Carolina. All in favor of the motion, please say aye. Aye. Any opposed? That motion is carried. Thank you, Commissioners. We have a great deal of work to do today. First of all, I want to thank you for your work yesterday. It is a testament to the process that so many people from so many different backgrounds coming together to bring proposals in the limited time. We understand that in a simulation, we do have a limited time to discuss and debate these proposals. They are weighty and they are important. Not to take anything from that, we have 8 proposals and we do not have 8 hours today. As we were driving back from James Madison's house on Wednesday, there was a car wash that had a sign. It said, "Be brief, no matter how long it takes." I would urge you, commissioners, today, be brief, no matter how long it takes. as we move through these. In that light, may I please have the committee chairs and vice chairs stand? We have from the Fiscal Restraint Committee, Senator Lundberg from Colorado. We also have Matt Caldwell from Florida as the chairs for that committee. I'm sorry, Representative Caldwell. Oh, I'm sorry, I got crossed. Representative Wilson, please. Representative Wilson from Alaska. And then also from the Federal Jurisdiction Committee, we have Representative Standridge, Commissioner Standridge from Oklahoma, Commissioner Caldwell from Florida, and then from the
Term limits.
from the Judiciary, the Term Limits Committee, we've got Chairman Vance Wilkins and Vice Chair Alan Hayes from Florida. As you know, in your own committees, there was a great deal of discussion, a great deal of debate, a number of questions that came up and were resolved. I would invite you commissioners to sidebar with these chairs and vice chairs, the members of your delegation from these committees, to the extent possible. We don't want to limit debate in any way, but to avoid duplication of discussion, if there's any way that you can get your questions resolved to the extent that you have them in sidebar conversations, would you please seek out these chairs and vice chairs of those committees, and as much as you can in sidebar, let's see if we can deal with those. I would also like to thank these chairs and vice chairs for their work. I know that was a tremendous opportunity and a great deal of work in such a limited time. May we please thank these chairs and vice chairs for their efforts yesterday. I'm reminded that as we have the opportunity to move forward, we'll begin with the first proposal. As you press your microphone and stand, you'll be recognized. We have pages, I understand, that will be coming around with your state's name to recognize you. We'll try to recognize you in the order that you stand, and you're all familiar with the rules as we go through in terms of the speaking order, speaking times. We'll please ask you to observe that and observe the car wash rule today to the extent that you can. We will begin with proposal number 1 from the, and just from an order standpoint, we're going to come through the order that we presented these. We will start with the first proposal from the Fiscal Restraint Committee. We will next move to the first proposal from the Federal Legislative Executive Jurisdiction Committee. We will next go to the first proposal from the Term Limit Committee, and then we'll work backwards. We'll go to the second proposal from the Term Limit Committee and work back through, and hopefully we'll get through all of these proposals today. So starting with the first proposal from the Fiscal Restraint Committee, Senator Lundberg, or your designee, would you read through and present this proposal? The time is yours.
Thank you, Mr. President. I appreciate that. The first proposal, and in your notes, our committee actually did assign titles. We spent some time discussing that, but it really is not a part of the actual proposal to be considered. So this is proposal number 1 from the Fiscal Restraints Committee, essentially dealing with the limitation on the ability of Congress to increase the public debt. This is much in line with many of the components of balancing the budget. Hence, actually in our title description, we had wrestled between debt limitation and balanced budget amendment, and settled on the debt limitation, but it deals with the area of, as it says, the public debt shall not be increased except upon a recorded vote of 2/3 of each House of Congress, and only for a period not to exceed 1 year. And that's an important point. Section 2, no state or any subdivision thereof shall be compelled or coerced. That's a word that we worked on to ensure that it was clear that Congress nor the President may coerce or compel the states with the appropriation of money. And third, the provision of this section of this amendment shall take effect 3 years after ratification. Again, that length of term of when it will take place was another item for considerable debate and discussion. we present this to the convention as a whole, and I move proposal number 1 from the Fiscal Restraint Committee.
The motion is to adopt proposal number 1. Do I hear a second to the motion? Motion is seconded from the Commissioner from Arkansas. Discussion to the motion. Yes, the gentleman from Michigan.
Yes, Michigan. I'm afraid that the more words you give a court, the more options they have to muck things up. I would want to amend it. Instead of compelled or coerced, I would replace those 3 words with the word required. With that change, I would support the amendment.
So if I may, Commissioner, in section 2, the motion is to the words compelled or coerced, change that to shall be required.
That's correct.
So that would read, no state or any subdivision thereof shall be required by Congress or the President to appropriate money.
I think technically I would have to offer that as a friendly amendment.
Shall be required. Do I hear a second to the motion to amend?
Second.
There's a second from
Indiana.
Discussion to the motion to amend. Yes, the gentleman from Wisconsin.
Gentleman from Virginia.
Virginia, excuse me. That's a critical error on my part. Our host of Virginia. Gentleman's recognized.
There are a couple of Redskins fans in Virginia as well, just so Wisconsin knows. Mr. President, I would encourage that we retain the language as debated in our committee. We spent a good amount of time talking about this topic, and it was the sense of the committee, I believe, in deference to the chairman, that we wanted to make clear to the Congress that we find the debt to be obscene. And we want to make it very, very clear in this second portion of this resolution that we will not be compelled or coerced to appropriate funds that they may press upon us. And while required is certainly a satisfactory word, we believed it was important to make this point very clear. And so I would encourage the body to accept the language that was overwhelmingly supported in the committee. Thank you, Mr. President.
Thank you, Commissioner. I would remind you, this is being recorded and streamed worldwide. Please, if you will, make a point to speak into your microphones. I'll recognize the Commissioner from Arizona.
Thank you, Mr. Chair. Senator Lesko from Arizona. I agree with the previous statement. I agree that we should retain compelled and coerced. I believe it is a more appropriate term, and I support the committee on this. Thank you.
Thank you, Commissioner. Further discussion to the motion to amend. I'll recognize the gentleman from West Virginia.
Thank you, Mr. Chair. As it relates to this particular amendment, I think the compelled or coerced is the better terminology, but I would also point out, I think there's a few things. First, we have, beyond compelled or coerced, we have incentivized. How many people in here right now are wrestling with the question, do we give up our federal education dollars or do we send the boys into the girls' showers? Okay, so this doesn't answer that question for sure, whichever language we use here. The second thing that I would point out that is, I believe, a deficiency in this particular section of this is that it says Congress or the President, and yet I know that there are a number of commissioners here who represent states that have had federal judges literally order the state to raise taxes in order to fund that judge's priorities. And so this clearly, and I assume that that was done deliberately in committee, excludes the federal judiciary from this question. And I don't believe that would be appropriate. I think the state should be allowed to run the state's business. So I'm in opposition to this particular amendment, but I think this entire section needs considerable more work.
Thank you. Further discussion of the motion. Gentleman from New Hampshire.
Thank you, Mr. Chairman.
Commissioner, is your microphone on? I don't think we're picking you up. Lights on, nobody's home, unfortunately. There we go, thank you.
Thank you, Mr. Chairman. Commissioner Daniels from New Hampshire. I rise in opposition to the motion of replacing the wording. We talked a lot about the word coerce, and think in terms of that the federal government does not require you to spend money on EPA mandates. However, they will withhold funds that could go to your state or penalize you if you don't do it. So while there is a requirement, there is no requirement that the state do that. The word coerce takes care of that, that instance. So I would encourage you to vote against the amendment and keep the wording as it is.
Thank you, Commissioner. I would also remind the body again, we have 8 items and we don't have 8 hours. And so please, if we can avoid duplication, if someone has stated your point, we can move through and move through the items. I don't want to cut off debate in any way, but we do have a lot of work to do. Recognize the gentleman from Texas.
Move to table the amendment.
The motion is to table the amendment? There's a motion to table the amendment and we have a second. There's no discussion to that motion, as I understand, correct? So place the motion. The motion is to table this proposal. All in favor, please say aye. Aye. Opposed, please say no. No. I'm going to call for a roll call vote, Mr. Secretary. The motion is to table the proposal. Is it to table, excuse me, gentleman from Texas, is it to table the motion to amend to table proposal 1?
To table the motion to amend.
Yeah, I think that's not in order. I think you can call the question.
I can move to table the amendment.
Yeah, I don't believe it's in order to table the amendment. I think you can call the question on the amendment or table the entire proposal.
Call the question on the amendment.
Your point of order is recognized. Gentleman from
Tennessee.
Tennessee.
A motion to table is proper on an amendment.
Is that I'll defer to our parliamentarian.
I don't think that's the case, but I will verify.
Again, as we're waiting, I would encourage you, to the extent possible, to sidebar with the chairs and the members of those committees in the discussions, to the extent possible. Again, not to limit debate in any way, but to the extent that you have questions. And we gained a lot of experience in the debate and in the discussion in that process of developing and sifting and molding the language. I would encourage you to take the opportunity to do that. I think in the interest of time, what's that? So we have our parliamentarian instructs us that a motion to table under Mason's rules is not applied to a motion to amend. Gentleman from Texas, is that a motion to call the question then?
Motion to call the question.
Motion is to call the question. There's a second. So the motion to amend, striking the words compel or coerce, replacing them with required, is before the body. Voting yea is to amend. Voting nay is to strike down the motion to amend. All in favor of the motion to amend proposal 1, please say aye. Aye. All opposed, please say nay. Nay. I will rule that the motion fails. Further discussion to the motion to adopt proposal 1. Gentleman from California is recognized.
I think the comment earlier regarding the limitation of Section 2 to Congress and the President was well taken. I propose to amend that by saying no state or any subdivision thereof shall be compelled or coerced by Congress or by any member of the federal executive or judiciary to appropriate money.
So the motion is in Section 2 of Proposal 1, no state or any subdivision thereof shall be coerced or compelled by Congress or any member of the federal executive or judiciary.
Yes. To appropriate money.
Okay, if you can write that out for us, please. And to the extent possible, if you have amendments, if you can put them in written form, it would be very helpful. Can we get that language up here for the members to see?
Yes. We'll be up momentarily.
Mr. Secretary, are we?
Yes, we'll be up momentarily.
Okay. Oh, that's great. Thank you. Thank you. As a matter of procedure, while that's getting up, if when I call for a voice vote, if the chairs of your delegation would voice the vote for your delegation rather than all. I know we're robust and we've got that energy going. If we could have the chairs wage the voice vote. I know for most of us that becomes a Pavlovian reaction that when it's called, we just automatically vote even if we're in the other chamber, but we'll do our best to restrain ourselves. Are we up?
Yeah, we're up.
Okay, so the motion is to amend Section 2, no state or any subdivision thereof shall be coerced.
All right, guys, so we are into it already. First Amendment that is being discussed by the entire body. Walk us through, first of all, what happened initially. There was a report from each of the committees. Tell us what was happening there.
Basically, the way it works is, in order to summarize for the body what goes on, they had broken into 3 committees yesterday, one for each subject matter area. They had debates like what you're seeing today in committee privately. And so now the committees come in and they submit their report to the entire body.
And you had each of the states represented in each of those committees, right?
That's correct. Roughly 150 commissioners, roughly 50 per committee, so each state mostly represented in each committee. When they came back together as a whole body, it's important they submit those committee reports to the entire body. So that's the first thing that we saw this morning.
And then they made a decision to tackle this amendment first. One of the things that jumped out at me was, a lot of the opponents of a convention talk about, nobody knows what the rules are going to be. It's going to be hard to figure out. Well, we even saw a question about this particular rule, but very quickly, parliamentarian went back to Masons, figured out the rule, and the body solved the problem very quickly, I thought.
Well, and one thing that you need to understand is this is a very deliberative body, not very different than any state house legislature. And so they do have specific rules that they have to follow. They're following Robert's Rules of Orders and parliamentary rules. And so there is a process that they go through, and each person has the ability to amend if they choose, but they have to follow the rules of parliamentary procedure.
Yeah.
But this is a very deliberative body, and I think that is critical that the viewers understand that.
I thought that stood out yesterday in committee as well. Again, the opponents say, you're going to have people that don't know what they're doing. These are just legislators. These are seasoned veterans that know what they're doing. They're used to doing this. And I saw in the committee process exactly what we just saw a few minutes ago, talking through it, figuring it out, and then moving on down the road.
What we're seeing is what I would call true statesmanship, which is why I'm so encouraged for the country and what's going to come out of this. You're seeing statesmen and women stand up, express their opinions in a cogent and quiet way, and then get back to deliberations. And so I think just briefly what I want people to understand, they're operating according to a set of rules. Like you said, they've adopted those rules. You're going to continue to see this thing run according to those rules. We'll come back as developments occur and explain to people what's going on.
And this is a modified set of rules for a simulated convention.
Exactly.
But they've also been debating throughout the states a very clear set of rules for when the actual convention takes place.
That's correct.
It's going to be very orderly.
So let's go back to the proceedings here.
All right.
People do not stay on welfare and they become productive members of the society. I personally grew up in a family of 10. on welfare. I was well educated. I retired as a Marine Corps Lieutenant Colonel and a productive member of society. So if we do not educate our children, we're going to pay for them in welfare and other items. So we need to look at the quality of life and saving money.
Thank you, Commissioner. Further discussion of the motion to amend. The gentleman from West Virginia is recognized.
Thank you, Mr. President. I actually believe the argument that was just made by the commissioner speaking before me really illustrates the point of why we're all here. We have a federal government that has reached way outside the boundaries of what is plainly delineated within the Constitution. The idea that the federal government could order any state to spend money on education when education is clearly a state priority and a priority that should be set by the states. Frankly, I'm surprised here in this particular body, what I just heard was a plea to the federal government to be our nanny and to tell us what to do. It doesn't matter if it's the judiciary or Congress or whatever. The states and the federal government have particularized roles, and they need to stay within those roles. And the problem that has brought us all here is that we have a federal government that is no longer staying within its proper role. So I strongly support the amendment, and I would, I guess, plea with the fellow commissioners here to think about why it is we're here. Are we really wanting to say we want the federal government to tell us how to do this? Because if we are, I think we're wasting our time.
Thank you, Commissioner. Further discussion of the motion. Gentleman from Ohio.
Mr. President, I'd be less than honest to say that I agree with most of what came out of our committee, because there is this thing called reason. Because although we here believe we are the last word, we are not. To violate the separation of powers in this amendment by pulling the president or the executive branch out, the judiciary branch out, and including the Congress, and then say we're not changing the Constitution, I think it's less than honest. Much of what we're trying to do, I'm here because I agree with. But it must be done with some reason and consideration. So at the end of the day, people say it can be done, it will not run away, and that is what we'd like to see done. Elimination of parts of the Constitution, violating the separation of powers. I don't think we're here for that. So I have voted against, and with the agreement of my other commissioners, most of what will be presented today, because I believe that we need more time and more perspective before we present something to the public that we've lived under for more than 200 years. Thank you, Mr. President.
Thank you, Commissioner. Gentleman from Arkansas is recognized.
Thank you, Mr. Chair. I just wanted to address the latter part of that, the judicial branch. One thing that I'm a little bit concerned of is that if the Supreme Court were to rule that the, let's say Medicaid, for example, is an entitlement program that a individual is entitled to, maybe under the 14th Amendment, something along those lines, then they could actually compel a state, if the Congress doesn't have the authority, if the executive branch doesn't have the authority, they could actually still compel a state to make appropriations to provide for that. So I do think it probably would be appropriate to include the judicial branch within this. And if we did not, I think that there's actually a very reasonable possibility that they would require states to make appropriations on Medicaid or other programs that could be considered entitlements.
Thank you, Commissioner. Gentleman from Virginia is recognized.
Mr. President and Commissioners, I like this amendment very much, but I don't believe we should put it in this particular resolution. If we load a resolution up with too many different parts, we get opposition from too many different places. So it's better to leave it simple and direct as it is originally. And if you want to do the judiciary, you should have a separate resolution for that. Let it stand on its own.
Thank you, Commissioner. Further discussion of the motion. The gentleman from Rhode Island is recognized.
Good morning, Mr. Chairman, or Mr. President. I'm concerned about this language here because I'm concerned that we have a diversity action, members of one state filing suit in another state for, say, a contract violation or something along those lines. and there's an order that comes down from a federal judge, pay these individuals. And if it's a state that's a defendant, this type of amendment here seems to me to be ill-considered, because there's at least a concern that that could be considered an appropriation or would require a state appropriation, and as a result, we have people with no access to justice. So I think this is ill-considered at this time. There may be appropriate language, and I understand the concerns relative to programmatic appropriations, but just the regular course of the judiciary and adjudicating disputes between two parties, this seems to be a significant and unwarranted limitation on the judicial branch.
Recognize the Commissioner from Arkansas. Call the question. The question's been called. All in favor of calling the question, chairs of your delegations, please say aye. Aye. All opposed to calling the question, say nay. Nay. Roll call vote. Yes, please, Mr. Secretary, please call the vote.
Okay, if the state delegation chairpersons would please quorum with or caucus with their delegation, and please determine how their state will vote. Beginning with the state of Alabama, on the motion to call the question. Alabama votes yes. Alaska.
Yes.
Alaska votes yes. Arizona.
Arizona votes no.
Arizona votes no. Arkansas.
Yes.
Arkansas votes yes. California.
Yes.
California votes yes. Colorado.
Yes.
Colorado votes yes. Connecticut.
Connecticut votes no.
Connecticut votes no. Delaware.
Delaware votes yes.
Delaware votes yes. Florida.
Florida votes no.
Florida votes no. Georgia. Georgia votes yes. Hawaii.
Hawaii votes yes.
Hawaii votes yes. Idaho.
Yes.
Idaho votes yes. Illinois.
Illinois votes no.
Illinois votes no. Indiana.
Indiana votes yes.
Indiana votes yes. Iowa.
Yes.
Iowa votes yes. Kansas.
Kansas votes yes.
Kansas votes yes. Kentucky.
Kentucky, yes.
Kentucky votes yes. Louisiana.
Louisiana votes yes.
Louisiana votes yes. Maine.
Maine votes yes.
Maine votes yes. Maryland.
Maryland votes yes.
Maryland votes yes. Massachusetts. I'm sorry?
Yes.
Massachusetts votes yes. Michigan.
Michigan votes yes.
Michigan votes yes. Minnesota.
Minnesota votes yes.
Minnesota votes yes. Mississippi.
Mississippi votes yes.
Missouri.
Missouri votes in the affirmative.
Missouri votes yes. Montana. Montana votes no. Nebraska.
Nebraska votes yes.
Nebraska votes yes. Nevada. Nevada votes yes. New Hampshire.
New Hampshire votes yes.
New Hampshire votes yes. New Jersey.
New Jersey votes yes.
New Jersey votes yes. New Mexico.
New Mexico votes yes.
New Mexico votes yes. New York.
New York votes yes.
New York votes yes. North Carolina.
North Carolina votes aye.
Is divided? North Carolina
Yes.
is divided? Okay.
Yes. North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio. Ohio votes no.
What? No. What? No. Ask for
Oh.
clarification.
Is it Ohio?
No.
Oklahoma.
Mr. President, can we have a point of clarification, please?
Yes, ma'am.
Is the motion to lay the amendment on the table, or is the motion
No,
to
the motion is
adopt this to the
the motion is to
Constitution?
call the question on the amendment.
Okay, well then it's a no.
I'm sorry, I can't see where the question is coming from. The motion is to call the question on this amendment.
Oklahoma votes yes. Oregon. Oregon votes yes. Pennsylvania. Pennsylvania votes yes. Rhode Island.
Yes.
Rhode Island votes yes. South Carolina. South Carolina votes yes. South Dakota. South Dakota votes yes. Tennessee. Tennessee votes yes. Texas. Texas votes yes. Utah. Utah votes yes. Vermont.
Yes.
Vermont votes yes. Virginia.
Yes.
Virginia votes yes. Washington.
Yes.
Washington votes yes. West Virginia. West Virginia votes no? Abstain. Okay, West Virginia abstains. Wisconsin. Is Wisconsin present? Is there a vote from Wisconsin? Wisconsin not voting. Wyoming.
He's right there.
Wyoming votes yes. The result is 42 in favor of calling the question, 6 opposed with 2 abstentions.
We must have some really loud nay voices in here. We got to get that balance a little bit better. All right, so the motion passes. To call the question, I will now place the question on the motion. The motion is to amend Section 2 of Proposal 1 as shown on the screen. All in favor of amending this proposal as shown on the screen, chairs of your delegations, please say aye. All opposed, please say nay. I'm going to rule that that motion fails. Yes, gentleman from Missouri.
Thank you, Mr. President. I wish to speak on the underlying proposal.
Thank you. So we're back to the underlying motion. Yes, the gentleman is recognized.
Thank you, Mr. President. I rise to speak in support of the proposal. While it is not perfect, it is certainly good. And let not the perfect be the enemy of the good, but let us accomplish something. I believe it's an ancient truth that the borrower is servant to the lender, as Solomon said. You know, the legal terminology for a loan and a security agreement, those two pieces of paper, the legal terminology, while I'm not an attorney, I'm told is chattel paper. And I think we all know what chattel is. So let there be a recorded vote in Congress, and let us see who is to make servants of all of us. I think it is incumbent upon us to consider the road signs that the nation has seen over these last decades. And I think it is incumbent upon us as state legislators and as commissioners here today to look to the future and have a global perspective on what is going on in the world. One of the nations that we borrow from the most is making grave expansions in the South China Sea with man-made islands. Let us not become their servant. This is a matter of national security, and I believe it is important that we at the state level consider our role when we pass a budget that includes, quote, federal money. We bear some of the responsibility. There is no difference between federal money and state money. There is only money which comes from the taxpayer, and let us not burden future generations with massive inflation as a way to pay for it. So I rise to support this, and I believe it is wise in its choice out of the committee, because even the correction to our errors over the course of decades going into debt must be done with caution and wisdom so that we don't move too swiftly and cause disruption in the nation. So I support this and I commend the committee. Thank you, Mr. President.
Thank you, Commissioner. Gentleman from Georgia is recognized.
Thank you, Mr. President. And I follow the good commissioner and ask for a call to the question.
Motion is to call the question on this proposal number 1. All in favor, chairmen of your delegations, all in favor, please say aye.
Aye.
Any opposed, say nay.
Nay.
I will rule that that motion carries. The ears are getting better this time. There we go. So we will place the question on the adoption of proposal number 1. I'm going to ask for a roll call vote on this, Mr. Secretary.
Thank you, Mr. President. Alabama. Alabama votes yes. Alaska.
Yes.
Alaska votes yes. Arizona.
Aye.
Arizona votes yes. Arkansas.
Yes.
Arkansas votes yes. California.
California passes for a moment.
Okay, California will come back around. Colorado.
Aye.
Colorado votes yes. Connecticut.
Connecticut votes no.
Connecticut votes no. Delaware.
Delaware votes yes.
Delaware votes yes. Florida.
Florida votes yes.
Florida votes yes. Georgia.
Georgia votes aye.
Georgia votes yes. Hawaii.
Hawaii votes aye.
Hawaii votes yes. Idaho.
Idaho votes aye.
Idaho is divided?
No.
Oh, aye. Okay, Idaho votes yes.
Do have a speech.
Illinois. Illinois votes yes. Indiana. Indiana votes yes. Iowa.
That's a good point.
Yes.
Iowa votes yes. Kansas.
Kansas votes yes.
Kansas votes yes. Kentucky. Kentucky votes yes. Louisiana.
Louisiana votes yes.
Louisiana votes yes. Maine.
Maine votes yes.
Maine votes yes. Maryland.
Maryland votes yes.
Maryland votes yes. Massachusetts.
Massachusetts votes yes.
Massachusetts votes yes. Michigan.
Michigan votes yes.
Michigan votes yes. Minnesota.
Yes.
Minnesota votes yes. Mississippi.
Mississippi votes yes.
Mississippi votes yes. Missouri.
Missouri votes in the affirmative.
Missouri votes yes. Montana. Montana votes yes. Nebraska.
Yes.
Nebraska votes yes. Nevada. Nevada votes yes. New Hampshire.
New Hampshire votes yes.
New Hampshire votes yes. New Jersey.
New Jersey votes yes.
New Jersey votes yes. New Mexico.
New Mexico votes yes.
New Mexico votes yes. New York.
New York votes yes.
New York votes yes. North Carolina.
North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio.
Votes no.
Ohio votes no. Oklahoma.
Oklahoma votes yes.
Oklahoma votes yes. Oregon.
No.
Oregon votes no. Pennsylvania.
Yes.
Pennsylvania votes yes. Rhode Island.
Yes.
Rhode Island votes yes. South Carolina. South Carolina votes yes. South Dakota.
Yes.
South Dakota votes yes. Tennessee. Tennessee votes yes. Texas. Texas votes yes. Utah. Utah votes yes. Vermont.
Vermont votes yes.
Vermont votes yes. Virginia. Virginia votes yes. Washington.
Yes.
Washington votes yes. West Virginia. West Virginia abstains. Wisconsin. Do we have a vote from Wisconsin? Wisconsin not present. Wyoming. Wyoming votes yes. California.
California votes yes.
California votes yes. Mr. President, the votes are 45 yes, 2 no, and 2 abstentions.
Proposal number 1 passes. Good work, Commissioners. We will continue to remind you of the time. I think we're moving well. We'll keep on that pace as we go. We will now move to...
All right, well, we remain live here at the Convention Estates in Colonial Williamsburg, and joining us is Professor Rob Nadelson, probably the most read and studied on this process of anybody involved. How much is this like what you think the founders might have envisioned?
Well, they certainly wouldn't envision the video system, and they would not have envisioned the microphones, right? And they probably would be very pleasantly surprised at the number of states involved. They would recognize North Carolina and Georgia and Massachusetts, but there would be some very unfamiliar names. They probably thought of Wyoming as a portion of Pennsylvania or New York, which it was at that time. Wow. Not the current state, but the name. The procedure that's followed, however, is very close to that historically used by conventions of states all the way from the 1600s up until the last one we had, which was in 1922.
So this is not as new as what sometimes we think of it as. We think it's a whole new concept. No, this is actually a proven concept that's been used.
That's right. In fact, we've identified about 37 conventions of states or before independence of colonies.
Yeah.
the rules that they're operating under today were rules that were crafted based upon that accumulated experience. The last general convention, that is the last convention to which all states were invited, was held in 1861 in Washington, D.C. And so we use those rules as the basis for these rules. Of course, we had to update them to take into account such things as tablet computers.
Right, and truncate them a little for our simulated convention.
That's correct.
You write extensively about this, and folks, if you go to conventionofstates.com and click on Learn, you can actually see a lot of this history where you document it, you footnote it, it's all there. Let's talk about what just happened. So the first vote on an actual proposed amendment to the Constitution just passed by these guys.
Right. Under the rules, there are 3 separate committees, and one of those committees deals with the problem of federal fiscal excess. It comes up with proposals to try to rein that in. The first proposal was one of theirs, and it is essentially a balanced budget amendment. But instead of specifying revenues and expenditures, it talks in terms of debt. You can't run additional debt without a 2/3 vote of both houses of Congress, and that therefore requires a balanced budget. And so what we saw was that committee report discussed and then approved on a roll call of the states, as you can see, overwhelmingly. There were also 2 efforts to try to amend it, and the commissioners decided not to amend it.
And it was, what, 44-4 and just a few against?
Yeah, that's right. It was overwhelming.
And if this were the actual Convention of States, that proposed amendment would then go back to all 50 states for ratification.
That's right. That would be the proposal process, and it would be up to Congress then to decide whether it wanted conventions or legislatures in the states to ratify. But either way, you would still need 38 states to approve it, which is a pretty tough bar.
Right, which it's fortunately a very popular amendment and would have a good chance. We're going to go back to the actual action. They've taken up another amendment. Let's see what that one's all about.
Is a named institution in the Constitution, specifically Article 5 recognizes us as a political entity corporate within our states. We empower individuals to act on our behalf, and that would be the implication here as well, that we would be, as legislatures, empowering individuals to act on our behalf, most likely our attorney generals in this case. The final sentence of Section 3 outlines that this statement of standing guaranteed to state legislatures shall not be construed to limit standing that may otherwise exist for a person. And finally, Section 4 is an implementation period, not more than 5 years from the date of ratification. That is the proposal, Mr. President.
Thank you, Mr. Commissioner. You move the adoption?
I do.
Motion is to adopt a proposal. I have a second?
Second.
Second is from Delaware. Discussion to the motion. Gentleman from California is recognized.
Mr. President, I wholeheartedly endorse this amendment. The mission creep that we've witnessed over the last century by the Supreme Court has reinterpreted the limited commerce clause to be a general police power, allowing the federal government to regulate every aspect of life, including the core police powers that were explicitly reserved to the states by our Constitution and the 10th Amendment. The power to regulate and advance the health and safety and welfare and morals of the people is a power that was vested originally in and remains in the states. The Supreme Court decisions over the last century to the contrary notwithstanding. This amendment will restore that original constitutional balance and reinvigorate the notion that those core aspects of government belong closest to the people in the states.
Thank you, Commissioner. The gentleman from Virginia is recognized.
Thank you, Mr. Chairman. Would a question to the committee chair be in order?
I will recognize that. That is in order.
If the screen could go back to the first page, I have a question related to Section 1. And in particular, line 2, the reference to sale, shipment, transportation, or other movement of goods, articles, or persons. My question is whether that is contemplated to include or exclude financial transactions on the internet.
Mr. President?
Yes.
Thank you, sir. Thank you, Commissioner from Virginia. I believe the intent in Section 1 is to return the definition of Congress to that classical understanding of goods, articles, and persons. As you would read through Section 2, it would then exclude anything else to be under the power of Congress. That is the understanding as we put this together.
I thank the gentleman.
Chair will recognize gentleman from Tennessee.
Thank you, Mr. Chairman. Mr. Chairman, I would like to address the sponsor of the amendment, the Commissioner.
Yes, Commissioner Caldwell, will you yield for a question? I should have asked the first time. Commissioner Caldwell, will you yield for a question?
Yes, sir.
Proceed.
Thank you, Mr. Chairman. Commissioner, I am going to try to rephrase the question just asked by the gentleman from Virginia because I don't think you answered the question, and maybe not intentionally, but my question is going to be, will this allow Congress to regulate commerce through the internet that would be between states? Is that the intent of the amendment? I'm asking that because I'm trying to understand the intent of the amendment.
Thank you. Mr. President?
Yes, Commissioner.
Thank you, Mr. President. Thank you, Commissioner. I was attempting to answer the question more broadly than just the specific of internet, although it would depend on what commerce was being conducted. So again, as we review, the original understanding of commerce was the movement of goods, articles, and persons among the several states. And Section 2 is outlining that it cannot expand beyond that. So we had a great deal of conversation about, for example, financial transactions. Those would be excluded under Section 2 from the regulation. So we determined not to name specifically things such as internet commerce because it all depends on what commerce is being conducted and how that is occurring between the several states. Very simply trying to reiterate what the understanding of commerce was at the beginning and push back against the specific decisions that have expanded the application of commerce under necessary and proper. Not trying to be obtuse, but trying to address it's bigger than maybe that simple question.
Thank you, Commissioner. Yes, Commissioner from Tennessee, do you have a follow-up question?
Yes, thank you, and I appreciate that sentiment, and I appreciate the spirit behind the amendment. I still wonder if the wording of the amendment, though, does not leave to question whether commerce and goods going from state to state that are purchased electronically would be subject to congressional control, and was just wanting to know the thought that the committee had when they proposed the amendment.
Mr. President?
Yes, Commissioner Caldwell, yes.
Thank you, Mr. President. Thank you, Commissioner. Again, we discussed specifically financial transactions and intangible actions. I believe the committee's, well, since we did not specifically discuss internet transactions, I don't want to speak for the committee as a whole. I will share my thoughts that our intention, I believe, was to be limited and thoughtful and speak specifically to the actions we find objectionable, not try to anticipate or inadvertently create a scenario that creates difficulty moving forward, believing that none of us can predict what additional means or methods of commerce are going to develop in the future. I think that should be personally up to Congress. We're looking to address the specific infirmities that have developed previous to today in this amendment.
Thank you, Commissioner. Further discussion to the motion. The gentleman from Georgia is recognized.
Thank you, Mr. President. I just want to speak in favor of this amendment. If you study our history and you look around, there are many worthy amendments that we have that we will deal with here today. But if there is one thing that's expanded the power of Congress more than anything else that we've seen in our history, It's this misapplication of the Commerce Clause. And what we have here that we developed in the 5 hours and 6 hours that we had to debate yesterday, I think is a very solid attempt to rein in Congress and bring back the understanding of what the Commerce Clause was really intended to do. And so I would ask that this body today pass this amendment. Thank you, Mr. President.
Thank you, Commissioner. Gentleman from Michigan is recognized.
Kurt O'Keefe from Michigan, thank you. I believe I submitted for paragraph 4 a proposed amendment, which I believe does not change the substance of anything. Does the podium have that?
Mr. Secretary, do we have a written submission from Michigan?
All right, so let's get a little bit caught up on what's happening right now. They moved on to a second amendment dealing with the Commerce Clause. Ken, what's this supposed to accomplish?
Well, I was going to ask Professor Nadelson that very question because the Commerce Clause, in my mind, has been terribly abused by the Supreme Court. So, Professor, what can we accomplish by attempting to amend the Commerce Clause, and why the Commerce Clause?
Well, the Commerce Clause is a part of the list of powers of Congress in the Constitution. And what it says is that Congress shall have the power to regulate commerce with foreign nations among the several states and with the Indian tribes. And its original understanding was to enable Congress to regulate, say, the shipment of goods between state lines, and also certain incidents or ancillary matters having to do with the shipment of goods, as well as the shipment of goods and other things with foreign nations, with the Indian tribes. Over the years, the Supreme Court has interpreted the Commerce Clause in conjunction with another clause called the Necessary and Proper Clause to enable the Congress to control the entire American economy, not just that portion having to do with the shipment of goods and articles across state lines. So now we see the Congress regulating manufacturing, land use, mining, agriculture, the list goes on. And that was not within the original purview of the Constitution. So the intent of the amendment is to try to move the Constitution back to what was originally understood.
So, Professor, if an amendment like this, and we've seen the verbiage of the language of this amendment on the screens, and our viewers have seen that as well, what would be the impact if such an amendment were proposed by this body today and then ratified by 38 states and then implemented as an amendment to the Constitution?
Well, Congress would still have an enormous amount of power as far as regulating the economy is concerned. But certain matters, such as the regulation of manufacturing, labor relations, agriculture, and so forth, would be carried out at the state rather than the federal level.
Let's talk about why the states are having to jump in on this, right? Because we never amended the actual Commerce Clause to the Constitution. It's never been amended. But Chief Justice Roberts said in the Obamacare case that their power is well established. My question is, well established by whom? We, the people, never expanded it, but the court expanded it. So is this the only way for us to overturn that expansion?
Effectively, it's proven to be the only way. Over the years, people have said, well, if we can elect presidents who will appoint Supreme Court justices, that'll bring about change. But that, in fact, hasn't worked.
Yeah.
So we have to do it by constitutional amendment. I will tell you there's precedent for this, not specifically a convention, but there are several instances in which constitutional amendments were adopted specifically to override the U.S. Supreme Court. The founding generation encountered a decision very early on in our history in which they thought the Supreme Court was expanding its own power too much, so they passed the 11th Amendment, which overturned that opinion. The notorious Dred Scott opinion of decision of 1857, which declared that an African American could never ever be a citizen of the United States, an obviously erroneous decision, was overturned by the 14th Amendment. And most recently, a very confused Supreme Court opinion in Mitchell versus Oregon, adopted in 1970, was overturned by the 26th Amendment. So there is a pattern, and the founders envisioned the use of the amendment process for that, purpose.
They never envisioned the court to have the final say on every law in America and to essentially run the country. So there had to be a place for being able to overturn them.
They did envision the court having the power of judicial review.
Sure.
But they also envisioned the use of the amendment process as a way to rein in the court and, in fact, other branches of the federal government as well.
Yeah. All right, let's get back to the action on the floor.
time I've had to think about this, I doubt that it has a great deal of impact one way or the other, although I think I would prefer the original statement, which would apply to everyone to be responsible to make it effective rather than limiting it just to Congress. This is now reducing the entities that are responsible to uphold the fidelity of the amendment.
Thank you, Commissioner. Further discussion to the motion to amend? Seeing, yes.
Call the question, sir.
Gentleman from Georgia is recognized. Question's been called. It's a second to the motion. Motion is seconded. We place that motion. Chairs of your delegations, please, all in favor of calling the question, please say aye. Aye. Any opposed, say nay. I will place the motion to amend Section 4 as written on the screen. All in favor, please say aye. Aye. All opposed, please say nay. I will rule that motion fails. We are back to the underlying motion. Further discussion to the underlying motion. Gentleman from Mississippi is recognized. The gentlelady from Mississippi. Excuse me.
This would be a question to the chair, if I may.
Yes. So will you yield?
Thank you, Mr. Chair. Can you explain to me why you felt it necessary to add the last sentence on Section 2, but Congress shall have the power to define and provide for punishment of offenses constituting acts of war or violent insurrection against the United States? Just seems to me like that's redundancy of what's already in the Constitution, and I just want your thoughts on that.
Sure. Mr. President?
Yes, Mr. Chairman.
Thank you, and thank you, Commissioner. Much of Section 2, and I will share that both Section 1 and Section 2 were very fully developed amendments. We were blessed in our subcommittee to have 4 submissions, really 5, including a multiple purpose amendment with very, very similar language. And this was contained within several of the proposals based on a concern that reverting to the very narrow understanding of the federal ability to act within a single state would possibly create a conflict in purpose for Congress. And so this final sentence I would describe as a both suspenders and belt approach. It did not receive a great deal of discussion in our subcommittee. I will share that our advisor in the committee was a proponent of its inclusion, and in reflection, the subcommittee was comfortable to leave it in the language.
Thank you, Commissioner. And just as a matter of practice, if you direct your questions through the chair, and then we'll direct them back. The gentleman from North Dakota is recognized.
Thank you, Mr. President. I'd like to express the concern I believe brought up by a speaker from Alaska. As I read Section 4, the article shall be effective not more than 5 years. To me, that does mean that it has no effectiveness after 5 years, and it would either be shall be effected, or it should be shall become effective, so that we know that there's an act that occurs which shall be not more than 5 years, which makes it effective. So I move the motion that we change the word be to become.
Motion to amend is in Section 4. This article shall become effective.
Second.
Not more than 5 years from the date of its ratification. I have a motion and a second from
Second.
California. Discussion to the motion to amend. Ohio, would you wish to speak to the motion to amend?
Mr. President, if I may speak to the motion to amend, we also had a suggestion on language that I think would create clarity, and so if the sponsor of the amendment is willing to entertain amending his amendment, is that possible?
You want to reserve the right to make a motion to amend?
Yes.
Do you want to propose what you're suggesting?
Would that be appropriate in this context?
Yeah, I'll entertain that.
Thank you, Mr. President. So to create clarity, I would propose an amendment to strike not more than, so it would read, this article shall be effective 5 years from the date of its ratification. I think our goal was to create clarity on the period of time in which it could be adopted, but clearly upon discussion in this greater body, it has increased confusion. So to remove not more than, I think, would suffice.
And I think, Commissioner, the underlying motion was the article shall become effective. Are you willing to keep the word become and then strike the words not more than?
Yes, sir.
So the substitute motion to amend would be this article shall become effective 5 years from the date of the ratification. Did I read that correctly?
Correct, please, and thank you.
So that would be a substitute motion to amend. Do I have a second? I have a second from Delaware. Discussion to the substitute motion to amend. And let me go back to the gentleman from North Dakota. Is that
That's acceptable to me, sir.
friendly amendment? Discussion to the substitute motion to amend. Vice Chairman Caldwell.
Thank you, Mr. President. Without having polled my subcommittee members, I am comfortable with the amendment as proposed.
Friendly amendment all around. Discussion to the substitute motion to amend. Motion is to call the question from Delaware. Do I have a second? A second from Missouri. All in favor of calling the question, chairs of your delegation, please say aye. Aye. Opposed, please say nay. Place the question on the motion to amend. Chairs, please say aye. Let me place that again and make sure everybody's awake. Chairs, please say aye. Aye. Opposed, please say nay. That motion passes. Motion is amended. Discussion to the underlying amended proposal. Yes, a gentleman from Texas is recognized.
Move to call the question.
Motion is to call the question for Proposal 1. Do I hear a second? Second from Indiana to call the question on Proposal 1 for the Federal Legislative Committee as amended. All in favor, please say aye. Aye. Opposed, say nay. I will now place the motion. Mr. Secretary, will you place a roll call vote? The motion is to adopt Proposal 1 of the Federal Legislative Executive Jurisdiction Committee. Oh, excuse me. I promised I would come back to you. Vice Chair Caldwell.
Thank you, Mr. President. We were determined here that I was likely to snatch victory or defeat from the jaws of victory were I to speak any longer. So I recommend adoption. Thank you.
Thank you. Thank you, Commissioner. The car wash rule is clearly in effect. Thank you. Mr. Secretary, will you place the motion?
Alabama. Alabama votes yes. Alaska. Alaska votes yes. Arizona.
Aye.
Arizona votes yes. Arkansas. Arkansas votes yes. California.
California votes yes.
California votes yes. Colorado.
Aye.
Colorado votes yes. Connecticut.
Connecticut votes yes.
Connecticut votes yes. Delaware.
Delaware votes yes.
Delaware votes yes. Florida.
Yes.
Florida votes yes. Georgia.
Georgia votes aye.
Georgia votes yes. Hawaii.
Hawaii votes aye.
Hawaii votes yes. Idaho.
Yes.
Idaho votes yes. Illinois.
Illinois votes yes.
Illinois votes yes. Indiana. Indiana votes yes. Iowa.
Iowa votes yes.
Iowa votes yes. Kansas.
Kansas enthusiastically votes yes.
Kansas enthusiastically votes yes. Kentucky. Kentucky votes yes. Louisiana. Louisiana votes no. Maine.
Maine votes yes.
Maine votes yes. Maryland.
Maryland votes yes.
Maryland votes yes. Massachusetts.
Massachusetts votes yes.
Massachusetts votes yes. Michigan.
Michigan votes yes.
Michigan votes yes. Minnesota.
Yes.
Minnesota votes yes. Mississippi.
Mississippi votes no.
Mississippi votes no. Missouri.
Missouri votes yes.
Missouri votes yes. Montana. Montana votes no. Nebraska.
Cornhuskers vote yes.
Nebraska votes yes. Nevada. Nevada votes yes. New Hampshire.
New Hampshire votes yes.
New Hampshire votes yes. New Jersey.
New Jersey votes yes.
New Jersey votes yes. New Mexico.
New Mexico votes yes.
New Mexico votes yes. New York.
New York votes no.
New York votes no. North Carolina.
North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio.
Ohio votes yes.
Ohio votes yes. Oklahoma. Oklahoma votes yes. Oregon. Oregon votes yes. Pennsylvania.
Yes.
Pennsylvania votes yes. Rhode Island.
Yes.
Rhode Island votes yes. South Carolina. South Carolina votes yes. South Dakota.
Aye.
South Dakota votes yes. Tennessee. Tennessee votes yes. Texas. Texas votes yes. Utah. Utah votes yes. Vermont.
Vermont vote yes.
Vermont votes yes. Virginia. Virginia votes no. Washington. Washington votes yes. West Virginia. West Virginia votes yes. Wisconsin. Wisconsin votes yes. Wyoming. Wyoming votes no.
Interesting.
The vote is 45 yeas to 5 noes.
Chair will rule that Proposal 1 from the Federal Legislative Executive Jurisdiction Committee passes. Commissioners, with that, I will inform you we are halfway between our work and lunch. And so just so you know, engaging the time, I think we're moving well. If we keep that pace going, we have 6 other proposals. We may need to look at our pace a little bit to get here. I know Texas last night requested that we finish by 9:45. That may have been a little ambitious, but it is Texas. But we will do our best. Thank you. So with that, we will move to proposal number 1 from the Term Limits and Federal Jurisdiction Committee. We will recognize the chair of that committee, Commissioner Wilkins.
Mr. President, I will yield to the patron of the amendment.
Yes, to, sorry, Chairman, where am I going?
I will yield to the patron of the resolution that we are proposing as proposal number 1.
Is that Vice Chairman Hayes? You're recognized to present proposal 1.
Thank you, Mr. President. Proposal 1 says no person shall be elected to more than 6 full terms in the House of Representatives. No person shall be elected to more than 2 full terms in the Senate. And these limits shall include the time served prior to the enactment of this article.
Thank you. Move adoption of the proposal?
Yes, sir. I do move the adoption of this proposal 1 from this committee.
The motion is to adopt proposal 1 from the Term Limits Federal Jurisdiction Committee. Do I hear a second? Second from Georgia. Discussion to the motion. The gentleman from California is recognized.
Thank you, Mr. President. I respectfully rise in opposition to this proposal as a duly elected representative from the great state of California, falling victim to term limits this year. It's an experiment that has proven, unfortunately, gone awry. What we've experienced in California, and not for myself that I care that I'm termed out, because I'm happy to go back to the private sector, but we're losing many good people who have served honorably and honestly, that we will lose that institutional memory as they are termed out of office. What we've experienced in California since 1990, when we passed our term limits, is the power that should be bestowed upon the duly elected members of the Assembly and the Senate has swung to the unelected lobbyists and the unelected staff members, and maybe worse, the unelected bureaucrats that run the state. A function of the term limits that we've experienced in California is that as members are looking to be termed out, they immediately begin looking for their next opportunity and begin to pay less attention to the responsibilities that they have in their duly elected office. As a result of that, they cede much of their influence to either their staff or the special interests that lobby them on a regular basis. There's other problems with term limits that I could take much more time to share with you about, but those are the ones that rise to the top of concern.
Thank you, Commissioner. In Utah, we are welcoming the good representatives and businesses from California on a daily basis. I recognize the gentleman from New Hampshire.
I was one of the few people in committee that voted against this, but as I overnight and then listening to some other people, I agree with this because the limit shall include time served prior. At first I looked at anybody who served more than 12 years would have to leave. But the problem, when I was anybody who's elected, if for example I got elected to my third term before this was enacted, I still get to complete my third term. One of the things I keep hearing over and over again, not to criticize a gentleman from California, we did in the committee, says, well, the power is ceded to bureaucrats, the power is ceded to this. But if you listen to Senator Coburn and you listen to Patrick Henry, it's not our responsibility to cede power to anybody. The people elected us, the people empowered us to do our job. In 12 years, you can't do your job because you have to cede power. You should have never been elected in the first place. So I agree with term limits, and the other part is everybody who's running for election on the federal is ceding their power. In the state of New Hampshire, 2 people are running for federal senator. Yeah, they're going to spend over $100 million. Who are they going to owe their power to? Are they going to owe their power to the people or the power of that $100 million? That's why I wholeheartedly support this amendment.
Thank you, Commissioner. Recognize the Commissioner from Oregon.
Thank you, Mr. President. I rise in support of this amendment to, after eloquently hearing Patrick Henry this morning, we need to return to the citizen style of government, and I respect all the honorable service of our servicemen, but I believe we lose sight of what the original intent of the founders was. When you have a job to do, once your job is finished, you should return, and you can share that knowledge with the next generation. But to continue the service, I think, is a disservice to the citizens of our nation.
Thank you, Commissioner. I will remind you, you can lift your mics up. We need, with the recording and the streaming, to capture the audio, and if you're able, I think the mics do lift as well. Let me recognize a gentleman from Minnesota. No light, nobody home. There we go. Now we've got the light.
Thank you, Mr. President. A couple points. We had a long, robust, thorough discussion of this proposal in the committee, commissioners, and the gentleman from New Hampshire just spoke, and I appreciate his comments regarding the proposal. On one point that was mentioned earlier, where the experience with the states, again, that came up in our committee as well. The states are completely different from the federal power base. There's a very big difference. In Minnesota, most of us, we don't have term limits, but most of our people are under 20 years. And that's because we get paid so little, primarily. But, which is good. So I appreciate New Hampshire's comments, the Commissioner from New Hampshire and others, but this is very different power structures from the states. And the initial intent, as the other gentleman mentioned, is that up until the early 20th century, we didn't need term limits because they didn't serve that long, and it wasn't a problem. When we started paying these guys and gals more, 16th and 17th Amendment had a huge impact. So I support the proposal and thank the work of the committee. Thank you.
Thank you, Commissioner. I'm going to go to Connecticut, Maryland, then Virginia.
Thank you, Mr. President. A few of the previous speakers mentioned the people, and this is the source of my opposition to this proposal, and that is that it negates the will of the people in elections. There are already term limits. It is called Election Day, and each elected representative on a state or federal level has to win that election to continue their service. I think the desire for term limits stems from the concern that some people have been in office for a very, very long time that we disagree with. The fact that we disagree with them is not necessarily the reason for their required removal. I think that certainly some people do agree with them, otherwise they would not be getting reelected. The answer to this problem is simply to work hard to change the hearts and minds of the people in those districts to replace those folks, not to create an artificial solution in the form of term limits. And I'll be voting no, Mr. President. Thank you.
Thank you, Commissioner. Commissioner from Maryland.
Thank you, Mr. President. I rise in opposition to this amendment. I support term limits, but I think that this is an issue that divides us. This would jeopardize the ratification of the overall effort, and this is something we could do on our next effort. Once we get the fiscal restraints passed, we could then take up term limits. For that reason, I would oppose this. Thank you.
Thank you, Commissioner. Commissioner from Virginia, and then I'll go from Virginia, New York, Washington. Commissioner from Virginia is recognized.
Thank you, Mr. President. The Virginia delegation is sympathetic to the objective of this amendment, but I also understand some of the objections about the unintended consequence of ceding authority to unelected staff, unelected lobbyists, unelected people in the executive branch. And so I'm wondering if a better balance might be achieved if we amended this resolution in the first line from 6 to 9, and in the third line from 2 to 3. That would mean 18 years for members of the House and members of the Senate, and I so move that amendment.
The motion is to amend Proposal 1 on line 1 from 6 full terms to 9 full terms, and from 2 full terms to 3 full terms in the Senate. Is that correct?
That's correct. Thank you.
Motion is to amend as stated. Do I hear a second to the motion? Motion is seconded from the Commissioner from Arkansas. Discussion to the motion to amend. If you are standing to speak, it is to the motion to amend. Let me go to North Carolina, then Oklahoma, then Texas. North Carolina, this is to the motion to amend.
Thank you, Mr. President. I would be against this motion to amend. I don't want to go back and explain to people that we passed term limits for Congress and now you can only serve for 36 years. I think if we're going to do it, it should be something meaningful, and I hope that we will defeat this amendment.
Thank you, Commissioner. Commissioner from Oklahoma.
Thank you, Mr. President. Yes, I make that same point, 36 years. I've been in 4 years. If you want to live in the capital in your state or in Washington, D.C. for 36 years, you're probably not the person we want there. So I think a limited amount of time. I think the original proposal is a well thought out time allowed for people to be there. I think that's well long enough. If you want to live longer than there, maybe find a different country to live in.
I'm reminded that we're exceeding our bandwidth. If you're not speaking, if you would please have your mic turned off. That's probably good practice in any event, but if you're not speaking, have your mics turned off. I'm going to go to Texas, then Oregon, then Tennessee.
Don't you use my stats either?
I got them.
Commissioner from Texas.
I rise in opposition to the amendment. The term limits amendment isn't designed to deprive people of their democratic right to vote for or against the candidate of their choice. Congress itself has protected incumbents through finance legislation and through restricting the political activities of the people. As a result, we have a congressman who's walked on the House floor before man walked on the moon. So we can make it 9 full terms in the House. We could make it 26 full terms in the House so the gentleman from Michigan can run one more time. But it isn't going to be effective. What people want to see is an amendment that prevents Congress from protecting itself. Now, term limits on a state level where we're closer to the people you might have an argument that the people truly have a choice of their local representatives, because they can walk house to house, speak to the people they represent, and the people know their representatives. But on a congressional level, the districts are too big and there's too much money. That's why term limits are so popular. And we can't have a convention like this with a group of elected officials defeating a term limits amendment to protect themselves. So I rise in opposition to the amendment and in favor of the question.
Thank you, Commissioner. Let me go to the Commissioner from Oregon, and then we'll go to Tennessee.
Thank you, Mr. Chairman. Members, I rise in opposition as well to this amendment. I caution the body as a whole. In committee, this topic took 4 hours to come up with these numbers. And to my fellow committee members, I apologize for my redundancy because I asked this question 2 times, and I'll ask it again. Whether it's 9 full terms, as the proposed amendment, or it's 6 full terms, what is the problem you're trying to get at? And does a term limit of any nature, of any time frame, reduce the power and the reach of the federal government? That is the question that you have to ask. If it does not, as the arguments that are made by those that are restricted with term limits in their states, that the power goes to the bureaucracy. Fair argument. By throwing out people that have experience, that are good people, that are representing their people, is that a good thing? You have to answer that question in supporting this or opposing this. Statistically, a member of Congress serves on average 9 years, currently. A member of the U.S. Senate serves 13 on average. Now, I don't understand that average. I get that. But that is the average. The career politician that we speak of isn't there anymore. Ask the good senator from Oklahoma. Ask the good senator from Kentucky. Ask the good senator from Florida. They don't want to be there. So are we putting symbolism over substance? The question is not, in my opinion, humble opinion, a number. It's what does it achieve? And does this proposal, or any proposal, shrink the reach of the federal government? And if it does not, it's probably not even germane to this convention. Thank you, Mr. Chairman.
Thank you, Commissioner. Let me go to Tennessee. Tennessee would call the question on the motion to amend. Is that, Tennessee, is that?
Mr. President, I move previous question.
Okay, so the motion is to call question on the motion to amend. Chairs of your delegation to the motion to amend, please say, to call the question on the motion to amend, please say aye. Aye. Opposed to calling the question, please say nay. I'm going to rule that that passes. I'm going to place the vote on the motion to amend. To be clear, this is a vote whether or not to amend from 6 to 9 full terms in the House, from 2 to 3 full terms in the Senate. All in favor of the motion to amend, chairs of your delegations, please say aye. Aye. Opposed, please say nay.
Nay.
I'm going to rule that that fails. That motion fails. Let's go back to the underlying motion. Gentleman from West Virginia, do you want to speak to the underlying motion?
Yes, Mr. President, thank you.
Commissioner from West Virginia is recognized.
Robert Carnes, West Virginia. I guess I haven't done that before. But I rise in opposition
Commissioner, could you raise your microphone, please?
I rise in opposition to the underlying proposal for a variety of reasons. Some we've already heard from other members around the body, but I would just submit to you that Oklahoma has term limits, as I understand it, and Oklahoma is still Oklahoma. California has term limits, and you know what? It didn't fix California, not one little bit. In all due deference to the commissioner from California.
What this does, especially in the particular way that it's written, and I think we all know it because we're all legislators, this empowers the bureaucracy, it empowers the lobbyists, because we don't term limit the bureaucracy, we don't term limit lobbyists. They get to stay there, they get to understand the game, they get to run the game, and what this is going to do is allow them to have even more power to do that, because they know that whenever they have someone who is pushing for something that the people of a particular state or the nation in this case want, all they have to do is outlast them. And I think I've heard from people who are from term-limited states that that's exactly what they've been told by lobbyists, and exactly what they've been told by members of the bureaucracy is that, guess what, in a couple of years you won't be here, but I'll still be here. This is going to empower those folks. Now, I am a term limits guy, but the problem with this is the absolute nature of it. And so first, it needs to, if we're going to actually do a term limit, it should be a window, a time where you have to sit out for a period, because the real question that we have with these long-serving members of Congress is that they have the power of incumbency. And the power of incumbency means a 90+% reelection rate whenever they run for reelection. If they were simply forced to sit out for even a term or two, it would break up that power of incumbency while still allowing the best of the best to come back and bring their institutional experience back to the table, which I think is something that's very important. So I can't support this particular term limits resolution because it doesn't contain that important ability to retain that institutional knowledge. Instead, it just throws them all out at the same time and empowers the bureaucracy, empowers the lobbyists, and disempowers the people's representatives in Congress. Thank you.
Commissioner. Recognize the Commissioner from Florida.
Thank you, Mr. President, and I will tell you freely, this is, I believe, the most important amendment we could consider here in this process. I think it is the most likely amendment that a actual convention will ever be able to adopt, and I will outline both my reasons of proponents for the proposal and why it would be the one most likely to be adopted. I always find it humorous that people say lobbyists are empowered by term limits. They seem to be the group that most often complains about term limits because they lose the influence that they have bought and accrued over the years with members who are now leaving. They are consistently the ones who complain the most. With the bureaucracy, that is to your Speaker and your President. We have a tradition of term limits now in Florida going back more than 20 years, and I can name by individual the members of the staff that have been dismissed as we prepare to enter this next session because they were acting inappropriately over the last 2 years. That is on your leadership to dismiss the people who are acting inappropriately and beyond their commission. We worry about balance of powers. Although this is, I think, rarely mentioned, the President has a term limit. George Washington set a great example by retiring after 2 terms, but that branch is at a distinct disadvantage to the other 2 branches. I think a part of the problem with the way in which Congress behaves today is that they not only ignore us, but they ignore a president in their final term, knowing full well that there is no threat the president can bring, particularly in those last 2 years. Congress, particularly the House, has grown out of proportion. Now, I don't know of a great solution yet to this question, but you'll recall that when the convention came together that proposed what ultimately became the Bill of Rights, actually sent out 12 amendments. The 11th of those we adopted about 25 years ago, which limits the way in which the Congress can compensate itself. The 12th was to set the size of districts to an appropriate level so that representation was actually real. I don't think any of us would submit that representation of 600,000 plus people by a member of the House is in any way constructive. I also don't know how we solve the problem that making it constructive would mean a House of maybe 2,000 members. When you look at the proposals we're considering today and the ones been discussed in the committee, demonstrably term limits have the support of the people. Somewhere in the nature of 80% nationwide if you average the support, and it's been adopted in many of the states. I think as we think about the amendments that we should put forward for an actual convention to be ratified, we should take the example of those reforms which have been adopted within our states and have been done so effectively. Lastly, Mr. Brockaway from Georgia has encouraged me to share a story that I added to our discussion in our subcommittee yesterday. It's the difference between dogs and cats. That's one I heard when I first got elected. A dog wakes up each day and looks at the owner, watches the owner pour its food, shower love upon it, and the dog thinks to himself, "My owner must be a god with all the power that he exercises." The cat wakes in the morning, looks at the owner filling the food bowl, showering love upon him, and thinks to himself, "I must be a god for how this owner treats me." And the important fact is to remember that many of us enter the legislative process as dogs, and we must be sure not to leave as cats. Thank you, Mr. President.
Thank you, Commissioner. I'm going to recognize the Commissioner from Washington, and then we'll go to Rhode Island, then Alabama.
Thank you, Mr. President. Skylar Rude from Washington State. I would just like to talk a little bit about our state. The first legislative power protected in our state constitution is the power of the initiative, an example of direct democracy, which we value in our state. I'm opposing this amendment. I believe this would, to echo the words of the gentleman from Connecticut, take away choice from the voters, which I think would be very inappropriate. To question the judgment on a national scale, to question the judgment of the constituents of a specific congressional district or state. The only reason this is being proposed is to negate the will of the voters. So I'm a no.
Thank you, Commissioner. As you notice, we have a number of people that want to speak to this. If you can keep your comments concise as possible. Going to come to Alabama, and then Rhode Island, then Alabama, and then we'll go to Louisiana.
Thank you, Mr. President. To preclude the possibility of gubernatorial appointments, I would like to amend this to no person shall serve more than 6 full terms,
So we just wanted to break in here briefly for a moment as this debate on term limits is going on. I think this is one of the most contentious and interesting debates of the convention. We saw this in the committee hearing, but I also wanted to point out over to my left over here, there is an off-floor caucus taking place, and these are actually taking place with relative regularity around the room. So looking to my left, what we have is we have Senator Coburn over here, and he's caucusing with the Oklahoma delegation. There's also a delegate from Michigan over there. And what they are discussing is term limits, something Senator Coburn is deeply interested in. He's an expert on the subject. And so what I just wanted you folks to see is that's going on all over the room at different points here during the convention. You have various members, various delegations get up and caucus together, not just within their states, but across state lines. So that's the kind of wisdom that's being exchanged here. It really adds to the floor debate. I just want you to know that that is pretty much going on constantly. So we're going to take that back to the front of the room now.
Amend.
Mr. President, we spent a good deal of time in committee discussing that. The concern with SERVE, which was the original proposal, was that it would not handle the instance of members of Congress that are appointed midterm to fill a vacancy. You could have a senator, for example, serve 2 years of the prior term and then effectively be allowed only 1 term to be elected. We did not want to truncate it that much, and the change from serve to elected accomplished that purpose.
Thank you. From the discussion of the committee. Commissioner from Arizona, then we'll go to Missouri. This is to the motion to amend. To the motion to amend, the Commissioner from Missouri.
Mr. President, I was seeking recognition to speak earlier on the underlying motion. I wish not to speak on the amendment.
I'll come back to you then. Again, to the motion to amend. Anyone else that wishes to speak to the motion to amend? Commissioner from Wyoming.
Call the question.
We'll call the question on the motion to amend from elected to serve. Do I have a second from Georgia? We place the motion to call the question. Chairs of your delegations in favor of calling the question, please say aye. Aye. Opposed, say nay. I'm going to rule that sleepily passes. Place the motion. In favor, this is in favor of amending. Chairs of your delegations, please say aye. Opposed to the motion to amend, please say nay. Nay. I'm going to rule that that fails. We are back to the underlying motion now. We'll come back to the gentleman from Alabama, then Louisiana, then Missouri.
Thank you, Mr. President. We are here to limit government. We are not here to limit the people. And the people of the great state of Alabama have seen fit to send two terrific United States senators to Washington, one elected in 1986 and one elected in 1996. And by doing this, by enacting term limits, we're not going to limit government. We're going to limit the will of the people of my state and yours to send our members to Congress for as long as we seem fit. And I would like to warn the smallest states that seniority has always been to the benefit of our states. Please keep those things in mind before we vote on this. Thank you, Mr. President.
Thank you, Commissioner. We'll go to Louisiana and then Arizona. Then I'm going to come over to Colorado.
Mr. Chair.
Oh, I'm sorry. I'll come back to you after that from Missouri. I had you on the list. Yes, Louisiana, Arizona, Missouri. Then we'll come over.
Mr. Chair, I'd call the question.
Motion is to call the question on the underlying proposal. Do I hear a second? Second to call the question. In favor of calling the question on this proposal, chairs of your delegations, please say aye. Aye. Opposed, say nay. Nay. I'm going to rule that passes. The question has been called on the underlying motion to adopt Proposal 1. Let me go, Mr. Secretary. Let me place the motion. We did that already. We're now on the underlying motion. Mr. Secretary, roll call vote.
If the delegation...
Oh, I'm sorry. Excuse me. To the Vice Chair Hayes from the committee, summation on the motion.
Thank you, Mr. President. And members, you've heard the discussion. We could beat this horse to death for the next 3 hours. And I think that would be cruel and unusual. So we should not do that. Brevity is rewarded. Thank you for being here.
Shall I call the roll?
Yes, Mr. Secretary, please call the vote.
Alabama.
Alabama votes no.
Alabama votes no. Alaska.
Alaska votes no.
Alaska votes no. Arizona.
Arizona votes no.
Arizona votes no. Arkansas. Arkansas votes yes. California.
No.
California votes no. Colorado.
Aye.
I'm sorry?
Yes.
Colorado votes yes. Connecticut.
Connecticut votes no.
Connecticut votes no. Delaware.
Delaware votes yes.
Delaware votes yes. Florida.
Yes.
Florida votes yes. Georgia.
Georgia votes aye.
Georgia votes yes. Hawaii.
Abstain.
Hawaii abstains. Idaho.
Yes.
Idaho votes yes. Illinois.
Yes.
Illinois votes yes. Indiana. Indiana votes yes. Iowa.
Iowa abstains.
Iowa abstains. Kansas.
Kansas votes yes.
Kansas votes yes. Kentucky. Kentucky votes no. Louisiana. Louisiana votes yes. Maine.
Maine votes no.
Maine votes no. Maryland.
Maryland votes no.
Maryland votes no. Massachusetts.
Massachusetts votes yes.
Massachusetts votes yes. Michigan.
Michigan votes yes.
Michigan votes yes. Minnesota.
Yes.
Minnesota votes yes. Mississippi.
Mississippi votes yes.
Mississippi votes yes. Missouri.
Missouri votes yes.
Missouri votes yes. Montana.
Yes.
Montana votes yes. Nebraska.
Nebraska votes yes.
Nebraska votes yes. Nevada.
Nevada votes yes.
Nevada votes yes. New Hampshire.
New Hampshire votes no.
New Hampshire votes no. New Jersey. New Jersey votes yes. New Mexico.
New Mexico votes yes.
New Mexico votes yes. New York.
New York votes yes.
New York votes yes. North Carolina.
North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio.
Votes no.
Ohio votes no. Oklahoma.
Oklahoma votes yes.
Oklahoma votes yes. Oregon.
Oregon's delegation is divided. We abstain.
Oregon abstains. Pennsylvania.
Yes.
Pennsylvania votes yes. Rhode Island.
Yes.
Rhode Island votes yes. South Carolina.
South Carolina votes yes. South Dakota.
South Dakota votes yes.
South Dakota votes yes. Tennessee. Tennessee votes yes. Texas. Texas votes yes. Utah. Utah votes yes. Vermont.
Vermont's been advised by their delegation to vote enthusiastically yes.
Vermont enthusiastically votes yes. Virginia. Virginia votes yes. Washington. Washington votes no. West Virginia. West Virginia votes no. Wisconsin. Wisconsin votes yes. Wyoming. Wyoming votes yes. Mr. President, there are 35 yes, 12 no, and 3 abstentions.
We'll rule that proposal number 1 from the Term Limits Committee passes. With that in the order that we've laid out, we're going to go to Proposal 2 from the Term Limits Committee and then work our way backwards. So we are now back to the Term Limits Committee, to the Chair, Chair Wilkins.
Mr. President, I yield to the patrons of the resolution.
Maker of this resolution is the Commissioner from Oklahoma. Commissioner from Oklahoma is recognized.
Thank you, Mr. President. The concern about the expanding power of the United States Supreme Court through an unchallenged authority it has claimed for itself is well documented, so I won't elaborate on that and instead move directly to the proposal before you, which provides a check on the United States Supreme Court. It's pretty straightforward. You have the words in front of you. Any decision by the Supreme Court may be vacated by a resolution passed by the legislatures of 3/5 of the several states or by 2/3 of both houses of Congress. No state legislative resolution older than 5 years will be counted to aggregate the necessary number, which simply means if your resolution is older than 5 years, you need to revisit that to make it count. Section 2, a decision that is vacated within 6 months of the date of the entry of the judgment shall result in a vacation of the judgment itself. If it's longer than that and is vacated, it won't disturb the judgment as between the named parties, but it won't have the effect of becoming law, if you want to look at it that way. The congressional override is not subject to a presidential veto and not subject to litigation or review or any federal or state court. The state's override shall not be the subject of litigation or review in any federal or state court or oversight or interference by Congress or the President. Let me say that those last 2 sections got some discussion, and there is an opinion they may not be necessary to this amendment. We left them in, the thought being when people vote on this, we need clarity. As you know, very smart people produced by our law schools often find ways to read intent that isn't there. That said, I will move on to invite any of the committee members to help me clarify anything I may have misstated or omitted. I also understand there may be an amendment. Either way, I yield to questions.
Okay, the motion then is to move Proposal 2 of the Term Limits Committee. Do I have a second?
Second, Michigan.
Second to the motion from Michigan. Discussion to the motion. I recognize the gentleman from Oregon.
Thank you, Mr. Chairman. I've got an amendment at the desk I'd like to offer.
That's in order. We have a motion to amend. Is that text available to us, Mr. Secretary?
Which amendment is this?
So the motion reads, deleting the phrase, or by 2/3 of both houses of Congress, so that Section 1, if amended, would read, any decision of the Supreme Court may be vacated by a resolution passed by the legislatures of 3/5 of the several states. No legislative resolution older than 5 years shall be counted to aggregate the necessary number. Is that the motion?
Yes, Mr. Chair.
Do I hear a second to the motion? Second from Indiana. Discussion to the motion to amend. Recognize the Commissioner from California.
I would just like to suggest to the gentleman making the amendment that if we're going to do that, we should eliminate Section 3 and renumber Section 4 to Section 3.
Would that, would you want to make a substitute motion to amend?
Yes.
The substitute motion to amend is to then eliminate Section 3 as well and renumber Section 4 as Section 3. Is that correct? Do I have a second to the substitute motion to amend?
Second.
Second from?
Oregon.
Oregon. So we have before us now, and let me come back to you in your comments on the substitute motion to amend to the maker.
I'm fine with the substitute amendment, but reserve my right to speak to the amendment.
Friendly substitute amendment. Second, I'm sorry, the second was from? Oregon, the second on that. Discussion is now to the substitute motion to amend. Let me go to Wyoming.
Mr. Chairman, I believe I get to speak to my amendment. Then you can discuss my amendment.
I'm sorry, please.
Thank you. This was debated in our committee, and the rationale, and we were divided as a committee, the rationale behind striking the 2/3 of both houses of Congress was that, again, why would you let the fox guard the hen house? If you truly want to reserve the power back to the states and have a say in a judicial decision, why would you let the Congress also have that same say? If the Congress passes a law, the Supreme Court overturns that law, the Congress then gets to come back and say, we just disagree. So that was the logic and the rationale for removing Congress and reserving that right back to the states. So with that, Your Honor, or Your Honor, you've been in court too much. Those lawyers. Thank you, Mr. Chairman.
No black robes here yet, thankfully. The discussion is to the substitute friendly motion to amend. Let me go to Wyoming, then Oklahoma.
Thank you, Mr. President. On and against this amendment and for the proposal, really what this amounts to is checks and balances. And right now, we have antiquated checks and balances for the Supreme Court. There is no checks and balances as it is for the Supreme Court because of the antiquated checks and balances that exist right now. So what we wanted to enable to do is to have those checks and balances not only at the federal level, where you have Congress who would be able to check the power of the Supreme Court, but then also give another option, which was the states then to check the balance of power for the Supreme Court as well. So if you eliminate this 2/3 of both houses of Congress, you effectively eliminate any kind of checks and balances that would exist within the federal branch, reserving that only to the state. And so therefore, I would urge this body to reject this amendment. Thank you, Mr. President.
Thank you, Commissioner. Commissioner from Oklahoma, my apologies. I should have come back to you on the motion to amend.
No problem, Mr. President. Thank you. The reason I liked leaving the language as was, including the 2/3 of Congress, simply is to the previous speaker's point, including them in the checks and balances, but more practically, state legislatures do not meet year-round like Congress does. Some of them only meet every other year. Some of them have very specific limits about how special sessions can be called. And so, in my mind, the thinking here is that if something comes out of the Supreme Court that needs very rapid action, Congress being present has the ability to act on that while the states get organized. Does anybody really think 3/5 of the states are going to vote on something in 6 months? So Congress being there can do that. It allows it, but we placed a higher bar on Congress to make sure that it had such a heavy majority and provided the balance that our founders anticipated to the Supreme Court. So I favor leaving the language in there, but I wanted to explain to everybody why it was there. Thank you very much.
Thank you, Commissioner. Let me go to the Commissioner from Alabama.
Mr. Chairman, I rise in opposition to the amendment. When the gentleman explained the reason for the amendment, that it would, he seemed to indicate that this would take away from the state's ability to provide a check and balance to the Supreme Court. And I see nothing in the original language that takes away from the rights of the states. This just adds another layer of checks and balances on a runaway judiciary, and I would oppose the amendment and urge this body to reject the amendment, and let's have two sets of checks and balances on the court.
Thank you, Commissioner. Let me recognize the Commissioner from Texas, then we'll go to Colorado, Indiana.
Mr. President, I rise in support of the amendment. I want to point out that we just passed probably one of the most important amendments that this convention can pass, which is limiting the commerce power of Congress. Well, by not adopting the amendment here, by a 2/3 vote of Congress, Congress can override that. Congress can actually increase its commerce power by a 2/3 vote when a court strikes down any act of Congress that doesn't comply with that provision. We're here today to limit the power of the federal government. We're not here today to expand it or to add new checks and balances for other branches of the federal government. And we're here to increase the power of the states. Congress has tools in its toolbox already in order to check the power of the courts. It can abolish federal courts. It can create new federal courts. It can increase the size of the Supreme Court. 9 is no magic number. So when we add a provision like this that empowers a congressional veto over rulings of the Supreme Court that actually check its own power, we're granting Congress a very, very big power. This amendment needs to be passed for the sake of empowering the states and limiting the power of the federal government. And as far as checks and balances go, I mentioned there are checks and balances on the Supreme Court. And I defer to the founding fathers that those are adequate, sufficient checks and balances for the federal government branch on another federal government branch. So I support the amendment, Mr. President.
Thank you, Commissioner. Commissioner from Colorado is recognized.
Thank you, Mr. President. As compelling as some of the arguments have been made for this amendment, I rise in opposition to the amendment and wish to point out some practical considerations that we should bear in mind, and that is that the Supreme Court, by tradition, ends their session in June, and most of the more difficult decisions will indeed come at that point in time, at which many of the states are not in session. And so it's an absolute certainty in my mind that if something comes through the court that does need this extraordinary action, that the states will not be available for a significant amount of time. And far too often the decisions made have ramifications that make it an established fact if immediate action cannot be taken. I'll not name any specific case, but I will tell you that in June of 2015, there were some issues that needed some attention that this overall amendment could have remedied. And therefore, I believe Congress should be empowered to take this action as well as the states. I'm voting no on the amendment to the proposal.
Thank you, Commissioner. We'll go to the Commissioner from Indiana.
Thank you, Mr. Chairman. I rise in support of the amendment. One of the prior speakers mentioned rapid action in Congress in the same sentence. I've never heard that before. I would only advise that I think that if an issue rose to this level of attention, that virtually all of us have the option to go into special session if it were necessary. Obviously, we're discussing hypotheticals here, but I would say that this entire body has been organized to discuss reasserting states' rights over the federal government. And insofar as we have that common thread, I absolutely believe that enshrining a role for the states in this process is integral to reform efforts. I am much less confident that adjusting the balance of power between the three branches of the federal system is something that we ought to entertain at this point. I think doing this as a state initiative is the way to go, and I will be supporting the amendment. Thank you.
Thank you, Commissioner. We go to Florida, South Dakota.
Thank you, Mr. President. And this, I'll speak to this amendment, but more broadly, the proposal, which is also related to the abrogation proposal that came out of our committee regarding executive and congressional action. I think we need to be very thoughtful about what we're really advocating by setting to the states the ability to overturn decisions or actions of the three branches of government. I think it introduces some of the basic infirmities that the Articles of Confederation had and the reason why the Constitution was created in the first place. These problems were designed to be addressed by a Senate that was appointed by the states. The infirmity we struggle with today is the 17th Amendment. And we can talk about the realities or the proposals we could bring forward to amend that infirmity, but this undercuts the very purpose of the Senate. The Senate at that point becomes a rump institution whose job is simply to ratify treaties and appointments. The states now taking over almost all of their purpose. The other thing I would note is we were admonished yesterday morning to be very careful about what we send out of this process, that it be proposals that have a realistic chance of 38 states adopting. I mentioned earlier that we should take our lead from reforms that have been adopted at the states, those which have broad and wide support, such as term limits. I don't know of a single state in which the political subdivisions of our states have such a radical authority over our legislatures. And while I certainly understand and recognize that the relationship is much different, the states create both our political subdivisions and the federal government, the average person and the average legislator is not going to recognize that distinction. And this, I believe, could be easily thwarted from adoption through simple misunderstanding on that key point. For those reasons, I would oppose both the proposed amendment and the underlying resolution. Thank you, Mr. President.
Thank you, Commissioner. Commissioner from South Carolina, then Connecticut.
South Dakota.
Of South Dakota, excuse me.
I'd rather have South Carolina. Thank you, Mr. President. I rise in favor of this amendment and also in passage of the resolution. Originally, I thought this would be a good way to check the federal courts.
Excuse me, can you hold your mic closer?
Absolutely. Originally, I thought this would be a good way for multiple checks on the federal courts, but then I realized that in South Dakota, in our body, there are times when we decide to suspend the rules by a 2/3 vote. And many times, I think that it is completely inappropriate that we vote to suspend the rules. There's nothing I can do about it in a minority case. But in this case, if we allow Congress to have the veto over the court decision in this point, we would essentially be allowing them to suspend the rules, except for those rules would be the Constitution. And I think that that's too dangerous of a power to give. They already have, as mentioned previously, other ways to check the courts, and I think they should use those. So I encourage you to pass the amendment and pass the resolution.
Thank you, Commissioner. Commissioner from Connecticut is recognized.
Thank you, Mr. Chairman. I rise in support of this amendment. I heard the word antiquated used in reference to the checks and balances as provided in the Constitution. I think at a convention of this sort, there's no word which is more terrifying to me. I think that one of the reasons we're here is because we have great faith in the wisdom and vision of the founders of the country and the balance that they provided, which, if it has not worked perfectly, has worked with remarkable effectiveness over more than 2 centuries. Some of the other checks which the legislative and executive branch have on the judicial branch have been mentioned, but I think the fundamental one has not, that the judicial branch is the child of the other 2 branches, that while the President and the Congress are elected by the people, the Supreme Court is selected by the President and approved by the Senate. There could be no more potent check. Now, like a child, the child may not grow up exactly the way we want them to be, but they are in fact our child, and we have that responsibility for them. What I would say too is this two-thirds of both houses of Congress then throws the balance off in the sense that it gives one of the other two branches a check on the Supreme Court, but not the executive branch. Now, I would not suggest that the president be given a veto power over Supreme Court decisions either, but if that makes you hesitate, I think giving it to Congress should as well. And I would finally say, historically, we, given where we're coming from generally as a group, may look at the decisions of the Supreme Court over the last nearly a century as having been bad for the country. But if we go back to the early days of the New Deal, there was a time when the Supreme Court was the group that was holding up conservative values and trying to prevent the growth of executive power. And the Congress in those days would easily have been able to override the Supreme Court decisions with the huge majorities that came into the New Deal. I think that removing this makes this amendment closer to the founder's vision, and I will support the amendment.
Thank you, Commissioner. Let me go to the Commissioner from Oregon, and then we will come to Virginia, then Minnesota.
Mr. Chairman, point of parliamentary inquiry.
Yes, state your position. State your point.
The amendment is on the table. It is my amendment. If I were to remove the amendment in substitute for the author of the amendment agreeing to postpone discussion to a time certain for purposes of, I know Mr. Eastman and others have potential amendments that they're proposing to offer on this, whereby we might be able to clean up the language a little bit and get a better consensus and bring it back. Would that be possible?
I believe you can withdraw your amendment at any time before the vote under the rules that we've stated. To withdraw, we've got our supplemental rules. Okay. So I believe under our supplemental rules, you can withdraw the amendment. We would need a separate vote on postponing in time certain. Okay. So I could recognize the gentleman from Oklahoma following you. You can withdraw your amendment on your own accord, and then we can go to the gentleman from Oklahoma if you'd like.
Would the gentleman from Oklahoma yield for a question?
The underlying maker of the motion, would you yield for a question, Commissioner?
Certainly. I'm sorry.
Go ahead.
That is a big man right there. The question that I would have is, as the current language, any decision of the Supreme Court. In a situation where, if this were enacted, when you have something like Bush v. Gore, where the Supreme Court makes a decision, that is, any decision where it would bump up against other constitutional parameters and requirements, I don't see a remedy for something like that.
I think that's a different question than we were starting to talk about, which was probably my willingness to hold this to a date or time certain.
Oh, then I will withdraw that question if you want to address the previous.
And I'll need some help on the rules. What I don't want to do is effectively table this until some other day, since we're limited on time. I would be willing to step out and try to work on some language, especially if there is another amendment that somebody's about to propose. And perhaps after our lunch period, come back with a reworked version. Now, I may reject all of that, but in the spirit of timeliness, I'm willing to do that.
Did that sound okay? So I think in order, Commissioner from Oregon, do you withdraw your amendment?
Yes, I would withdraw my amendment.
So the amendment is withdrawn, and then Commissioner from Oklahoma, are you proposing that we move to have this on a time certain, and I would suggest the item following lunch? We may be able to take up one more item before lunch, and we would take this up immediately after whatever, if we finish before lunch. Would that work?
That would work for me.
Do I have a second to that motion?
Second.
A second from Alaska. Let me place that motion. The motion is to postpone this item taking it up as our first item upon finishing whatever item we may take between now and lunch. Is that perfectly obscure? Okay. We will take this up as the following item after whatever we finish after lunch. Chairs of your committees, all in favor, please say aye. Aye. Any opposed, say nay. Okay, the item is postponed until after our next item. We will now then go to Proposal 2 from the Federal Legislative Executive Jurisdiction Committee. Proposal 2, let me go to Chairman Standridge. Commissioner from Oklahoma is recognized.
Thank you, Mr. President. Next proposal that we have, once again, I'd like to thank the work of our subcommittees. The Abrogation Subcommittee worked very hard on this, and I sat in on the committee and did a lot of great work. I'd like to recognize Chairman Casper, who speak to this proposal, and of course solicit maybe some of the help from the members that helped craft this. Chairman.
Thank you, Chairman, and thank you, Mr. President. We have titled this proposal number 2 in our subcommittee, Abrogation of Federal Law. And I'd like to, before I begin, define abrogation. Abrogation means to nullify or to render unenforceable. And our subcommittee felt that was a better term than some of the other terms that have been used in this area. So to proceed under Section 1, the state shall have the authority to abrogate any provision of federal law issued by the Congress, President, or administrative agencies of the United States, whether in the form of a statute, decree, order, regulation, rule, opinion, decision, or other form. We left out the treaty possibility and the courts. So Section 1 would not apply to treaties or to courts. And some may ask, what does the word opinion mean in keeping the language in? And that was pointed out by Professor Barnett and others, that administrative agencies do issue opinions. So we felt we needed to keep opinion in. Section 2, such abrogation shall be effective when the legislatures of 3/5 of the states approve a resolution declaring the same provision or provisions of federal law to be abrogated. The abrogation authority may be applied to provisions of federal law existing at the time this amendment is ratified. So we can go back to prior law or obviously going forward. We had a discussion in the subcommittee about what percentage vote should we use for abrogation. Some favored just a simple majority at 26. But the majority of our subcommittee and the vast majority of our full committee favored a 3/5 votes of the states, which would be 30 votes. Section 3, no government entity or official, and here is a correction that needs to be made because it was printed wrong. No government entity or official, our subcommittee and full committee struck the words whether federal, state, or local. So when it's appropriate, Mr. President, I would offer an amendment to strike those words if it has not already been done. Professor Barnett pointed out that no government entity means no government entity. And we also were pointed out that in general, the United States Constitution does not apply to local government. So it would read, no government entity or official may take any action to enforce a provision of federal law after it is abrogated according to this amendment. Any action to enforce a provision of abrogated federal law may be enjoined by injunction by a federal or state court of general jurisdiction in the state where the enforcement action occurs, and costs and attorney fees of such injunction shall be awarded against the entity or official attempting to enforce the abrogated provision. We wanted to protect the state right very, very strongly against lawsuits where the people who did not wish to, or who had abrogated, would have their attorney's fees paid for the protection of the opportunity to continue on with that action. Section 4, no provision of federal law abrogated pursuant to this amendment may be reenacted or reissued for 6 years from the date of abrogation. We wanted to protect from the Congress immediately turning around on an abrogated situation and pass a new statute that would be almost identical to what had just been abrogated. So the Section 1 is our authority, Section 2 is the procedure, and Section 3 is the enforcement part of the proposal number 2, Mr. President. And I would move that we would adopt an amendment striking the words whether federal, state, or local from Section 3. And if it needs another motion, so be it. Otherwise, I would then move the adoption of the proposal.
To clarify, you said that was a Scrivener error?
Yes, it was.
Without objection, we'll strike the words. Without objection, we'll strike the words whether federal, state, local. Hearing none, we'll correct that Scrivener error. Please proceed.
Thank you, Mr. President. So with that, Mr. President and members of the convention, I want to thank the subcommittee who worked very, very hard, and I want to especially recognize Representative Merrill Nelson from Utah, who was very instrumental in helping draft this type of language that, as an attorney, was very much, our subcommittee felt very expert in the Constitution in the area that we're discussing. So with that, I would move adoption of proposal number 2.
Motion is to approve adoption of proposal number 2 from the Federal Legislative Executive Jurisdiction Committee. Do I hear a second? Second from Arkansas. Discussion to the motion. The gentleman from Delaware is recognized.
Mr. President, thank you very, very much. Like most of the people in this room, I share great value for limiting the unchecked power of federal government, but we did create a federal government to exercise some powers on our behalf. It was a nullification crisis of 1830 under General Jackson when he was serving as president that helped move this country from these United States are to this United States is. It was the Civil War of 1860 that once again kept us together. If not for that, today we would be 2 or more states. Like many people here, I want to see the power checked, but I don't know that a vote of abrogation of lawful acts of Congress in this case is the best solution. To the sponsor of this, I would say I'm comfortable if there was a way to handle administrative proclamations and rulemaking, and even executive orders of the president, which appear to be unchecked, although Congress can override them, but having a state override in that area is okay. But I do have some heartburn with the idea that we subject every act of Congress to a complete override, as this would appear to do.
Thank you, Commissioner. Commissioner from Arizona is recognized.
I know, I'm pulling this up, sorry. Thank you, Mr. Chair. Will the Representative Merrill Nelson from Utah yield to a question?
I believe that it would be a question to the maker of the motion, and he may yield his time. Would you?
That's fine.
Will the sponsor of the motion yield for question?
Mr. President, I would.
Proceed.
Thank you. And I am not a constitutional attorney, but I do have a question that in Article 6, Paragraph 2 of the Constitution is the Supremacy Clause, where it says that any laws that are in conflict, that the federal laws will be supreme over the state laws. So if we adopt this and this amendment is ratified, will this be in conflict? Will there be a conflict within the Constitution itself with 2 different directions on how to handle state and federal laws when they are in conflict?
Thank you, Commissioner. Sponsor of the question, do you yield time?
Mr. President, I yield time to the question and to Representative Nelson for the answer.
The Commissioner from Utah is recognized.
Thank you very much, Mr. President. This would not create a conflict with the Supremacy Clause. I just want to explain a little bit, lay a background in answer to your question. First of all, the reason we need this amendment is because the federal government has expanded way beyond its federal powers, on which we can argue that it's supreme. But over the past 100 years, with the passage of the 17th Amendment, states have lost the constitutional check on Congress. This amendment attempts to restore that check by giving us some oversight over Congress. And so the purpose of this, the problem we see is that when Congress passes a law and authorizes an administrative agency to issue regulations, such as whether it's grazing permits or coal mining or waters of the U.S. or whatever it might be, those regulations based on the federal statute affect the states. And the states really have no good remedy. And so the question is, who should have the final say? Does this work better? Who should have the final say is the question on these matters of federal law. And the premise of this amendment is that the states should have the final say because the states created the federal government. We're not saying by this proposal that the federal government is evil or wicked. We're not enemies to the federal government. We need a federal government, but we need a federal government confined to its constitutional authority. And over the past 100 years, the federal government, through its agencies, has expanded to encroach on the inherent sovereign rights of the states. And so the purpose of this amendment is to give the states a procedural tool to override statutes and rules. And it does not conflict, getting now to your specific question, it does not conflict with the Supremacy Clause. It rather supersedes the Supremacy Clause because this amendment gives the states then the final say.
Thank you, Commissioner. Commissioner, you have a follow-up question?
In response, I don't think that there is a commissioner in this room who agrees with you more on everything that you said. I just want to make sure and am looking for legal direction that we don't create a conflict within the Constitution. And so I think we should make sure that it either negates and is struck out. Article 6, paragraph 2, I don't know how that works, if we would have to strike that as well out of the Constitution or just leave it. So those are my questions, and I just want to make sure we move correctly in that direction.
Thank you, Commissioner. Further discussion to the motion. I'll recognize the gentleman from California.
Let me address also that question. I fully support this amendment. Ever since the 17th Amendment, the states as governments have had no say in the national chambers in order to protect their sovereign interests. This is a measure to restore that power. I don't think it conflicts with the Supremacy Clause, though, which specifically says the Constitution of the United States and the laws made in support or in furtherance of the Constitution. This would now be one of the constitutional provisions that the laws have to be made in furtherance of. So it would be covered by the existing Supremacy Clause, and this would prevail, this abrogation. I would like to propose one minor clarifying amendment to Section 2. This abrogation authority may also be applied to provisions of federal law existing at the time this amendment is ratified. Without that, I fear a court might say this is limited to only laws that existed at the time the amendment was ratified, and Congress would have a free hand to do whatever it wanted in the future. The addition of that word would solve that problem, I think.
Could you please restate that, Commissioner?
Inserting the word also in the last sentence of Section 2.
So the last sentence of Section 2, this abrogation authority also may also be applied to provisions of federal law existing at the time. I'm going to, as a grammatical addition, I'm going to just place that without objection. If there's objection, we'll certainly have the debate. Without objection, to add the word also. Hearing none, okay, we'll include that grammatical change. If you would add that this abrogation authority may also be applied. Further discussion to the underlying proposal. Yes, the gentleman from South Dakota.
North Dakota, Mr. President.
North Dakota, excuse me.
We are like cats and dogs that we heard about earlier.
We'll let you decide which is which at the end of the day, right?
They've got the tourists and we've got the oil and the coal. Mr. President, I would like to propose a friendly amendment pointed out to myself just a minute ago by Professor Nadelson and Professor Barnett. Beginning in Section 1, it is suggested by our legal scholars that we substitute the states for the following: the legislatures of the states shall.
And I don't know if procedurally it's appropriate for you to amend your own proposal. I would entertain a motion to amend from the gentleman from Utah. The gentleman from Utah is recognized.
Yeah, thank you, Mr. President. I will make that amendment, so it will read the legislatures of the states.
So the amendment for Section 1, the legislatures of the states, so inserting the words the legislatures of shall have authority. Again, without objection, by hearing any objection, I'm happy to have debate. Without objection, would place that correction. Certainly. Okay. Let's have. Do I have a second to the motion to amend? Have a second from New Jersey. Discussion to the motion. Gentleman from Wyoming is recognized.
Thank you, Mr. President. This gives me a little bit of heartburn. We're restricting it just to the legislatures of the states. Perhaps you don't have a state legislature who has the backbone to do it, but you have a governor that does. I don't know how you fix this, but it does give me a little bit of heartburn here. And I wonder if we're just being a little too restrictive. That's just my comment.
Is that a question to the sponsor, or if he's yielding to the gentleman from Utah?
My understanding, Mr. President, this is an amendment that's being made. An amendment to the proposal?
Correct. So we're speaking to a motion to amend. I'm just wondering if that was a question to the maker of the motion to amend.
I don't have, if someone would like to speak to that's fine. I guess that's the heartburn that I have with this. If someone who has some knowledge who could enlighten me, then I would certainly entertain that.
Okay. Thank you. Let me go to the maker of the motion to amend, if the gentleman from Utah would like to speak, and then we'll go to the gentleman from Oklahoma.
Okay.
I'd just like to point out that Section 2 of our amendment refers to the legislatures of the states. And so it is the legislatures of the states that is the procedure by which we're effecting this abrogation. And so it's the legislatures acting for the states. This amendment merely clarifies in Section 1 to make it consistent with what we've stated in Section 2.
Okay, thank you. Further discussion to the motion to amend. Gentleman from Arkansas is recognized.
Thank you, Mr. President. I was a part of this committee that drafted this proposal. I don't think there's any question that the unsustainable growth of our federal government and the unsustainable growth of the national debt is a result of a flagrant disregard for the will of the people. And I think this proposal addresses that in a very fine way. My colleague from Utah, or the commissioner from Utah, made a very pertinent statement yesterday. He said, "We the people created the federal government, which is the creature, and now the creature is devouring the creator." And I think that sums it up very well. So I speak in favor of this proposal.
Thank you. Further discussion to the motion to amend. Let me go to the commissioner from Alabama, then Virginia.
I was speaking on the amendment, or on the underline.
We'll come back to you then. Commissioner from Virginia is recognized.
Mr. President, I move the pending question.
Motion is to call the question. Do I hear a second? Second from Texas. All in favor of calling the question on the motion to amend, chairs of your delegations, please say aye. Aye. Opposed, nay. Motion is Call the question. Now on the adoption of the motion to amend. Chairs of your delegations, please say aye. Aye. Opposed, nay. Motion is amended. To the underlying motion, Alabama.
Thank you, Mr. President. I believe there's no action before us in any of the proposals that does more to remove the influence of the federal government on the lives of our citizens on a day-to-day basis than this proposal, and I urge passage of this proposal.
Thank you, Commissioner, for observing the car wash rule. I would remind you, we following this, we have our time for lunch, and so this will be the last item we'll take up before lunch. Be able to gather those, and given that we still need to move through, I would suggest we take some time to break, bring those back, and come for lunch. Let's go to further discussion on the motion. Let me go to Virginia and then Arizona.
Mr. President and Commissioners, this is probably the most significant item that we're considering here today this whole weekend. The 10th Amendment has been shrunk and twisted and torqued so that the states have almost no power against the federal government. This would be a tremendous step if we could take this step to restore the 10th Amendment to its original intent. We are the creators of the federal government. We need to be able to control our creation. Thank you so much.
Thank you, Commissioner. Commissioner from Arizona.
Thank you. Senator Lesko from Arizona. I enthusiastically support this amendment. I was on the subcommittee that discussed this, and it was well thought out. We spent a number of hours on it and changed it as we thought appropriate. It actually covers a lot of problems that we have with the federal overreach, and it can apply to rules, regulations, laws. It's very well thought out, and I approve of it.
Thank you, Commissioner. Commissioner from Connecticut is recognized.
Thank you, Mr. President. I spoke at some length about this in our committee meeting yesterday. I sympathize with the concerns that the rest of the body and the rest of the speakers have mentioned about the overreach of the federal government, and certainly when it comes to the elimination of the 17th Amendment, something that I think that we should have discussed. To me, however, this amendment is just a bridge too far. I think that as much as I want to restore the rights of the states to have a say in these matters, I think what we're doing here is we're giving the states so much more power than was ever envisioned by the founders, and certainly that the 17th Amendment granted, that it is potentially dangerous. The thing here is that if 3/5 of the states is all that is required, keep in mind that they could be very, very small states with a relatively small population. And if we're referring to the legislatures of those states, now we're only referring to a majority of legislators in that state, in those states. And I think it could be a relatively small number of people making a determination to negate the authority of the federal government in its entirety, way more than the 17th Amendment ever allowed, and I think way more than is just. I'll be opposing this, Mr. President. Thank you.
Thank you, Commissioner. Recognize the Commissioner from Tennessee, then we'll come to Arkansas.
Mr. Chairman, I call the question.
The motion is to call the question. Do I hear a second? Arkansas? Motion is to call the question and seconded. Let me hear a voice vote from the chairs of your delegation in favor of calling the question. Please say aye. Aye. Opposed, nay. Question is called. We will move to the underlying motion to approve the adoption of Proposal 2 from the Federal Legislative Executive Jurisdiction Committee. Mr. Secretary, we'll go to roll call vote.
Mr. President.
Oh, I'm sorry. Yes, thank you. Let's go back to the maker of the motion for summation.
Well, thank you, Mr. President. We had the same objection as the previous speaker did in our committee. And I'd just sort of like to repeat what I said yesterday during the discussion. The commissioner from Connecticut cited this as a bridge too far. Well, members of the convention, I'd like to say there is a bridge too far in the United States government, but that bridge too far is executive orders, the EPA, and the waters for the U.S., or of the U.S., just to name a few. These actions of the executive and congressional legislative branch of the United States government have impacted, I'm sure, every one of our states. And most of us in here, I think, would believe that they're unconstitutional. The people of our nation are in bondage. They're looking for this body and some other action from the various states to act. The time is now. The time is right. Let's get on the bridge and go across it and pass this proposal.
Thank you, Commissioner. Let's place the vote. Mr. Secretary.
Alabama.
Alabama votes yes.
Alabama votes yes. Alaska.
Alaska votes yes.
Alaska votes yes. Arizona.
Copper State votes
Arizona votes yes. Arkansas votes yes. California.
Yes.
California votes yes. Colorado. Yes. Colorado votes yes. Connecticut. Connecticut votes no. Delaware.
Delaware, first state, votes no.
Delaware votes no. Florida.
Florida votes yes with sunshine.
Florida votes yes with sunshine. Georgia.
Georgia votes nay.
Georgia votes no. Hawaii.
Hawaii, yes.
Hawaii votes yes. Idaho.
Yes.
Idaho votes yes. Illinois.
Yes.
Illinois votes yes. Indiana. Indiana votes yes. Iowa.
Iowa votes no.
Iowa votes no. Kansas.
Kansas votes yes.
Kansas votes yes. Kentucky. Kentucky votes yes. Louisiana. Louisiana abstains. Maine.
Maine votes yes.
Maine votes yes. Maryland.
Yes.
Maryland votes yes. Massachusetts.
Yes.
Massachusetts votes yes. Michigan. Michigan votes yes. Minnesota.
Yes.
Minnesota votes yes. Mississippi.
Mississippi votes yes.
Mississippi votes yes. Missouri.
Yes.
Missouri votes yes. Montana. Montana votes no. Nebraska.
Yes.
Nebraska votes yes. Nevada. Nevada votes yes. New Hampshire.
New Hampshire votes yes.
New Hampshire votes yes. New Jersey.
New Jersey votes yes.
New Jersey votes yes. New Mexico. New Mexico votes yes. New Mexico votes yes. New York.
New York votes yes.
New York votes yes. North Carolina.
North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio.
Ohio abstains.
Ohio abstains. Oklahoma.
Oklahoma votes yes.
Oklahoma votes yes. Oregon.
Yes.
Oregon votes yes. Pennsylvania.
Yes.
Pennsylvania votes yes. Rhode Island.
Yes.
Rhode Island votes yes. South Carolina. South Carolina votes yes. South Dakota.
South Dakota votes aye.
South Dakota votes yes. Tennessee. Tennessee votes yes. Texas. Texas votes yes. Utah. Utah votes yes. Vermont. Vermont votes yes. Virginia. Virginia votes yes. Washington.
Washington votes yes.
Washington votes yes. West Virginia. West Virginia votes yes. Wisconsin. Wisconsin votes yes. Wyoming. Wyoming votes yes. Mr. President, we have 43 yes, 5 no, and 2 abstentions.
Thank you, Mr. Secretary. That proposal passes. Commissioners, with that, we have passed 4 proposals as amended. We have one that we've debated we will take up immediately after lunch. Lunch is ready. If you will, why don't we take 20 minutes, gather your lunches, and if you would, bring them back, and we'll continue working through and see if we can get our way through the final proposals. We'll adjourn for lunch. Yes. Oklahoma, excuse me.
Mr. President, our term limits in Judicial Jurisdiction Committee plans to meet briefly. Where are we doing that? To discuss the changes to the bill that same room we met in yesterday.
And then I would also remind you, thank you.
Thank you.
Any with changes to the judicial vacation proposal. Also, if you have any comments or questions on the rules, any comments, additions to the final rules, Professor Nadelson has requested that you funnel those comments forward or funnel them to him as you have additional comments for final rules going forward. We will break for lunch, be back in 20 minutes.
All right, gentlemen, a very successful morning so far. Several amendments already passed. We'll get to those in just a second. One of the questions that we've been getting at hashtag COSM is, who are these folks? So who are the actual commissioners? Where did they come from? Kind of what positions do they hold back home? And
the vast majority are state legislators from all 50 states. There's a handful of others, like Dr. John Eastman from California, former U.S. Supreme Court law clerk, law school dean, conservative activist for many years. So there's a few supplemental folks like that, but the vast majority are, the people that actually have the power under Article 5, the state legislators.
By the way, for those of you that might just be tuning in, this is Mark Meckler, president of Citizens for Self-Governance. Mike Ferris, founder and chancellor of Patrick Henry College, and also really the visionary behind Convention of States. Ken Clark and myself, Rick Green. And Ken, we've had several questions coming in. What other questions are folks at home asking?
Well, one of the biggest questions, and I think is something that we address, we're going to be getting into a lot of Twitter questions and Facebook questions, but one thing that I keep seeing over and over again is, why are we here? What are we doing here? Let's explain that real quick, because I think that's really important. Mike?
Well, what we're doing is giving knowledge, information, vision, and hope. Hope that the federal government really can be curtailed, and that this process really can work, and that it's safe. That we see a very deliberative, informative process where the people that are making the rules are doing it, very seriously, and this gives us a hint of what would come at the official convention later on. And it says this is safe. We can really curtail the federal government. This will work, and so I think it's very hopeful.
Well, Mark, you mentioned this morning, too, it's good to walk through this process before the real. I mean, I think a lot of these folks out here will be the commissioners from their states, so it's a great dry run to get to see what it will actually be like.
It is. And when you're doing something of this magnitude, I think it's really important that you do a dry run. And we've learned a lot. I mean, there are so many things that you couldn't possibly anticipate until you hit the floor, put the rules in place, let people operate under those rules. There's so much collective wisdom in this room, you can't help but learn. So we're going to learn. We'll reincorporate that into the existing set of rules, and those experiences go forward. And as we move forward into the real convention, which I have no doubt we will, this experience will form the foundation for the actual convention.
And you say something of this magnitude. Mike Ferris, I've heard you say on multiple occasions, I think it's very true, that we need a solution as big as the problem. So that
right.
goes back to why we're here. There's a big problem. This is the big solution.
Right. If we want to have government that reinstates the original vision of the Constitution, we have to fix a lot of Supreme Court decisions and the practice of the president and Congress over time in a lot of areas. So the Constitution as written, it's a good deal. But the enforcement of that has been taken from us by the collective power of Washington, D.C. And so we're stripping away that power, going back to the original balance of power between the states and the federal government with some more effective tools to achieve the exact same objective as the founders.
That is the big question, too. You said the Constitution as written is great.
Yeah.
Because people will say, well, why would they follow what these guys are doing if
Right.
they're not following the Constitution now? Address that one.
Because you put new processes in place to check them. We're not changing the spirit of anything, but we're changing, like the vote requirements. The original Constitution gave Congress the power to tax. If you put a two-thirds requirement, say you can't pass taxes unless you have two-thirds of Congress, well, that's a procedural limitation on the power to tax. It's really important that preserves the original intent of the government, that we have limited taxes and that we have a limited government. And so those kind of procedural checks, tweaking the process, because the founders really believe that process protects freedom. And so we don't want to change the freedom principles. We don't want to change the basics of anything. But we do need to tweak some points of the process. And the founders said real experience will show that we're going to need to make some changes over time.
Yeah.
And real experience has shown And we don't have to change the spirit of anything, but putting some checks on the Supreme Court, which is going to be debated right after lunch again, we need some processes to put some checks there.
Yeah, because it has been their interpretation of the Constitution that has been the problem. So that's essentially what we're doing here is allowing the states to overrule that. Ken, what else are folks at home asking?
Well, the first one was, and Mike, I think this follows greatly to what you were just saying, what have we done so far? What has happened with the simulated convention so far? What amendments have been proposed? What amendments have been passed? And so I happen to have a list right here. Mark, you want me to hand that to you?
You go through it, Ken.
Well, and so far we've gotten 4 of them. And the first one is proposal number 1, dent limitation amendment. And I think that's very powerful. I'm not going to read it to you, but that's the first one that's been passed. And the second
real briefly,
one...
what that does is require the states to approve, a majority of the states to approve any increase on the federal debt.
Absolutely.
Yeah.
So in other words, we actually then have a real debt ceiling instead of the fake one that Congress pretends they have right now, right?
Are we actually saying 19 trillion's already too much? I mean, we're actually going to we're actually going to limit it at this point.
I don't know. Give your teenager a credit card, see how well that works.
Right.
The second amendment that has been passed so far is a regulating. It goes the power of Congress to regulate commerce among the several states. In other words, redefining the Commerce Clause.
Right. The vast majority of federal overreach in the area of economics, business transaction, even a lot of criminal law has been through the Commerce Clause. And so if we want to cut back federal regulation of our lives in general, that is the number one thing. In fact, if we got nothing out of the real thing besides that, we have done the nation a great service.
I'd love to jump in on that. To me, and Mike said this, I think this is the most important one. And here's why. There are so many places that if you read the Constitution and read the enumerated powers, it seems so clear to us that the federal government does not have the authority to do the things they're doing.
Yeah,
right?
according to the plain language, it's pretty obvious.
And you mentioned this. People say, well, if they're not following the Constitution now, why will they follow it if we amend it? In fact, that's the primary question that I asked Mike Ferris when he brought this project to me, because that's the one thing that didn't make sense. So I'm biased. I think it's a great question, right? But he had a better answer than the question. And the answer is, and a lot of conservatives are going to be stunned by what I'm about to say, largely they do follow the Constitution. The question is which one, right?
Right.
So is it the one under glass in the National Archives that we love? And the answer is no, that's not our Constitution anymore. Yeah. If you want to look at the Constitution, you have to buy a book. It's over 2,000 pages. It's literally about this thick. And like it or not, that's the Constitution.
That's the Courtstitution, the one that's been
that's a great way to
days.
put it. Exactly. So that includes all those decisions of the Supreme Court, all the things that so offend us, all the things that have expanded government power. And for the people out there who say, we need to protect the Constitution as is, that's the one they're protecting.
That's true. It's so true. And this is the process for actually wiping out that Constitution and coming back. And you said redefining, but really restoring the original intent of the Commerce Clause, right?
Yes, that's exactly what it does. And I think Mike can speak to that better. But real quick, we did just pass one more proposal. Everybody talks about the 10th Amendment. Everybody talks about states' rights. Well, what about an amendment to give the states the ability to override a federal law, both passed and one that would happen in the future? Right.
Yeah. For example, not only Obamacare, but right now the EPA is doing their best to destroy agriculture, the coal industry with this dust regulation. The state legislatures are passing resolutions, like I was in Virginia this year, where they passed a resolution to write a nasty letter to the EPA. Well, big deal. This proposal says you get together 30 states, you eliminate that regulation. And so it gives a real weapon to the states to make the 10th Amendment a real weapon. And that's what we need.
Well, guys, we've heard a lot of people say, Convention of States is too complicated or hard. Nullification is the easy route. Isn't this amendment that we just passed the proper constitutional way to nullify federal law? Isn't that what we're really talking about doing?
Because in the Articles of Confederation period, we had a problem when one state alone could stop needed changes, like we wanted to pay the people who had fought in the Revolutionary War. One state stopped that. And so they didn't want one state to stop anything. They wanted the states collectively to have the power to stop federal overreach. And Article 5 was the method they gave us. But we're going to give us a new weapon where we can stop not only constitutional level decisions, but statutory and regulatory level decisions, and have the states collectively, not all of them, but a majority, a good majority, have the ability to override federal overreach. And, the states once again become far more robust, and the authority and the dignity of being a state legislator just goes up.
And by the way, folks at home, there's so much more information at conventionestates.com. If you'll go there, we're scratching the surface on a lot of these issues, but many of the objections or concerns about convention estates, you guys have written extensively on that. There's videos, there's a lot of great tools, so be sure and visit conventionestates.com today as well.
Well, and I think that the process, the deliberation that we've seen today speaks to how serious of a matter this is and how serious these people take it, because this isn't something that should be endeavored into lightly.
Right.
And that has been very evident with what we've seen so far.
I've heard that from so many people even here saying, look, I came to this over a period of years. I didn't just jump on the bandwagon. Right. It took years of research. I think maybe all of us went through that as well. So like you said, they're taking this very serious. These are thinking folks out here, and you can tell even in the way they deliberate each of these amendments how serious it is to them.
So another question that we have from Facebook, and this comes from Trish. And Mark, I'm going to propose this one to you. Can they remove the power that a president has while in office?
I'm not sure I understand the question. I'll rephrase it as best I can. Hopefully I'm addressing Trish's question. In other words, can we limit presidential power, executive power, generally speaking? When she says while in office, I'm trying to understand if she means midstream in a presidential term, but I'm just going to address it generally. And the answer is yes, they can redefine and limit the power of the executive. That comes within our application. There's an interesting power that the president has that we've heard a lot about recently, and it's this power to issue executive orders. You know, it doesn't actually say anywhere in the Constitution what that power is or how or if it's limited. I think the founders would be astounded. They never intended for the executive to be able to legislate through the use of executive orders. And we are definitely seeing that now. I mean, we see many instances of this. So that's one area where I can imagine a convention could specifically prescribe what a president can and cannot do through the use of executive orders.
Right. At the real convention, you could address it a little more head on. But the abrogation amendment that we just talked about would have the ability to take an eraser from the states and take out any executive order that the president issued.
And I think that's critical. I think the states are screaming for it. I think the people of this country are screaming for it as well.
Right. Yeah, even if they can't describe or define the terminology, people know in their gut, just because a president has a pen and a phone, to be able to make law on their own, we know that's wrong, but we're watching it happen going, well, how do we respond? How do we stop it? This is the answer right here. This is how you stop that overreach from any of these federal branches.
And Ken, before we go to the next question, there's a sort of a general overarching thing that I want to discuss, which is this is not the convention, right? It's actually substantially different in that we only have a couple of days.
Right.
I mean, in a real convention, we'd still be discussing procedural matters here, right? We wouldn't be into the substance. So these commissioners from all over the country have done an extraordinary job truncating this thing, getting into committees, debating in short order, coming to a conclusion in short order. So, but it's important to note the product that they're coming out with, while it is good, it is not, in my opinion, near as good as it would be in a real convention, because they just don't have the time to spend debating. And man, I saw a lot of learning going on in those committee meetings, a lot of opinions being changed and adjusted and language being tweaked. If you were in a real convention with an unlimited amount of time, I presume what would come out would be better than what we're getting here. And what we're getting here, I think, is very good, but it is not final product by any means.
Yeah, I mean, some of the amendments I wrote or drafted, part or all of them. And I was sitting in committee yesterday and going, that suggestion about my language is really good.
Yeah.
I like that. Let's tweak that. And
we even heard people get up and say, in committee I voted against this, but now that I hear more of the debate and I learn more, I'm actually for it.
So the reason you don't want to go away from the convention process is that we can improve language. Things that I've studied for 30 years and drafted an amendment. It's really pretty good, I think. And they left it mostly intact. Some of it they changed, and the changes in every case to my language was an improvement. So the process is so important and will help us because the Bible says that iron sharpens iron.
That's right.
That's what we see going on here, and it's really a terrific
This
process.
truly is wisdom in the multitude of counselors, and you guys are improving each other even as you debate these things.
Well, but I think it brings up a very good point that Jim on Facebook had asked us, who are these commissioners? Where do they come from? How many states are represented? Who are these people? Because, Mike, you had mentioned that the suggestions you're getting are very good. They're very deliberate. So who are these folks?
Well, all 50 states are here, and they are, in 90% of the cases, round numbers, state legislators. and they're used to writing law. There's a handful of lawyers here, but they're mostly not lawyers. They're mostly state legislators.
As a lawyer, I would say thank goodness to that.
Praise God, me too. I mean, we've got, at the pinnacle of lawyers, we've got, a guy that's been a law school dean and was a clerk for the U.S. Supreme Court. So, but, they've got some of us
And
that are
professors that this is their expertise. I mean, they've been doing this for decades.
But nonetheless, the vast majority are people with common sense who've been elected by the people of their state. They're not career politicians, but they're wise in the ways of legislating. And they're tired of federal overreach. So that's one thing, is these people are tired of federal overreach. And that's true when I go out in state legislatures in every state. I don't care if it's red, blue, or purple. States are sick of Congress telling them what to do.
And so this is how the people acting through their state legislatures can affect the federal government, because this is the only tool the Constitution gives the state legislators to do anything about Washington, D.C. Am I right or wrong in that?
That's exactly right. This is the tool where we change. The supreme law of the land is the Constitution. The supreme power of the land is to be able to lawfully change the Constitution by yourself. Only state legislatures have that power, and this is the way that they do it.
Let me get you guys to comment on what happens from here. How does this simulated convention affect the efforts back home? We've been asked how many states have actually passed actual applications. How do you think this affects the legislative sessions coming up in just the next few months in terms of momentum for truly adopting this and making it happen?
Look, anytime that you educate people, you empower them, right? And so knowledge in action is power. And so what we see is we've got legislators from all over the country here and non-legislators, citizen activists, and they're learning about the process. The entire purpose of this event is teaching, right? Collective learning, getting together, learning these lessons together, getting better, but it will naturally generate enthusiasm for the movement. I think there are a lot of people out there watching, maybe for the first time for sure. None of us have ever seen this before, right? And they're looking at this and saying, wow, it's actually working. It's a deliberative process. I'm impressed by the quality of the debate I'm hearing. So I think there are people who've never even heard of it that are going to see this and be impressed. And I think that builds enthusiasm. And truly, the Convention of States Project has to be a grassroots movement by nature. And so as much as this might affect legislators, I think it affects the grassroots even more. You'll see the enthusiasm blossom beyond the 1.5 million people roughly who already support it. Interesting note for those of you who are watching out there, whether you're involved or not already, today, the Convention of States Project has literally volunteers or people who have signed in support in 100% of state legislative districts in the country. Every single one. Never been done before. We actually had to send a guy out in the field into New Hampshire to nail down those last couple of districts.
Well, I remember that's kind of what got me excited, Mike. Even 3 years ago at one of our legislators' conference, you got up and started describing the grassroots process for doing this. So it was no longer just a theoretical discussion of us all sitting around and saying, hey, what if we did this? You laid out a plan for how you would actually, and this was one of the goals, to have people in every legislative district, and it's happening.
Yeah, I borrowed on my 30 years of helping homeschoolers fight for freedom. And thought, when there's a reasonable number of people who contact their legislators in any state, the vast majority of them will listen and often respond. And if you put enough pressure on state legislators, you can get stuff done. And you don't need a majority of America because a majority doesn't participate. Victory in politics always goes to a majority of those who participate. And in state legislative matters, less than 1% of the people ever participate. And so with 1% of the American public, that's about 3 million people. I guarantee you this gets done. 3 million people spread out evenly among their legislators. This will pass.
It's real. It's incredibly realistic. And you mentioned both the legislators and the grassroots folks going home with momentum from this. Just sitting around in the mills or out in the hallway talking to some of these legislators that attempted to get this passed last session. I can see the optimism in their eyes and in the things they're saying, because now they're not just, again, theoretically talking about it. They're going to be able to go back home and talk to their fellow legislators and say, look, let me tell you exactly how it worked. I can tell you from firsthand. It can be done. It will be effective. So they're going home more motivated. And like you said, Mark, all these folks at home watching today, you guys need to be sharing this on Facebook and Twitter. Everybody at home needs to be talking as well and showing them the realism of how this can be done.
Well, and I hope that people will also watch. You can see on our Facebook page we have links to, we had James Madison come speak to us. And it was really extraordinary, right? A piece of living
It
history.
wasn't the real, just in case anybody was.
I sure
yeah.
felt like
I mean-
it to me, man. It was, so, here in Williamsburg, there's historical reenactors. Madison comes and spoke to the assembly here. It was really extraordinary to hear him talk about the history of the Constitution, how it developed, the history of Article 5. And he used this metaphor talking about a blank piece of parchment and how everything in American history, in his life and in history generally, starts as a blank piece of parchment. And I think where we're at right now, really, Article 5 and the use of this second clause of Article 5 was, until this event, a blank piece of parchment.
It's true.
We've been writing a couple of notes on it as we build out our network, but I think the first chapter is now written on that first piece of parchment, and that's this event.
Yeah.
And history will record this event. For those of you who are watching, I mean this with all sincerity, you ought to write this down.
Yeah.
You ought to put it in your diary or your journal. If you know American history, you know the Annapolis Convention is critical to the whole process of the drafting of the Constitution and passage ultimately. And when people study 1787, the convention, they have to look back to Annapolis,
That's
right? This is the equivalent to Annapolis, in my opinion. The actual convention doesn't take place without this convention first. And when historians study it, when our kids and our grandkids and our great-grandkids study it, yes, they will study when we actually hold the convention, but they will say, how did this happen? And they will look to history, and they will look to this event.
Yeah.
They'll want to know who was here. They'll want to know what was said. They'll want to know what amendments were debated and passed. This is literally extraordinarily history in the making. It's an incredible privilege to sit in the middle of this thing.
No doubt. And you may be, people at home may be saying, well, I'm not there, and what can I do, and that sort of thing. I'm not a constitutional scholar like Mike Ferris. I haven't headed up a huge grassroots organization like you have, Mark, a radio host like Ken and I. But there are all kinds of tools at our website at conventionestates.com that people at home can use. I mean, we've created, everything's at their fingertips. Now they can go out there and use that in social media to help move people.
I think one of the things that we have the benefit of that we didn't have in Annapolis or things like that is what the four of us are doing right now and what we've been doing all day. This event is being streamed live on the internet, and there are literally thousands of different people out there. There are literally thousands of watch parties going off throughout the country right now as we speak. So talk about transparency, talk about documentation, talk about seeing the live debate. Which one of us wouldn't have given our left arm, okay, to be in that room in 1787.
I'm glad you said left, not right.
Yeah. Well, that one I can do without. So, but I mean, think about that, and think about the millions of people that are going to be affected because they're going to be able to go watch the committee hearings that happened yesterday, watch the live debate in the committee that I was filming yesterday. They had subcommittees, and I was able to get what was going on in each amendment. That's powerful, and these people will understand just how deliberative of a process this truly is.
As these commissioners wrap up lunch and come in, what should we expect for the afternoon? What's next?
Well, the very next thing is going to be a proposal that was being tweaked out in the hallway. I was out there helping with the tweaking process on giving the states the ability to override decisions of the Supreme Court of the United States. The Supreme Court was intended to be a court, not a legislature, but way too often they act like a legislature. And so we're giving a mechanism for the states to fight back against that.
Well, in fact, didn't Hamilton tell us we didn't have to fear the court unless they acted like the legislature, which is what they've been doing?
That's exactly right. And then then he says it's just utter despotism.
Yeah.
And so we're here to stop despots. It's a really simple thing.
That's exactly what we're doing. So, folks, you want to know how to solve it? We're about to watch it happen right here. They're going to be debating that amendment in just a few moments. Let's get back to the action.
Welcome back to the first ever Convention of States simulation. My name is Ken Clark. This is the president of Citizens for Self-Governance, Mark Meckler. Mark, we've been talking about this all day long. We've been going back and forth. We've been debating amendments. We had committee hearings yesterday. Where have we come so far in the process, and where are we going to go this afternoon?
And so real quickly, for the folks who are just joining us, we've had 4 amendments passed. Really extraordinary. I mean, this is a very truncated process to see them get through the debate and see them, the gentility and the statesmanship with which this is operating is very extraordinary. And they've just had a really short lunch break. They're moving straight back into debate. We don't want to talk too much because we want to listen to the debate, but you're joining us in midstream, the first ever Article 5 Convention of States, a simulation, a dry run. It's going incredibly well. At the chair, at the helm of the thing, is the elected president, Ken Ivory, a representative from Utah, and the vice chair is Professor John Chapman from California, and I think we'll let you rejoin the proceedings.
Absolutely. That's a wrap. We'll be back later.
We had is related to balance between Congress and the Supreme Court. We also had an issue between, the federal Supreme Court and state relationship. So the language you're going to see essentially deals with the state side of that and protecting the state interests. The question of balance between Congress and Supreme Court is probably best left to a separate amendment. So keep that in mind as Dr. Eastman explains. And Mr. President, our colleague from Oregon may need to weigh in as well. Thank you.
Thank you, Commissioner. We have had substantial debate on this, Commissioners. We will now go to the Commissioner from California to what I understand is a substitute motion.
This is a substitute motion from the committee, so this is now the proposal from the committee. What we did was we eliminated the aspects of federal law being invalidated by the Supreme Court, recognizing that Congress itself has tools at its disposal, whether the impeachment power or the power to offer an amendment of its own, that it can use if the situation is dire enough. Ever since the 17th Amendment passed, however, the states no longer have any tool at their disposal. And this amendment is designed to give them a tool to check an overly aggressive Supreme Court that is effectively usurping its powers under the guise of constitutional interpretation. And this would leave the ultimate decision of what the Constitution means as Abraham Lincoln understood it to be, in the hands of the people of the states. In response to Dred Scott, Abraham Lincoln famously said in his first inaugural address that the court's decision is going to be final between the parties of the case, but if we are to treat the court's opinion on a matter of contested policy as the final decision of the government binding on all of us for all time, we will have ceased to that extent to be a self-governing people. This amendment is designed to get that balance back in correct line. So any decision of the Supreme Court invalidating a state law may be vacated and the law reinstated. And that phrase is in there to deal with what if the Supreme Court had merely affirmed a lower court decision. The law reinstated by a resolution passed by 3/5 of the states or by both houses or by 2/3 of both houses of Congress. And then the second thing, to pick up on that Abraham Lincoln idea, the decision is going to be binding as between the named parties of the case, but it will not have binding effect forevermore. It will not be precedent. And so the elimination of the first sentence in Section 2 is designed to put this proposal in line with that very wise understanding of Abraham Lincoln. Thank you, Mr. President.
Point of order. Thank you, Commissioner.
Point of order.
Yes, the Commissioner from Arkansas, or from Alaska is recognized.
Yeah, the states are really close. But I'm pretty sure that since we already had this amendment in front of us before lunch, that this has to be an amendment to the amendment. I don't think the committee can bring this forward, as a new one, unless they take one away.
I think what the motion is a substitute motion. So with the sponsor coming forward, we defeated a motion to amend, and so the underlying proposal was before us, and so now what's pending now is a substitute motion to the entire proposal, and so then we'll consider whether we adopt that or not.
Don't we need a second to be able to have that on the floor?
Yes, we will. We will. Prior to that, Commissioner, you had you spoke previously about deleting Section 3 and moving Section 4 up. Is that germane to this, or does Section 3 still stay?
Because we've allowed Congress itself to vacate a Supreme Court decision invalidating a state law, Section 3 still is necessary.
Okay. Thank you for the clarification. Do I have a second to the substitute motion? Second from New Mexico. Thank you. The motion is before us. Discussion to the motion. Discussion to the substitute motion. Or, discussion to the motion to substitute. Seeing none, I'll place that. Yes, gentleman from Texas is recognized. Do we have a microphone for the Commissioner from Texas?
The right side or the left side?
I know.
Does
I hope someone's not trying to tell me something. I rise in opposition to the motion to substitute because of the
because of the extreme nature in which this amendment would narrow the proposed amendment as it was originally made. The three words, invalidating a state law. Any decision of the Supreme Court invalidating a state law may be vacated, and no others. That means Congress exceeding its Commerce Clause power may not be vacated. That means an Obamacare statute, for example, that exceeds the power that exceeds the scope of its power may not be vacated. Only state laws that are invalidated may be vacated. And I don't know if that was the intent of the committee passing this. I believe the committee wanted a substantive limit on the Supreme Court's power. I don't think, as amended, this constitutional amendment does that.
Thank you, Commissioner. Let me recognize the Commissioner from Maine.
Thank you, Mr. President. Commissioner Greenwood from Maine. I have a question that I'd like to pose to the President.
To the Chair.
To the Chair.
State your question.
My question is, could somebody answer whether it's both houses in a joint convention or each house by the 2/3?
I think that's better for the sponsor of the substitute. Let me direct that to the sponsor of the substitute. Will you yield to the question? The maker of the substitute, please, Commissioner from California.
Yes, I'll yield to the question. If you would like to propose, I think that's a clarifying amendment. 2/3 of each house of Congress is what the intent was.
Okay, so would you make the motion to amend the substitute? Well, we haven't adopted the substitute yet. That's okay, we can amend the substitute and then still move for adoption. So the motion is to amend the substitute motion, which is, would you please restate?
To clarify that it says on the third line down, by 2/3 of each house of Congress.
Okay. 2/3 of each house of Congress, okay. Do I have a second to the motion? Second, Alabama, on the motion to amend the substitute motion. Discussion to the motion to amend? Seeing none, all in favor, please say aye. Aye. Opposed, nay? Okay, the substitute motion is amended. We still have the substitute motion before us. Let me go to West Virginia.
Thank you, Mr. President. I would point out in addition, while I don't really support this particular amendment as it's stated, because I think it does narrow it too much as was brought forth by Texas, even as it is, I think it needs work. So if it were to be adopted, I would propose an additional amendment invalidating a state law. We've also had issue with the Supreme Court invalidating state constitutions, which would be outside of this as well. So when, for example, states have adopted a marriage amendment, and then the recent decision by the U.S. Supreme Court invalidated those state constitutions that contain that provision. So I think this can't be simply state law. It would have to be state law or constitutional provision. And so I would move that that would be amended into this amendment.
Is that a proposal to amend or merely a comment?
It's a proposal to amend that into this amendment, that after state law or constitutional or state constitutional provision.
Do we have our Professor Barnett? Would you? Well, let me if you wouldn't mind. So the proposal, I'm sorry, Commissioner, is state law or constitution?
State law or state constitutional provision.
State law or state constitutional provision. So the amendment, the proposal, motion to amend the substitute to state any decision of the Supreme Court invalidating a state law or constitutional provision on the first line. Is that correct?
That's correct.
Okay. Robert, can you get that, Mr. Secretary, we get that put in? State law or state constitutional provision. Thank you. Okay, so that we have a motion to amend the substitute. Do I have a second to the motion? Have a second from Alaska. Discussion to the motion to amend the substitute motion. Yes, Commissioner from Florida.
Thank you, Mr. President. We also need to add there on line 2, and the law or constitutional provision reinstated.
Does that reflect your proposal?
Yes, sir.
Okay. So the motion to amend, I don't know if we're still to the, all right, you have to help me out here. Did we already amend and pass on state law or constitutional provision? Have we done that yet? We haven't done that yet. So let me go back to the gentleman from West Virginia. Would that be consistent with your motion?
In fact, what I was going to say is it is consistent, and so in order to prevent too many deep in terms of potential amendments to the amendment type thing, I would like to withdraw and restate my amendment to be such as has been suggested.
Okay, so the underlying motion that's amended is withdrawn. Please recognize the gentleman from West Virginia.
And so my amendment would be to, on that first line, add that additional language of or state constitutional provision, and then on the second line, add the or state constitutional provision reinstated.
Okay. As it's reflected on the screen?
As is reflected on the screen, except state, well, I guess law or constitutional provision is sufficient. So, yes, as it is on the screen.
Okay. Okay, so that is the motion to amend the substitute proposal, seconded by Alaska. Discussion to the motion to amend the substitute. Seeing none, we'll place the motion. All in favor, please say aye. Aye. Opposed, nay. Okay, so the substitute motion is amended. Now we're back to the underlying substitute motion. Discussion on the substitute motion for proposal number 2. The commissioner from Alaska is recognized.
Thank you, Mr. President. I guess I just need to hear more conversation why we're narrowing it so much. Because we've had things happen in Alaska that has nothing to do with state law or constitution, administrative orders, others. So if those who had the meeting in between at lunchtime could tell us what the issues were, why they thought they needed to narrow it versus keeping it the way it was beforehand.
So that's a question to the maker of the substitute.
Yes, Mr. President.
Will you yield to a question?
I will, Mr. Chairman. There are two ideas. One, if the Supreme Court has affirmed an act of Congress that intrudes on the states, vacating that decision is not going to accomplish anything. It would leave the underlying bad law in place. The abrogation amendment that we adopted earlier in the session is intended to deal with that. So we didn't have to deal with that aspect here. The second thing is if the Supreme Court had struck down an act of Congress on the ground that it was exceeding Congress's power and intruding on the states, giving Congress the ability to vacate that decision seemed counterproductive to protecting the states. So when we strip both of those out, we're then left with protecting the state laws against invalidation decisions by the Supreme Court, or letting the states also invalidate when the Supreme Court has struck down a congressional law, and we decided that protection of Congress can be handled elsewhere in another amendment. It made this one too cumbersome. The second point, though, may be well taken. We're limiting it to state law or state constitutional provisions. There are a lot of other actions by the states that the Supreme Court might hold to be unconstitutional. And, you know, without thinking through all the implications, an action by a police officer, an action, how broadly do you want that to go? We thought that maybe if an action that was not a state law was invalidated by the Supreme Court, and the state would have a response to come back and adopt it as a state law that would then trigger this, that may handle that situation without getting too much into the weeds.
Thank you, Commissioner. Yes, the Commissioner from Alaska is recognized.
Thank you, Mr. Chair. I propose an amendment to the amendment, Mr. Chair, and it would be inserting after the word invalidating in the first line, any provision of state law. This would make it clear that it would include regulations as well.
So to restate, it would be, you're proposing an amendment to the substitute, any provision of a state law.
Any provision of state law.
Any provision of state law or constitutional provision. Does that restate your motion?
It doesn't have the word a, and it changes the meaning.
Is that how you proposed?
Yes, Mr. Chair, may I respond to the remark?
Well, there's no remarks before us. We're just working on your language, so I want to make sure that we've stated your language correctly. Is this the language you're proposing?
Any provision of state law.
Any provision of state law with or without an A?
Without the A.
Without the A. Any provision of state law or constitutional provision. Okay, and then, so that's your motion?
Yes.
Do you have a second to the motion? Second from Kansas. So we have a motion and a second. Discussion to the motion. Discussion to the motion to amend the substitute motion. Let me come to Virginia.
May I speak to it, Mr. Chair?
Yes.
Thank you, Mr. President, Mr. Chair. Yes, actually, this was in discussion with our legal scholars in the back of the room. It would include state laws and regulations with this added language. And there are times where the Supreme Court is ruling on a regulation, so it's important. I think regulations we've found have been problematic in many states, so it's important that we make that clear. Thank you, Mr. Chair.
So discussion to the motion to amend. Virginia, is your comment to the motion to amend?
No, sir. I had a question to the underlying.
Okay, we'll come back to you on the underlying. Discussion to the motion to amend. The gentleman from Michigan.
Or state constitutional provision, then after it may be vacated, we have to put and the provision of state law or constitutional provision, just so that the language matches in both clauses.
Okay, I'm sorry, I didn't follow what you're proposing.
Validating any provision of state law. And in line 2, it should just match that and say the provision of state law. It should be the same wording in each clause. No one's following me. Got it. Okay.
So let me go back to the maker of the motion to amend. Is this a friendly amendment to the language that you're looking to propose?
Yes.
Okay, so we'll accept this as a friendly amendment. And we have a second from Kansas. Let's, any further discussion to the motion to amend? Yes, gentleman from South Dakota is recognized.
Thank you, Mr. Hello. Thank you, Mr. President. The problem I see with this amendment is that I don't see how it would take care of some of the most egregious court decisions, such as the couple that we had on Obamacare. We now are unable to deal with those court decisions. And the second part is, it seems to say if the Supreme Court invalidated a state law or a provision of state law, sometimes the Supreme Court leaves the law in place but then interprets it to mean such. And so we may not be able to vacate that decision because it didn't invalidate a law. So I'm just not sure about the language here. I understand that there's a difficulty in approaching this subject, but I just wanted to voice those concerns.
Thank you, Commissioner. Again, to the motion to amend the substitute motion. Further discussion to the motion to amend as before us. Seeing none, let me place that motion. All in favor of the motion to amend the substitute motion, please say aye. Aye. Opposed to the motion, say nay. Okay, I will rule that passes 5-3. To the substitute motion as amended. Discussion to the substitute motion. Let me come to Virginia, and then we'll come to Kansas.
Thank you, Mr. Chairman. I guess I have a question for the offer of the substitute, if that's appropriate.
Will the maker of the substitute yield to a question?
I will.
Proceed.
My question is whether Section 1 is intended to apply prospectively, meaning decisions of the Supreme Court made after this amendment would become ratified, or is it also a look-back provision where we could go back and look at Supreme Court decisions of the past that have been validated law?
I think I'm safe in saying the intent of the committee was that it be both prospective and retroactive. It says any decision of the Supreme Court.
Thank you.
Further discussion to the substitute motion as amended. Commissioner from Kansas.
Thank you, Mr. Chair. I do rise in support of the substitute amendment to the proposal. However, I do want to just correct, it's been over here bugging me, the S on houses needs to be removed. I think that's really just grammatical.
It is struck.
Is the S struck? I
It
can't
is
see
struck.
that from here. Well, in that case, I am all good with that. And I do support the substitute motion.
Okay. So we're good then? Okay. Further discussion to the substitute motion. Yes, Virginia.
Mr. President, is it appropriate at this time to speak to the underlying measure, the full measure?
This is where we are. We're now on the underlying substituted motion.
Mr. President, it's Virginia's intent at this juncture to support this amendment because of the fundamental nature of permitting states to deal effectively with the Supreme Court when its laws, frankly, have been struck down unjustly. But I would remind the body that on game day, when we are doing this for record at some point, hopefully in the future, that we keep our eye keenly on the ball of what can pass and be ratified by states sufficient to make it law. And while this is a great discussion we are having on an important issue, this is a tough one because you have to get it right. And you have to make sure that you have not created unintended consequences. And so for our purposes today, my delegation is going to be supportive of this concept, recognizing that going forward, I believe we have lots of work to do in the details of items as this. Thank you, sir.
Thank you, Commissioner. To the substitute motion, let me recognize the Commissioner from New Hampshire.
I have a problem with the substitute motion because it doesn't say how far do we go back on the Supreme Court decisions. The Supreme Court has been making decisions over 200 years, and it says, well, do we not like a decision that was made in 1810? You know, that's a problem. If we need a time certain of how far you can go back and look at Supreme Court decisions, because if we go Dred Scott or the Percy decision and we go back, then it has effects on a number of decisions. So there has to be a limit because the Supreme Court has made decisions, unmade decisions. So that's my problem. We have to have a time certain that we can go back.
Thank you, Commissioner. Let me recognize the Commissioner from Alabama.
Thank you, Mr. President. I would like to reiterate the gentleman and my colleague from Virginia. We're in a spirit of doing something that is historic, and that is finding means in which we can actually control the federal government and all its aspects. And for that, I believe Alabama is going to be supportive of this proposed amendment. But we are treading on the edges that we need to be careful of. We are treading, like the gentleman who spoke earlier, the former Marine, bless his heart, who we may be going just a bit too far in abrogating and affecting and afflicting. I support what we have. I think we need to get something directly out of this body in order to send a message through and, if not, eventually control actions of the Supreme Court. But let's be careful in how we do it, and let's make sure that we can do it. Thank you.
Thank you, Commissioner. Commissioner from New York.
In deference to my colleagues from Virginia and Alabama who spoke eloquently on this, I agree that this is an area that we need to work with, but the fact that we already know that there are problems with it, that there are issues that are not clear yet, and especially in the fact that we are supposed to be promoting not only the entire Convention of States and how Article 5 Convention will work properly to the general public, I feel that we should only push forth those amendments which we know are acceptable and will work properly. And while this is a great idea, there are too many things that need to be worked out. And as such, I would stand opposed to the proposal as stands.
Thank you, Commissioner. Let me go to the Commissioner from West Virginia.
Thank you, Mr. President. I think spotted what might be something that needs an additional change, and that is after any decision of the Supreme Court, and it leaves open the possibility, for example, that one of the inferior appellate courts or single federal judge could invalidate a state law, which the Supreme Court never takes up the case. There's tons and tons of those that occur where they simply don't grant certiorari. So I would insert a comma after Supreme Court and perhaps insert the words or other inferior court operating under Article 3 of the United States Constitution, comma. And if somebody can come up with shorter language that means the same thing, I'll go along with that as well. But any other federal court? So, comma, or any other federal court.
So, comma, or any other federal court, comma.
Yes.
That's your proposed amendment?
Yes.
Mr. Secretary, I believe that he stated there should be an or any other federal court. Do I have a second to the motion? Second from Alaska. Discussion to the motion to amend. If you're standing, you wish to speak to the motion to amend. Commissioner from Colorado.
Thank you, Mr. President. I rise in opposition to this amendment, and the reason I do is twofold. First, that the consideration that any court inferior to the Supreme Court is at the district level or below, meaning that its actual jurisdictional authority is a very small portion of the overall 50 states. I find it quite unlikely that there would be an action on the part of all of the states if a decision has only that much import. And I'm troubled by, and this is my second point, us complicating an issue, a constitutional amendment, too much. So as much as this is in the spirit of this proposal, I believe it's a complexity that is not appropriate and would urge its rejection.
Thank you, Commissioner. Further discussion to the motion to amend. Commissioner from Florida. Oh, I'm sorry. Let me come back to Indiana. Are you to speak? No. Okay. We just got your sign held high like Hoosiers would, right? The underlying. Okay. Thank you. To the motion to amend.
Thank you, Mr. President. And I was standing to speak to the underlying, but I think the amendment further illustrates the point I was going to raise, which is I believe this amendment in total is not quite baked and ready to be served. And it follows the case I laid out previously, in which I was overwhelmingly, my advice was rejected regarding executive and legislative authority. But as we stood here and talked to each other, had we not, for example, adopted the amendment of invalidating state law, this would have allowed states to invalidate Marbury versus Madison and undo the entire structure of how the Supreme Court operates. There are so many permutations, as illustrated by the current amendment under consideration, that this amendment is not in any way, shape, or form ready to be sent off this floor. I think there are many, many, many permutations that we have not even begun to consider of how this would play out. Thank you, Mr. President.
Thank you, Commissioner. Let me recognize, we'll go to the Commissioner from Mississippi, and then we'll come to North Carolina.
Thank you, Mr. President. Although I agree with the intent, overall intent of this legislation to rein in a rogue court, I do think there's a lot of questions out there, and if motion's proper, I'd like to table this amendment.
That is in order. The motion is to table this proposal. Do I have a second to the motion to table? Second from Arizona. Is it? Oh, I'm sorry. So, well, I don't know that it's not appropriate. I'm going to rule that it's out of order to do a motion to table an amendment. Was your motion to the amendment or to the entire proposal?
To the whole amendment, not just the strike off, but the whole.
To the whole proposal?
To the whole proposal, yes, sir.
So the motion is to table this proposal. Is there a second to the motion to Georgia?
Point of order.
Yes, the gentleman from New Hampshire is recognized for point of order.
Thank you, Mr. President. It's inappropriate to speak before offering a tabling motion.
That is correct. We've been somewhat lax. It's inappropriate to speak before offering any motion, and I appreciate the point of order. We've been somewhat lax on that. Let me recognize so I think given the point of order, we're back we're back where we started. Let me recognize the gentleman from Minnesota.
Thank you, Mr. Chair. I would move that we table this underlying proposal.
That is in order. So the motion is to table this entire proposal. Do I have a second? Second from Indiana. Is that that's not a debatable motion?
Point of order, Mr. President, but don't we have an amendment first that we have to deal with? Take it
Well,
on and then?
the motion to table would supersede that. I mean, I think that's only superseded by a motion to adjourn, if I'm correct. It's higher in the hierarchy. So the motion to table is supersedes. So and for our parliamentarian, this is non-debatable. Is that correct? So this is a non-debatable motion. The motion is to table this proposal. And let me place that motion. All in favor of tabling proposal 2. Let me just ask too, do I go back to the sponsor on a motion to table? Okay. Okay, thank you. So the motion is to table proposal 2. Let me place that motion. Chairs of your delegations, all in favor of tabling this proposal, please say aye. Aye. Chairs opposed, say nay. I'm going to rule that motion passes. The proposal is tabled.
Mr. President. Division.
Yes, the commissioner from Virginia is recognized.
Call for division, Mr. President.
Excuse me?
I call for division.
Division has been called. Under the Mason's rules, do we need 10? How many do we need to stand for division?
Stand?
Do we stand or vote?
No. Yeah, you standing, yes. So have the assembly stand.
What's that?
Have the assembly stand.
Okay, let me, on division, do we have in our...
That's probably true.
Mr. Chairman, Mr. Chairman, Mr. President.
On division, yes.
Parliamentary inquiry.
Yes, Commissioner from Virginia.
Would I not be correct that in a motion to division, if the chair rules as such, that it would be the chairman of the several delegations that would stand and be recognized on either side of the question? Would that be correct?
That is correct. That is correct. So let's go with the chairs of the delegation in favor of division. Well, no, I'm sorry, that's not right. So we'll just do a roll call vote, because in my house, the way we would work it, if 10 or more stand, we divide, which means we hold a vote, and we have a roll call vote. Let's just go quickly through a roll call vote on the issue of whether or not to table the proposal. That's where we're at. The question is, did the motion, I ruled that the motion to table passed. Let's just go to a roll call vote on the motion to table. Yes, sir. No, I think the division. We're voting on tabling or voting on.
It's not an appeal. They call it down.
on the issue to table, right? So we're just going to go to a roll call vote on whether or not to table.
So we're not doing the division vote now.
Correct. We're just going to do a roll call vote on whether or not to table. So an aye vote is to table Proposal 2. Let's go to the roll call vote, Mr. Secretary.
Alabama.
Welcome back to the Convention of States live stream. My name is Ken Clark. I have Professor Rob Nadelson sitting with us. Thank you for joining us again, Rob.
Great to be here.
So, Professor, let me ask you this question. We've been seeing a lot of procedural moves. We're talking about roll call votes. We're talking about tabling, points of order. There was a division called. Explain what we're watching.
Well, there's a very controversial measure which has been proposed by one of the committees, and the measure has gone through a number of different amendments on the floor. In fact, the sponsors themselves have asked for an amendment on 1 or 2 occasions. And so finally, a number of commissioners have concluded that really this measure is too complicated to fine-tune sufficiently to actually be offered as an amendment to the Constitution. And so as a result of this, one commissioner made a motion to table it. And that is what we call a privileged motion, no debate on the subject. And so the chair then called for a voice vote on the question of whether to table, and the chair ruled, based upon an overwhelming volume of aye votes, that it was in fact tabled. Then one person stood up and he asked for a division.
Now, what is division?
Well, see, a division can mean 2 different things, and I think in the home legislature, the person who asked for the division, it means something different than it means under these rules. What that person was really asking for was a split of the vote, so that people announced who was for and who was against. However, division under the rules here means taking a particular motion and dividing it into 2. So there was a little bit of confusion over exactly what was meant. The president, I think wisely, resolved the issue by simply saying, look, we'll have a roll call vote on the subject. Everybody can be on record as a result, and I don't have to make a judgment as to who wins.
Rob, thank you. Thank you for explaining that to us. We really appreciate it. We're going to go back and watch what's happening on the floor. Thank you.
Then I determine we have a quorum. I vote aye.
Oklahoma votes yes. Oregon? Yes. Oregon votes yes. Pennsylvania?
Yes.
Pennsylvania votes yes. Rhode Island?
Yes.
Rhode Island votes yes. South Carolina? South Carolina votes no. South Dakota?
Aye.
South Dakota votes yes. Tennessee? Tennessee votes yes. Texas? Texas votes no. Utah? Utah votes yes. Vermont?
Vermont votes no.
Vermont votes no. Virginia? Virginia votes no. Washington?
Washington votes yes.
Washington votes yes. West Virginia? West Virginia votes yes. Wisconsin? Wisconsin votes no. Wyoming? Wyoming votes no. Mr. Chair, the vote is 35 yes, 15 no.
Chair rules then the motion to table Proposal 2 passes. We will move on to item number 2 from the Fiscal Restraint Committee.
Mr. Chairman,
Yes.
might I have a moment of personal privilege?
I will rule that is in order pursuant to our car wash rule.
Okay. Members, I think this last action speaks to the point that I want to make. We all share a deep concern for the overreach of the federal court system. And our most recent action says, to quote my fellow commissioner, this one's not fully baked, not ready to be served. There may be others in our consideration today that may not be ready for prime time as well. I would like to suggest that we direct staff to begin now crafting a statement for this body to adopt at the end of our deliberations today that sends a message to the American public that we are presenting this list of proposals that we have approved, and we're supplementing that with a group of topics suggesting further deliberation, recognizing that these topics must be addressed by the Convention of States when one occurs. That would be my suggestion, Mr. President.
Thank you. Appreciate the comment. I'm sure that is noted by staff. Thank you, Commissioner. We'll move on to proposal number 2 from the Fiscal Restraint Committee. Recognize the Commissioner from Colorado.
Thank you, Mr. President. I move proposal number 2 from the Fiscal Restraints Committee. Mr. President, this proposal in essence repeals the 16th Amendment. It does it by first stating that Congress in Section 1 shall not impose taxes or other exactions upon income, gifts, or estates, or upon aggregate consumption or expenditures. Then it adds, but Congress shall have the power to levy a uniform tax on the sale of goods. Would point out that in our discussion we acknowledge that in fact Congress has that authority today if they were to exercise it, but we were trying to be as clear as we could on the direction this would go. Section 2 is concerning the increase in any taxes that Congress would have the authority under this amendment, would require a 3/5 vote from both the House and the Senate. And then the final section deals with making the effective date 5 years from its ratification, because of course at which time the 16th Amendment is repealed, giving an appropriate time for the transition from one taxing structure to another. Mr. President, I would also ask that a couple of stylistic changes be put into this or removed, in a sense, that being that the number 16th be spelled out, and that at the end of Section 2, period be placed at the end after President, because it is both redundant and not within the character of constitutional law to say President of the United States. Therefore, I make the motion and ask for those two.
Yeah, let's deal with those, and then we'll let you continue with your presentation. So the motion without objection is to delete in Section 2 at the end of the United States, so it would be presented to the President, period. And in Section 3, the number, Roman numeral 16, would be spelled out to 16th article. Without objection, we correct those Scribner's errors. Hearing none, we'll...
There was
there's a second.
Mr. President,
yes,
the state of Delaware seconds the fiscal restraints proposal number 2.
Okay, we have, well, we're on the Scribner error. We have a second to the Scribner error. I'll come back to you. So without objection, we'll correct the Scribner's errors. Commissioner, back to you.
Thank you, Mr. President. Just to wrap up the motion here and the explanation of it, this is a significant change by repealing the 16th Amendment, which of course is the amendment authorizing the income tax collection from individuals rather than the other provisions for taxation. It is a proposal that our committee felt appropriate for consideration of the body, and I ask for its approval.
Thank you, Commissioner. Delaware second?
Delaware seconds the proposal from the gentleman from Colorado.
Second from Delaware. Discussion to the proposal number 2 from our Fiscal Restraint Committee. Recognize the gentleman from Connecticut.
Thank you, Mr. President. I rise in opposition to this proposal. I think one of the things we have to keep in mind is the problems we came here to address are functional problems of the government, clarifications above all, I think, in the Constitution among the division of powers, and especially as between the federal government and the states. This is an issue of policy, and I myself would prefer this system of taxation to what we have currently. That said, I don't think it's appropriate to do this by way of constitutional amendment. For one thing, that's not the place for policy. And second, we, not knowing what the consequences of this change might in fact be, we could bind the hands of a Congress for bad effects down the road. It's conceivable, if we think back to the days of the founders, that such an amendment might have been proposed, or a constitutional provision to limit the country to an excise tax, which was what they were collecting on the federal level at that time. That's exactly the kind of thing that can become antiquated, to use the word that was used earlier in reference to the Constitution. Systems of taxation come and go. It's the constitutional document that we have to focus on correcting, and I think we would be making a mistake by including this.
Thank you, Commissioner. Further discussion to the motion. Recognize the gentleman from West Virginia, then we'll come to Texas.
Thank you, Mr. President. I rise in opposition to the proposed amendment. I know this is circulated around the country quite a bit, the so-called fair tax. But the reality is the name of this tax, almost everywhere else you hear it, is called value-added tax. It cascades and it builds upon itself as it works its way through the supply chain, and it winds up costing a lot more money to buy the goods than what the tax itself simply collects. Because the way any business, and I think there's a lot of business owners in here, sets their price is based upon a percentage markup. They're looking for a percentage profit. And so as it works its way through the process, they constantly have to mark up the product in order to keep up with the increased cost that's caused by the tax. Value-added taxes aren't really a good economic tax anywhere they've been tried. This one would be no different. In addition, I would argue against this because I think it contains a fundamental assumption that is simply wrong. Our problem with the federal government and the out-of-control spending and the out-of-control regulation and everything else is not simply because we have the wrong tax. A proposal that simply created a flat tax, income tax, would be better than what we have. This might be better than what we have, but the real problem that we have with the federal government is the federal government just simply has too much money. And when you have that much money, you're going to do something with it. And so the appropriate thing to do with the federal government would be simply Section 3 in this article. Let's get rid of the 16th Amendment, but let's not give them a whole different revenue source that allows them to continue to spend more money than they ever really should have spent. They're out of control because they have the money to be out of control. So I oppose this because of its value-added principles and because I don't want to give them another way to get the money they need. I want them to have less money.
Thank you, Commissioner. Commissioner from Texas.
Be abstained here. Okay. Karma.
Mr. President, I rise as the sponsor of this amendment in committee as well. First of all, this is not allowing Congress to impose any new tax that it doesn't already have the power to impose. In fact, it's removing its power to impose a tax. Then that's the income tax, restoring the original intent of the framers. The reason why the 16th Amendment had to be ratified is because the framers did not give Congress the power to impose an income tax. This is removing that power. And what are they left with? They're left with the sales tax. They're left with the consumption tax. It's a tax that's transparent and isn't taken from your earnings, unbeknownst to many people. It's a tax that's very transparent, and in fact that we impose in many of our states. In Texas, we have a sales tax. We don't have an income tax, and we have one of the most thriving economies in the country because of it. Lastly, I want to point out that what we're talking about is a consumption tax. And when you tax something, you get less of it. What we don't want is a production tax. When we tax the labor of individuals, they're incentivized to produce less for their fellow citizens. Now, when we work, we get the ability to request other goods from our fellow citizens. Well, a consumption tax disincentivizes us taking and incentivizes us giving. which is why it's the most economically beneficial tax we can have. The problem is, in order to institute a consumption tax, we need to remove the danger of an income tax so we don't have both. That's what this amendment does. And then let me point out, Section 2 of this amendment is perhaps as important as Section 1. It requires a supermajority of Congress in order to increase taxes. I would submit that this is good for the economy. I would submit it's a structural change that allows individuals to be free and keep more of their labor. It's not a policy change. This is a structural change in the relationship of the federal government to its citizens and the way in which they see themselves and their labor. So, Mr. President, I move for adoption.
Thank you, Commissioner. Let me go to the Commissioner from Oregon, then New Jersey.
Thank you, Mr. Chairman. I also rise in opposition to this, namely where it says Congress shall have power to levy a uniform tax on the sale of goods. If the goal is to rein in the reach of the federal government, by my estimation, giving them a blank check without any parameters, without any limits, is not achieving that goal. So as such a vagary without limitation, there's no way on God's green earth that I'm going to trust the federal government to limit themselves on what that amount may be, just so long as it's uniform. Thank you.
Thank you, Commissioner. Commissioner from New Jersey.
Thank you, Mr. President. I rise in opposition to this also. Just a report from the committee. This particular proposition had to be culled out of the group of package propositions that we were going to vote on because it was odious to many members of the committee. It squeaked through the committee, to be quite frank with you. It didn't get overwhelming support. VAT taxes expand the cost of government. Countries with VAT taxes have a heavier total tax burden. They slow down economic growth and destroy jobs. This is a bad idea. This is not what we should be submitting to the public for their review and acceptance. Thank you.
Thank you, Commissioner. Let's go to the Commissioner from South Dakota.
Thank you, Mr. President. While I definitely appreciate the work of this committee to try to address what I believe is a very egregious reach of the federal government into the transactions between the private citizens, I don't think that the proposal on the screen is actually offering the right solution to the American people, because as the founders designed it, the federal government itself was a co-op, if you will, of the state governments. They did not design for the federal government to reach in and regulate transactions between private citizens to this extent. And right now with the income tax, they are doing that. But if I counted the number of times that paychecks are given out versus the number of times that sales are transacted, you're actually increasing the number of transactions where the federal government now can reach through the veil of the states and tax and control those transactions. I would suggest that if we're going to repeal the 16th Amendment, which may be a good proposal, we should present to the people the solution that the founders envisioned, which was that the federal government should tax the states, and then the states could turn around and do a consumption tax like a sales tax, and I think that would be a good solution to the problem, this one that the founders gave us in the beginning.
Thank you, Commissioner. Let me go to South Carolina and then Virginia.
Thank you, Mr. President. I rise in opposition to this particular amendment, and I'm most conflicted when I do that. I am the sponsor and have been for 3 terms of the South Carolina state fair tax. Fair tax policy I believe in wholeheartedly. I just think that it's a very complex issue. It doesn't get addressed fully in this. It will be misunderstood. I serve also on a tax review committee right now, currently, and we all know tax policy is extremely difficult, and it's all the detail is what counts. And while in principle I really believe in this, and it hurts me deeply to stand in opposition to it, I don't think this is the day and the time and the right place for this without much vetting. Thank you, sir.
Thank you, Commissioner. Let's go to the Commissioner from Virginia.
Mr. Chairman, I was in the Army a long time, and my JAG lawyers used to tell me that when we were in the middle of administering justice, if you feel real good about what you're getting ready to do, slow down, you're about to do something wrong. The maker of this proposal is absolutely correct in his intent. And were this amendment to repeal the 16th Amendment, it would indeed bring the Constitution back in line with the founding vision. That would be a good thing. Not the least of which, the joy, Mr. President, we would have in watching the IRS collapse in utter depression. But I would suggest to the maker of the amendment that were this body to be considering an amendment, that it is the straight-up repeal of the 16th Amendment, we might have more adherence among states across the nation than were we to essentially write into the Constitution the Fair Tax Act, which, Mr. President, I support. But the Constitution should be about tying the knot, not braiding the rope. And I offer that, Mr. President, for your consideration.
Thank you, Commissioner. Let me go to North Carolina, then Georgia.
Thank you, Mr. President. I was rising in support of this proposal. I've been listening to the comments, and I would certainly support if people wanted to simplify it and just simply say that we're repealing the 16th Amendment. I would support that, if that's what we need to do. I do want to add to some of the comments that my colleague from Texas made that has already made. I'm not going to repeat. I do think that the income tax is too intrusive. It's a usurpation of federal power. It's too complicated. There are tens of thousands of pages in the tax code. Most people don't understand it. They constantly change it. Financial magazines come out every year with 50 different tax returns going to different people and getting 50 different results from 50 different accountants. The income tax is used to manipulate citizens, to incentivize certain behaviors, to punish others. The income tax is too often avoided. It's virtually impossible, it seems, to strike a proper balance of being able to enforce it without giving too much power, and we've seen the abuse as certain groups and certain individuals are gone after. So I would just suggest to this body that if this language is not what you like and you just want something as simple as repealing the 16th Amendment, then great. But I would love to be able to go back and say that that was one thing that we discussed today that I think would be extremely popular with the American people, that people would like to see, that we did something in this very important area to rein in the federal government, bring them back into control, and certainly support repealing the 16th Amendment to the Constitution. Thank you.
Let me come to Illinois.
Thank you, Mr. Speaker. I rise in opposition as well. I want to echo many of the comments of the former speaker. I'm no fan of the complicated tax code. But the reason I came here is I think the existential threat to our country is the federal debt and the growth of that debt. If you look at the graph of the growth of debt just in the last 8 years, I think the Congress needs to have the flexibility to deal with that, at least for a generation. And so I would advise tabling this. I'm not making a motion, but I would advise setting this issue aside and focusing on how we deal with the debt in the short term.
Thank you, Commissioner. Yes, excuse me.
Mr. Chairman, if I would, I'd like to offer a substitute amendment, if possible.
If I could, we're in order, and I'll come to you if you're there.
Sure.
Unless it's a point of order, I need to go in order to where we are. Let me come to the gentleman from Georgia.
Thank you, Mr. President. I rise as a strong supporter of the concept of the fair tax and a co-sponsor of such a bill in my home state of Georgia. But I also live in the congressional district of the gentleman who introduces this bill in the Congress every year, and not only introduces it, but also is the author of the book on the fair tax. And I just want to make the point, in agreement with our friends from Connecticut, that This is tax policy. This is not something that belongs in the Constitution. He introduces this bill as a general bill in the Congress. So I just wanted to add that to our discussion. Thank you.
Thank you, Commissioner. Let me come back to New Jersey, then we'll come to Alabama.
I make a motion we table this for the time being.
Motion is to table the proposal. Do I have a second? Second from Alabama. That is non-debatable. Let the committee chairs in favor of tabling the motion, please say aye. Aye. Chairs opposed to tabling, please say nay.
So, Kim, we're watching something happen right now that both with the last amendment on the judicial review and now here with this tax proposal, flat tax proposal, that most everybody in this room is for, we're seeing very intense and deliberative debate. It's obvious these guys want to get it right. They're not willing to just pass something out because they're for it.
Well, and let's talk about the one that went right before this one, and that was the judicial review. That's one of the cornerstones of what it is we're trying to do with Article 5. And that has so many different elements to it, so many different innuendos, if you will.
Yeah.
It's very difficult to figure out how to verbalize it.
It's going to take time.
It's going to take time.
Which they don't have in a simulation, but they're going to have at a real convention.
That's exactly right. So what we've seen is a very thoughtful deliberation among the chairmen that decided, you know what, we're not going to get this right. We're not just going to be able, we don't want to throw something up against the wall just because we should or we can.
This isn't going to be a you can read it after we pass it situation.
That's exactly right.
Yeah.
And so they chose to table it.
Yeah.
And they chose to table it deliberately because they knew they didn't have the time or enough information to actually do it right. We're seeing that very same thing happen now.
Yeah, and which I think the take-home message for folks watching at home and for us is that should give us a boost of confidence in the process and in these people that they're, again, not going to be rash. They're actually going to be very, very serious and deliberative. They want to make sure they get it right. We're talking about amendments to our Constitution. They realize that. And I think in a real convention situation, we'd see them having weeks at a time on each of these issues to make sure they nail it, make sure they get it right when they send it back home.
Well, I think you're absolutely right. And I think the thing that has impressed me most so far is the direct, conscious thought of the commissioners and how seriously they're taking this.
Yeah.
Because this is very, and I keep going back to the word deliberative, but what we just saw with that amendment going down, and we all want that.
Right.
We all know we need that.
And they want that. You can hear it in the way that they're describing it.
But they also want to get it right.
Absolutely.
And they're not going to pass something just for appearance.
Absolutely.
And I think that's critical.
All right, let's see what's happening with this amendment when we come back.
Missouri votes no. Montana. Montana votes yes. Nebraska.
Nebraska is divided and abstains.
Nebraska abstains. Nevada. Nevada votes no. New Hampshire.
New Hampshire abstains.
New Hampshire abstains. New Jersey.
New Jersey came here to work too, but not to cause harm. We vote yes.
New Jersey votes yes. New Mexico.
New Mexico votes no.
New Mexico votes no. New York.
New York votes no.
New York votes no. North Carolina.
North Carolina votes no.
North Carolina votes no. North Dakota.
No.
North Dakota votes no. Ohio.
Ohio votes yes.
Ohio votes yes. Oklahoma. Oklahoma votes no. Oregon. Oregon votes yes. Pennsylvania.
Yes.
Pennsylvania votes yes. Rhode Island.
No.
Rhode Island votes yes. South Carolina.
Carolina reluctantly votes yes.
South Carolina votes yes. South Dakota. South Dakota votes no. Tennessee. Tennessee votes
No.
yes.
No, you were right first time.
Texas.
Point of order. Rhode Island voted no.
Rhode Island votes, okay. Rhode Island votes no. Tennessee voted yes. Texas.
Texas votes no.
Texas votes no. Utah.
Utah votes yes.
Utah votes yes. Vermont.
Vermont votes no.
Vermont votes no. Virginia.
Virginia abstains.
Virginia abstains. Washington.
Washington votes yes.
Washington votes yes. West Virginia. West Virginia abstains. Wisconsin.
Abstain.
Wisconsin abstains. Wyoming.
Yes.
Wyoming votes yes. Mr. Speaker, there are 21 yes, 21 no, and 8 abstentions.
I rule that the motion fails then. The motion to table fails. We are back to the underlying motion.
Go back.
Let me,
Let him make his,
yes, just a second. I think the underlying maker of the motion, did you have
Yes,
the underlying sponsor of the motion?
yes, Mr. President.
I think that the sponsor of the motion is here, the commissioner from Colorado. Did you?
Thank you, Mr. President. First, I'm encouraged that we continue the discussion because it is a very important issue. And let me say two things, if I might. And the first one is a more thorough description of the actual proposal, because understand, yes, it does deal with eliminating the 16th Amendment, which is a very significant step, which is a constitutional tax issue which must be addressed in constitutional amendment to make that so. But it deals with more than just income. It deals with the estate taxes as well.
Commissioner, I'm sorry, not to speak to the motion. I'm sorry, I understood that you wanted to perhaps either withdraw or substitute.
Okay, and that was going to bring me to my point that I'm trying to make.
If you'd state the motion up front.
I'll be more direct.
We were reminded to get back into our procedure of that. If you would state a motion up front.
I will move that we, let me think this through. We'll think it through as we talk it through. That Section 1 and Section 3 be removed from the proposal to preserve the Section 2 as a potential middle ground and important statement that would make a great step forward for this convention, I believe.
So if I could restate that, then let me see if I can restate this. Congress shall not impose or increase any tax, duty, impost without the approval of 3/5 of the House of Representatives, 3/5 of the Senate, and shall separately be presented to the President, and the remainder of Section 1, Section 3 would be deleted?
Yes.
Let me restate that again, Commissioners. So the substitute proposal would be that Congress shall not impose, delete the balance of Section 1, or increase any duty, impost, or excise. I think for grammatical sake, that would need to say without the...
Yes, we need a little bit of...
Without the approval of 3/5 of the House of Representatives, 3/5 of the Senate, and shall separately be presented to the President. And then Section 3 would be deleted as well.
I so move.
That's a substitute motion. Is there a second to the motion? Second from Alaska. Discussion to the substitute motion. Gentleman from Texas.
Mr. President.
This is now, if you're standing to speak, it's to the substitute motion.
Mr. President.
Yes.
They'll hate that because it's repealing the 16th.
I have a friendly amendment to the substitute motion, if possible.
That is in order.
Okay. My amendment would leave the part of Section 1 up until "but Congress shall have the power to levy a uniform tax on the sale of goods," and will only strike that section. And the reason why, and I've consulted with our drafters on it as well, is that if the intent is to repeal the 16th Amendment, the 16th Amendment is not repealed unless you have affirmative language saying that Congress shall not do what the 16th Amendment allows. The reason being is that under current jurisprudence, the Supreme Court would not need the 16th Amendment to allow Congress to levy an income tax. So if you strike the language, "but Congress shall have the power to levy a uniform tax on the sale of goods," that removes any fair tax mention or any sales tax mention. But it does repeal the 16th Amendment effectively. And I would ask the author if that's acceptable.
I'm not sure if I understand the motion. Can you state the motion in state the language in its entirety?
I move to substitute the substitute amendment.
To amend the substitute, and if you would state what that would read then.
It would read,
Section 1, Congress shall not impose taxes or other exactions upon incomes, gifts, or estates. Period. And that would be the amendment to Section 1.
And then the balance would then go back. Let me see if I get this correct then. So you would delete the balance of Section 1.
Yes.
And then you would pick up the same language, Congress shall not impose or increase any tax, duty, impost, or excise without the approval of 3/5 of the House of Representatives,
Correct.
3/5
That's
of the Senate.
exactly how it would read with that initial clause of Section 1 remaining to give effect to the repeal of this. Oh, I would leave in Section 3 as well.
So Section 3 is, because the substitute Section 3 is out.
Oh, Section 3 is out in the substitute?
Yeah, the substitute Section 3 is deleted.
Okay. Well, I move to amend the substitute amendment to leave in Section 3 in the first clause of Section 1.
So then your substitute would be to essentially return to the original proposal, simply removing or upon aggregate consumption or expenditure, but Congress shall have the power to levy a uniform sales tax.
Yes, Mr. President.
So that language would be out. The balance would remain the same. Is that correct?
Yes, Mr. President.
Okay. Do we have that reflected then, so we can make sure we know what we're looking at as an amendment? Let me see if I can read this back while you're entering this on the screen. Congress shall not impose taxes or other exactions upon incomes, gifts, or estates, period.
Good so far.
Delete the balance of Section 1. Am I stating this correctly, Commissioner?
Yes, Mr. President.
So far. Then Section 2, is your proposal to revert back or the changed language?
The changed language.
The changed language then, Congress shall not impose or increase any tax, duty, impost, or excise without the approval of 3/5 of the House of Representatives and 3/5 of the Senate, and shall separately be presented to the President, period. And then, I'm sorry, your proposal was Section 3 stays or goes?
Section 3 remains.
Section 3 remains as written in President. That is the motion?
Yes.
Is there a second to that motion? Second from Delaware. A discussion to the motion to amend the substitute motion. Let me recognize the gentleman, the Commissioner from Ohio.
Mr. President, is this a proper time to speak to the entire amendment?
We're on the amendment to the substitute motion. Do you want me to come back to you?
Yes, because there's some significant flaws here, prime time flaws, that I'd like to outline about this whole thing.
I'll come back to you. We're on whether or not to amend the substitute. Let me come to the Commissioner from Florida, then we'll go to Virginia.
Thank you, Mr. President. I would be in opposition to the amendment to the substitute motion. There are several questions, and I think Commissioner from Colorado was outlining those briefly before he made his motion, that there's some question, even as we talk to each other, if we just repeal, for example, the 16th Amendment, which much simpler language would be to steal from the 21st. It's already been written. We know how to correctly write a repeal. But gifts and estates, are those, do we want those to not be taxable at all? Have we had that thorough debate? Are we all in agreement that gifts and estates are separate from income? There are some questions, I think, still here that need to mature, whereas the substitute motion, which would strike completely Section 1 and 3, and leave simply the question before the body whether we believe Congress should have a 3/5 level in order to increase or impose taxes, is a very simple question, and one which I think we could adequately address this afternoon.
Thank you. Let me go to California. No? Okay, let me come here to Delaware, and then we'll come Alabama, Missouri, and then back to Virginia. This is to the motion to amend.
Mr. President, I do believe it's essential to leave in Section 3 As I listened to that being made, I thought it was going to be dropping out Section 3. I think a broad consensus in this body exists to eliminate the 16th Amendment, and I'm pleased to see that the amendment to the amendment would leave in Section 3, and I would support that.
Thank you. Let me go to the Commissioner from Alabama.
Thank you, Mr. President. I have an amendment that I guess my goal here would be then to amend the amendment.
Yeah, I don't think that's in order until we deal with the amendment to the substitute.
Okay, well, you'd come back to me.
We'll come back to you. Let me go to Virginia, and then we'll come to Missouri.
Okay. Mr. President, speaking to the amendment, I think that what the patron has done in the first section makes a lot of sense.
I'm sorry, can you get to your microphone closer?
As best I can, Mr. President. If you pick it up, it dies.
You don't have the challenge that our commissioner from Oklahoma does, so I'm not going to sympathize too hardly with you.
Unfortunately.
All right.
Mr. President, I believe that the patron's amendment to the first section makes a lot of sense, and I support it. I'm sure my delegation feels similarly about that. And there is some efficacy to leaving in Section 3 because you don't want to have a conflict in your Constitution where in one place you say there's no income tax and in the other place you have a reference to income taxes, how you apportion them and so on and so forth. That makes sense. My concern as a veteran and a former member of the U.S. Army for 28 years is Section 2. I am very supportive of raising the bar on raising taxes to the level that we can, because we have to have that sort of discipline. But my concern is national defense. And my concern about Section 2 is essentially embedding a filibuster rule in the Constitution. This gives me concern. And I hope as we go forward in our discussion about this overall amendment that we will give consideration to passing this resolution as it has been amended with the exclusion of Section 2 at this juncture. And if we want to find ways to limit the ease with which Congress levies taxes on us, then let's go to work to do that. But my concern is Congress's fundamental duty is to provide for the protection and the defense of this country. And my fear is what Section 2 might do to their ability to do that. I thank the President.
Thank you, Commissioner. Commissioner from Missouri.
Thank you, Mr. President. Always concerned about being too clever by half. Just a cursory reading of the grammar in Section 2. I believe we're forcing Congress to present themselves to the President, and I would offer a friendly amendment that we say at the last phrase there, shall separately present such to the President, if that would be accepted as a friendly amendment.
Yeah, I don't believe that's in order at this time, but if we come back on the resolution, I'll come back to you.
Okay.
We're still on an amendment to the substitute. Once we deal with the amendment to the substitute, we can come back and address that. Let's go to the gentleman from New Jersey. Have you spoken to this issue already?
I'm waiting on after this portion.
Okay, we're back to the underlying.
Thank you, Mr. President.
This is to the motion to amend the substitute. Gentleman from North Carolina. To the motion to amend.
Mr. President, I'm not sure if it's properly in order at this point or we should wait until after the motion to amend. My suggestion would be to separate this into two amendments and to take out separate Section 2 and deal with it separately for the clear reason that I just don't want for the motion to pass. I mean, not to pass.
Yeah, I think let's dispense let's dispense with the motion to amend, and then we can come back and visit that. This is to the motion to amend. Gentleman from Kentucky.
Thank you, Mr. President. I support the way this has just been amended. I think it makes sense to the state of Kentucky. If you have a state that currently has an income tax and your state has corporate tax, and that language in Section 1 were to stay, you can get rid of your economic development cabinet. If you live in a state where they have no income tax and maybe their corporate tax is low, it will be a great windfall for that state. Tennessee's a 2-hour drive from where I live in Lexington. I'm moving. It will make great sense for businesses to relocate away from states that currently have an income tax, because you'd have a hard time getting rid of that. So at the expense of states that do have a current income tax, you will be penalized in this effort to move to this fair tax without getting rid of your personal income tax obligations within your own states. So be careful what you ask for. You might get it. Thank you.
Thank you, Commissioner. Commissioner from Nevada.
Thank you, Mr. President. I rise in support of this substitute amendment. I am in favor of Section 1 as it is stated there, because I do oppose estate taxes. I don't think that we should be taxing estates or gifts or incomes. I also rise in support of Section 2. If Congress would like to raise money for the military during times of war, they can sell bonds. And I don't think that when we pass a tax for any kind of emergency, that tax goes away when the emergency goes away. Thank you very much, Mr. President.
Thank you, Commissioner. Commissioner from Georgia.
Mr. President, Georgia moves to call the question.
The question's been called on the motion to amend the substitute motion. Do I have a second to the motion to call the question? Second from Nevada. We have a motion seconded to call the question. Let me put this to the chairs of the committees. All in favor to call the question, please say aye.
Aye.
Opposed? Nay? We move on the question. So the vote then is on the motion to amend the substitute motion as reflected on the screen. Chairs of the committees, please say aye. Aye. Opposed? Nay? No. Mr. Secretary, let's have a roll call vote on that.
Alabama.
Alabama votes aye.
Can we have order in the House? Okay. Alabama votes. Alabama votes yes. Alaska.
Alaska votes yes.
Alaska votes yes. Arizona.
Arizona votes no.
Arizona votes no. Arkansas. Arkansas votes yes. California.
California votes yes.
California votes yes. Colorado.
Yes.
Colorado votes yes. Connecticut.
Connecticut votes yes.
Connecticut votes yes. Delaware.
Delaware votes yes.
Delaware votes yes. Florida.
No.
Florida votes no. Georgia.
No.
Georgia votes no. Hawaii.
Yes.
Hawaii votes yes. Idaho.
Yes.
Idaho votes yes. Illinois.
Pass.
Illinois abstains. Indiana.
Yes.
Indiana votes yes. Iowa.
Yes.
Iowa votes yes. Kansas.
Kansas votes yes.
Kansas votes yes. Kentucky. Kentucky votes yes. Louisiana. Louisiana is absent. Maine.
Maine votes yes.
Maine votes yes. Maryland.
Maryland votes yes.
Maryland votes yes. Massachusetts.
Yes.
Massachusetts votes yes. Michigan.
Michigan votes yes.
Michigan votes yes. Minnesota.
Yes.
Minnesota votes yes. Mississippi.
Mississippi votes yes.
Mississippi votes yes. Missouri.
Yes.
Missouri votes yes. Montana. Montana votes yes. Nebraska.
Nebraska votes yes.
Nebraska votes yes. Nevada. Nevada votes yes. New Hampshire.
New Hampshire votes yes.
New Hampshire votes yes. New Jersey.
Jersey votes no.
New Jersey votes no. New Mexico.
New Mexico votes yes.
New Mexico votes yes. New York.
New York votes yes.
New York votes yes. North Carolina.
North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio.
Ohio votes no.
Ohio votes no. Oklahoma.
Votes yes.
Oklahoma votes yes. Oregon. Oregon votes no. Pennsylvania.
Yes.
Pennsylvania votes yes. Rhode Island.
Yes.
Rhode Island votes yes. South Carolina. South Carolina votes yes. South Dakota. South Dakota votes no. Tennessee. Aye. Tennessee votes yes. Texas. Texas votes yes. Utah. Utah votes yes. Vermont.
Vermont, yes.
Vermont votes yes. Virginia. Virginia votes yes. Washington.
Washington votes yes.
Washington votes yes. West Virginia. West Virginia votes yes. Wisconsin. Wisconsin votes yes. Wyoming. Wyoming votes yes. Mr. President, there are 41 yeses, 7 noes, and 2 abstentions.
Rule that the motion to amend passes. We are back to the underlying substitute motion as amended. Gentlemen from, yes.
Mr. President.
We have, I'm sorry, point of order? No? We're back to the underlying motion. Let's come to the gentleman from Missouri, then Alabama.
Thank you, Mr.
So we're
President.
now on the substitute motion as just amended.
Thank you, Mr. President. I would again offer a friendly amendment to sponsor that we either change the subject in the last phrase there in section 2, or we be more specific about what's being presented, because the way it reads right now, it refers back to the original subject, which is Congress. So I would offer a friendly amendment that we just say, and shall separately present such to the President.
So in section 2, approval of 3/5 of the House of Representatives, 3/5 of the Senate, and shall separately present such to the President. Is that correct? Shall separately present such to the President?
Not presented.
Yes, shall separately present
Thank you.
such to the President. Does that correctly state your motion?
Yes, I offer that as a friendly amendment if it's accepted for the sake of time.
To the Commissioner from Colorado, friendly amendment?
This is a friendly amendment.
Friendly amendment. Let's try this without objection. We'll approve this. Do we need discussion? Any objection? Okay, I'll rule that that's amended without objection. To the underlying motion now, let me go to the gentleman from Ohio.
Thank you, Mr. President. At least from my view, there are significant questions that are not answered in this. Congress doesn't do it, collect the money. Who collects the money if not the federal government in some form or other? So you have to have an agency, no matter what it's named. Who spends the money? I think we're back to Congress and spending the money. So the tax and spend tyranny that we're all here to kind of alleviate, I don't think is answered in this amendment. I think it's not ready for prime time, needs some work, good idea, but I think we actually give them the ability, if they can figure out a way to do 3/5, to tax us more and to spend more. And there will be a federal agency doing it, because I don't know how you do it any other way than collecting a nationwide tax, sales or otherwise. Thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner from Alabama?
For a major decision that will have such great impact, and the raising of taxes is one of those issues that I believe does deserve more than the majority.
Thank you, Mr. President. I have an amendment, and I think it goes to the heart.
State the amendment.
The heart of our republic, and it's in section 2, in lines 2 and lines 3. Delete 3/5. And my reason for this, Mr. President, is our nation has operated since its inception under the concept of majority rule. If we can go back to breakfast this morning, had Patrick Henry's proposal required a 3/5 vote, Virginia would have never voted to go to war. And there are times, it's easy for us to go back and say, hey, we made it more difficult to raise taxes. But the flip side of that is we go home and we say, we made it more easy for minority rule in our country. And we've graveled and complained and growled about things like the North Carolina bathroom decision and how it seems like that small groups hold such great influence over our country today. And I think we're deviating from a well-worn path in this nation that served us well, and that's majority rule. And therefore, I offer this amendment, Mr. President.
So as I understand the amendment, Commissioner, is to delete the 3/5 requirement that Congress shall not impose or increase any tax, duty, impost, excise without the approval of the House of Representatives, the Senate, and shall separately present such to the President.
That is correct. Thank you, Mr. President.
So just to clarify, that puts it at a bare majority of Congress, puts it back to...
Just like any other piece of legislation, yes, sir.
Okay. Is there a second to the motion to amend?
It is.
Got a second from Ohio. Second to the motion, discussion to the motion to amend. If you're standing, it is to the, let me come to the maker of the motion for comment.
Thank you, Mr. President. I rise in opposition to this amendment, because two things. One, I would observe that I'm not sure what Section 2 does with that. And secondly, I would point out that there are many parts of our system of government that requires a supermajority, not the least of which is Article 5 itself for the amending process, both for states calling for a convention and states ratifying any amendment. It's most appropriate to set a high bar for a major decision that will have such great impact. And the raising of taxes is one of those issues that I believe does deserve more than the majority. I will be voting no.
Okay, we're to the motion to amend the substitute motion as stated. We'll go to the gentleman from Nevada, and we'll come to Florida. Sorry, we've got...
I would observe that the Section 2 as under the proposed amendment, removing the 3/5, essentially is redundant. It says Congress shall not do what it wants to on taxes unless Congress approves that. So logically, it's of no value with that amendment. Thank you.
Okay, thank you, Commissioner. Gentleman from Florida, we'll come back to Virginia.
Thank you, Mr. President. I think we see the argument. I would call the question.
Question's been called. Do I have a second? Second from Arizona. Chairmen of your delegation, the motion is to call the question on...
Point of order.
Yeah, state your point.
Did the gentleman speak before he made his motion? If he did, it's out of order.
No, I think he stated the motion. To call the question on the motion, the amendment as stated, deleting the 3/5 requirement. To call the question, all in favor say aye.
Aye.
Opposed, nay? No. To the question of the motion now, we've cut off debate now, to the question of whether or not to pass this amendment. Chairs of your delegations, please say aye. Opposed to passing this amendment, please say nay. Nay. I will rule that that motion fails. We are back to the underlying substitute motion as amended. Let me come to Virginia.
Thank you, Mr. President. I believe that the amendment, or rather, I believe that Section 2, as I have previously mentioned, really is unnecessary. And I believe that this approach would be actually strengthened in terms of gaining support across the country were we to strike the second section. and move forward. And I hope that there will be an amendment to do so.
Thank you, Commissioner. Let me just remind the body that we are now at 2:10. We have an hour and 20 minutes. We still have 2 proposals after this one that we still may consider, time permitting. This is now to the underlying substitute motion. Let me go to South Dakota.
Call the previous question.
The motion is to call the question on the substitute motion as amended. Do I have a second? Second from? Tennessee. So this is a motion to call the question on the substitute motion as amended. The question is whether or not this proposal shall pass. Chairs of your delegation, actually, well, this is the ultimate question. Mr. Secretary, would you do a roll call vote? Yes, state your point. Yes, so the vote is whether or not this proposal as amended shall pass. So this is on the ultimate question of this proposal.
Point of order.
Yes, state your point.
We did not do a voice vote on calling the question, to my
Oh,
recollection.
my apologies. My apologies. So whether or not to call the, no, I think we did we not? We did a vote. It was overwhelming to call the question. We are now on the question, a roll call vote on the question of whether or not this proposal shall pass. Mr. Secretary.
Alabama.
Alabama votes aye.
Alabama votes yes. Alaska. Alaska votes yes. Arizona.
Arizona votes yes.
Arizona votes yes. Arkansas. Arkansas votes yes. California.
The once and future golden state of California votes yes.
California votes yes. Colorado.
Yes.
Colorado votes yes. Connecticut.
Yes.
Connecticut votes yes. Delaware.
Delaware votes yes.
Delaware votes no. Florida.
Correction, Delaware votes yes.
Delaware, was that correct?
Sorry,
Delaware votes yes.
Yes.
Delaware votes yes.
I'll get it.
Florida.
No.
Florida votes no. Georgia.
Georgia votes no.
Georgia votes no. Hawaii.
Abstain.
Hawaii abstains. Idaho.
Votes yes.
Idaho votes yes. Illinois.
No.
Illinois votes no. Indiana.
Yes.
Indiana votes yes. Iowa.
Yes.
Iowa votes yes. Kansas.
Kansas is glad we stayed here to work and votes yes.
Kansas votes yes.
Excuse me, Mr. Secretary. Point of clarification, yes. Gentleman from West Virginia, state your point.
Not on the table, we're actually on this proposal, is that correct?
That's right. The amendment to the substitute passed, and so that's what's on the screen is the amended substitute motion. We're now voting on the ultimate pass or fail of the amended substitute.
Sorry, I thought I heard an additional amendment to strike section 2, and I wanted to make sure I wasn't voting to strike section 2.
Yeah, I think that was a comment without a motion as I understood that. Mr. Secretary, continue, please.
Kansas votes yes. Kentucky. Kentucky votes yes. Louisiana. Louisiana is absent. Maine.
Maine votes no.
Maine votes no. Maryland.
Maryland votes yes.
Maryland votes yes. Massachusetts.
Massachusetts votes yes.
Massachusetts votes yes. Michigan.
Michigan votes yes.
Michigan votes yes. Minnesota.
Yes.
Minnesota votes yes. Mississippi.
Mississippi abstains.
Mississippi abstains. Missouri. Missouri votes yes. Montana. Montana votes yes. Nebraska.
Yes.
Nebraska votes yes. Nevada.
Nevada votes yes.
Nevada votes yes. New Hampshire.
New Hampshire votes yes.
New Hampshire votes yes. New Jersey.
No.
New Jersey votes no. New Mexico.
New Mexico votes yes.
New Mexico votes yes. New York.
New York votes yes.
New York votes yes. North Carolina.
North Carolina votes yes.
North Carolina votes yes. North Dakota.
North Dakota votes yes.
North Dakota votes yes. Ohio. Does Ohio have a vote? Are they present?
No.
Ohio votes no, or they're not present. Ohio votes no?
That is correct.
Ohio votes no. Thank you. Oklahoma.
Oklahoma votes no.
Oklahoma votes no. Oregon. Oregon votes no. Pennsylvania.
No.
Pennsylvania votes no. Rhode Island.
Rhode Island votes no.
Rhode Island votes no. South Carolina. South Carolina votes yes. South Dakota.
Aye.
South Dakota votes yes. Tennessee. No. Tennessee votes no. Texas. Texas votes yes. Utah. I'm sorry? Utah votes no. Vermont.
Vermont votes yes.
Vermont votes yes. Virginia. Virginia votes yes. Washington.
Washington votes yes.
Washington votes yes.
Sorry, no. Washington votes no.
Washington votes no. West Virginia. West Virginia votes yes? Is West Virginia delegate still caucusing?
Clarification, West Virginia, yes? Yes.
West Virginia is a yes. Wisconsin. Wisconsin is a yes. Wyoming. Wyoming votes no. Mr. Chair, the votes are yes, 33, no, 14, 3 abstentions are absent.
Chair rules that proposal passes. We have an hour and 15 minutes, and we have 2 proposals left. We've got the 3rd proposal of the Fiscal Restraints Committee and the 3rd proposal from the Federal Legislative Executive Jurisdiction Committee, and we'll see what kind of time we work through. This has been a phenomenal day and great work and exciting to see this moving forward. Let's see where we get on these final 2 proposals. We recognize the Commissioner from Colorado.
Thank you, Mr. President. As chairman of the Fiscal Restraints Committee, I move our proposal number 3, which is a line item veto authority for the President.
Is that the end of your presentation?
And I urge its adoption.
Motion is to adopt proposal number 3 from the Fiscal Restraints Committee. Do I hear a second? Second from Tennessee. Discussion to the motion. Do we have this on the screen? We do, okay. Any discussion to the motion? Yes, California. Commissioner from California.
Mr. President, I wholeheartedly endorse this proposed amendment. It allows the President to serve as a check on pork barrel spending in Congress. If anything he vetoes by line item is something that the Congress has termed to be necessary, they can always override his veto. This will restore some important fiscal sanity to our national legislature.
Thank you, Commissioner. Further comments? Further comments to the further discussion to the motion? Yes, the gentleman from Oklahoma.
Thank you, Mr. President. We're here meeting to restrain federal power, federal government, and the executive branch. This empowers the executive branch immensely and lets them use this as a tool as retribution and different strategies with Congress. So I would wholeheartedly not support this proposal and ask us to consider whether this was empowering federal government or restraining federal government. Thank you.
Further discussion of the motion? Commissioner from Nevada.
Thank you, Mr. President. My concern is that this is not broad enough. It only concerns appropriation bills, and I'm concerned about riders on any bill. I like single subjects, and I like line item veto on any bill concerning any subject. So I would offer an amendment and strike the word.
I'm sorry, Commissioner, we've gone to where you've already spoken to this. You need to state your motion at the beginning. Perhaps as we go through, someone else may be able to make that motion.
Thank you, Mr. President.
Let me go to the Commissioner from Oregon.
Thank you, Mr. President. I rise in opposition to this amendment for the very reason of separation of powers. You have a legislative branch that's responsible for crafting legislation. You have an executive branch.
Can you speak closer to your microphone, please?
Separation of powers, ladies and gentlemen. You have a legislative branch responsible for crafting the laws. You have an executive who is responsible for executing those laws. I fundamentally believe that this endues or it provides legislative authority to the executive. And that's fundamentally wrong. It goes against absolutely the core of what legislating is about. And as state legislators, You understand how difficult it is to navigate and get a bill passed or a package through your legislature? How difficult it is in the Congress for the leadership to navigate and try to get the requisite number of votes to move things forward, and to provide the executive, the president, the ability to legislate through this manner and fashion, I think is absolutely and fundamentally wrong. And I'd urge you to vote no on this particular measure. Thank you.
Thank you, Commissioner. Let's come to the Commissioner from Arizona.
Thank you, Mr. President. Senator Lesko from Arizona. I rise in opposition to this amendment. We in Arizona have experienced this personally when the governor had line item veto power, and it was used to game the system and take away power from the legislature and give it more to the governor. And thus, I would encourage people to oppose this amendment.
Thank you. Let's go to the Commissioner from Kentucky.
Thank you, Mr. President. Case in point on this particular issue that we debate here, I oppose this legislation as it stands. I think of a bill that might reach the President's desk that was including heavily funding for Planned Parenthood. Yet other legislators had been successful in putting in some good issues pertaining to pro-life. Yet the President vetoes the pro-life, sends the bill back, you do not have the votes to override, and you are stuck with a vote that you're for Planned Parenthood. And I think this issue can have a reverse effect, thus landing many congressional members and even ourselves in a very precarious issue. Thank you.
Thank you, Commissioner. Commissioner from North Carolina.
Thank you, Mr. Chairman. Friends, maybe a generation or so ago, this might have been a good idea, but we live in the age of the imperial presidency, and rather than adding to their power, we need to be putting them in shrink wrap. So I stand in opposition to this. Thank you.
Thank you, Commissioner. Commissioner from Ohio.
Thank you, Mr. President. I rise in opposition to this amendment. In this power, if given, because of your political philosophy, conservatives, they could do something to liberal proposals. And if Ms. Clinton were elected and got this power, what happens to conservative proposals? It gives the ability, too much ability, for the president to hold the legislators.
Welcome back to the Convention of States, our live simulation. We're broadcasting live all over the world, and this has been incredible. I'd like to introduce Senator Dr. Tom Coburn, formerly known as Dr. No, or still maybe known as Dr. No.
Retired former senator.
Retired former Senator Dr. Tom Coburn. Thank
now
you for
Dr.
joining
Yes
us.
to
Yeah.
Convention of States.
Yes, absolutely.
Yes, that's right.
So, Senator, let me ask you this. What have you thought about the entire process so far, and especially what's going on right now?
Well, one, given that this is a mock convention, I love the intensity of the legislators.
They're not taking it lightly.
No, they're not. They're looking straight at this, and you know, these are issues that are really dear to them, but they're also issues that are really dear to the American people. And so, even though we're in mock mode, it doesn't seem that way at all in this room.
The thing that has impressed me the most is the careful consideration that these guys are applying to the job that they're doing.
Right, right. It's exciting for me to see the thought. You know, these aren't new concepts. They've been talked about a long time.
Yeah.
And that you can tell these members, these commissioners, have actually thought about all these things for a long time and thought about the downside as well as the upside. So I think some really reasoned judgment in the room, which is what I would expect out of the actual convention.
Yeah.
And knowledgeable people coming to make their points. And I'm excited. The quality of what's been offered has been very good as well.
The thing that I liked, we were talking about this earlier. They're not just willy-nilly passing things. I mean,
Right.
they have shot down proposed amendments. They're amending them with thoughtful consideration. I think it's very impressive.
Shot down things that are good ideas and things they're for, but they want to make sure they get it right. How does this change? You've been traveling the country encouraging people to consider this process. How does this change or impact how you talk to people about it now that you've seen it in action?
Well, you know, I don't think it changes at all how we talk about it. What our problem is not enough people know about this as the solution to solve the lack of confidence, the lack of effectiveness, the financial irresponsibility that's going on in Washington. And when they find out about it, they're excited. So, one, my hope is a lot of people hear this and get to find out, wow, what's going on?
Yeah.
And number two is, we can say we'd had a mock convention, and, there wasn't anything stupid here.
That's right.
Or out of control or any of those things.
No, and the rules are set. The rules have worked very effectively in terms of guiding people within certain parameters. So, I'm excited. I think it's going to be very helpful. I hope it's talked about a lot. But most importantly, I hope more people find out about what this wonderful solution our founders gave us, George Mason gave us, to be able to do this.
Well, and I think that's the most important piece, because this is a solution that is in our Constitution. It is constitutional and is the only avenue we have as citizens using our state legislators to fight back against the federal government's overreach. I mean, this is it. This is the only process we have, yes?
Well, what about just the, they always tell us just elect good people and it'll solve the problem. Look, you come out of the belly of the beast in D.C. for how many years? Are we going to solve it just by electing?
No, and there are great people in Washington. The quality of people is fine. The motivation is what's wrong.
Yeah.
And
the structure needs to change.
Well, actually, every decision in Washington is made on 2 points: what's best for the country versus what's best for my political career. And unfortunately, we have people who are long-term servers anymore, where the number one goal is getting reelected.
Yeah.
And we heard today in one of the comments about the average length of service that used to be in the late 19th century and the early 20th century versus how it changed after World War II.
Right.
And where we had these long-serving people. And basically what they came to Congress because they'd been long-serving in their states. And that doesn't mean they're bad people, but it means their motivation is conflicted.
Well, it was designed to be a citizen legislator. It was never designed to be a career path.
Right.
And now it has become that. And, that is part of the problem. And we can have the debate about term limits all we want, but the fact that we're having that debate, I think, is very powerful.
And the debate about the jurisdictions, the real structures of power, where the power rests. Do you think a convention of states really can change that and shift some of the power back to the states?
I think it will really rebalance the relationship between the states and the federal government, but also rebalance the relationship between the three branches, because what our founders designed has totally been disrupted by the Supreme Court.
Yeah.
And by the laziness of Congress, because they've given their power away.
You mean the founders didn't envision a Supreme Court that was going to call all the shots and make all the fun?
No, I don't think so. But it's amazing if you read the history. Early, within the first 25 years, the Supreme Court was starting to undermine the Commerce Clause.
Yeah.
And the General Welfare Clause. So this idea that 7 or 9 judges know better than what our founders, what our history, and what the people want, is ludicrous. They don't know better.
In the earlier session this morning, they passed a proposed amendment that would, in fact, redefine the Commerce Clause.
Yeah.
Right, back closer to what it was intended. Because remember, the Commerce Clause is what the federal government uses through the bureaucracy to justify all sorts of regulation.
Oh, yeah. And the court has not said no to Commerce Clause expansions ever since the switch in time to save 9 in the 30s.
Yeah.
I mean, one time in the 90s they said no, and technically Roberts said no in the Obamacare case, but just shifted it to a tax. But this is a way of actually wiping out all those decisions and coming back to the original intent, both with Commerce Clause and, as you mentioned, general welfare.
That's right. And my concept of the greatness of America is it really is of the people, by the people, for the people. And that only works if most of the decision making gets made close to the people.
Yeah.
If it gets made in Washington, I represented almost 4 million people. Hard for somebody to come and get in to see me and spend 30 minutes with me. And I couldn't do that with everybody in the state. It was impossible. Everybody that wanted to see me couldn't. So if, in fact, you move most of this decision-making back to the states, where you can actually hold people together, we can defeat state representatives and state senators if, in fact, they're wandering off.
Right.
We can organize as grassroots organizations, that we can organize as concerned citizens, and if somebody's actually moving away from the principles of our freedom and our liberty, we can defeat them.
Right.
It's hard to beat a sitting senator who has the power of incumbency and the millions and millions of dollars that are available to them. It's hard to do that.
Isn't that what Mason was speaking to when he put this in? I mean, he
Absolutely.
basically said when the feds get outside their box, they're not going to put themselves back in the box. The states have to be able to do that.
Yeah, he said, do you know at any time in any part of history where somebody has self-limited their own power?
Yeah, and the
I
idea.
mean, Cincinnatus did. He walked away. And George Washington.
And Washington walked away twice,
yeah,
but
who
that's a
else
rare,
did?
right?
Who else has?
Right.
It's not a common occurrence because it's not in the nature of man to give up power.
And Senator, I've seen you talk over and over again about the $140 trillion worth of unfunded mandates that we have, this, that, and the other, and you always use that same example. And the idea that Washington, D.C. will pass any amendment or any piece of legislation that somehow limits its own power is absurd in this day and age.
Well,
it is.
I will tell you, I have one observation, that if we're successful with an Article 5 Convention of States to offer amendments, the first thing you're going to see is the things we've been talking about, Congress
going to try to do it, yeah.
You bet.
Yeah.
Because, they don't want to give up their power. They want to control this. And so the very fact that citizens are now rising up, they're rising up because of the interference in your daily life. They're rising up because of the interference in your state government. And they're rising up because the fact is they bankrupted this country.
Senator Tom Coburn, thank you for joining us. We're going to go back and see what's going on the floor, and we're going to continue to watch the debate. We will be back.
Great.
Once again, I'd like to thank our subcommittees and our committee for working so diligently to come up with crafting some great proposals here. Chairman Holman, who chaired that subcommittee, did have to leave, but Commissioner Hill, Angela Hill, she's still here, and she worked hand in hand with the chairman of that subcommittee to craft this language. I'd like to defer to her to present this proposal and for the consideration of this body. Thank you, Mr. President.
Certainly, the commissioner from
Mississippi.
Mississippi is recognized.
Thank you, Mr. Chairman. Proposal 3 reads, whenever 1/4 of the members of the United States House of Representatives or the United States Senate transmits to the President their written declaration of opposition to any proposed or existing federal administrative regulation in whole or in part, it shall require a majority vote of the House of Representatives and Senate to adopt or affirm that regulation. Upon the transmittal of opposition, if Congress shall fail to vote within 180 days, such regulation shall be vacated. No proposed regulation challenged under the terms of this article shall go into effect without the approval of Congress. Congressional approval or rejection of a rule or regulation is not subject to presidential veto under Article 1, Section 7 of the U.S. Constitution. Now, what our committee intent in this was, in the previous amendment we've adopted, we gave a 3/5 vote to the states to abrogate a federal rule, law, or administrative directive. This is another check and balance, whereas 25% of either house of the legislature in D.C. could petition for Congress to have to review and vote on a rule or regulation, one that is in effect or one that is proposed. So this would be another check and a more timely method for Congress to be able to address a federal rule or regulation, and if members brought this to the attention of the Congress and they failed to act on it, it would automatically be vacated in 180 days.
Thank you. The motion is to adopt Proposal 3. I have a second from Delaware. Discussion to the motion to adopt Proposal 3.
Call the question.
Call the question.
I can almost not see him over those flags right there. Commissioner from Connecticut is recognized. Discussion to the motion.
Thank you very much, Mr. President. There was some lengthy discussion in our committee about this particular proposal, and I am certainly sympathetic to those who are concerned about Congress giving more and more authority outside of their jurisdiction and passing it on to the executive branch and administrative agencies to create regulations. And sometimes those are things that they can distance themselves from, but yet still have an effect. And further still, sometimes the executive will take the original intent of legislation and turn it into something else
via regulation. So those are certainly concerns that I share. I, however, don't agree that this is the proper way to address it. I think that a more appropriate way would simply to be like some states do and require that a legislative vote takes place to approve every regulation. My greater concern and the reason why I'm standing is not so much about that debate, but rather about the wording of this particular amendment proposal, and my concern that it can be used by a small minority to gum up the works or create leverage to obtain any kind of congressional action. My concern is where it says, upon the transmittal of opposition, which would be coming from a mere 25% of the members, you have an immediate vacation of a rule. So you could have a majority pass a law which requires a regulation to be adopted, and that regulation could be adopted in good faith to the law, but yet the minority still, if they could come up with 25%, could stop that immediately and require a vote to occur. I just think it could be used in ways that are way beyond what's been conceived in the discussion in the committee, and I would advise caution moving forward. Thank you, Mr. President.
Thank you, Commissioner. Let me go to the Commissioner from Ohio.
Move to amend.
Motion is to amend. That's in order.
To delete upon the transmittal of opposition if Congress.
And then the entirety.
And then the entirety after that.
So from upon transmittal to the balance of the article, is that correct? So the last 4 lines?
That is correct.
So the motion is to delete the last 4 lines, well, on my printed version. So upon transmittal, there we go. The motion is made and seconded. Discussion to the motion to amend. If you're standing, it is to discuss the motion to amend. Gentleman from Minnesota is recognized.
Thank you, Mr. Chair. This was extremely well debated within the committee with a very vocal minority, and we accessed the support staff in order to draft it most appropriately. And after several iterations, the current language before the amendment was what was decided by the body, and with consultation from staff as the appropriate way to address this. And I would be hesitant to open that can again.
Thank you. To the motion to amend, Commissioner from Arizona.
Thank you, Mr. President. I rise in opposition amendment to this proposal. I too served on this committee. We discussed this continuously for quite some time, and it was a majority of our committee that believed that the original language was the best to go forward, and I specifically would not like to remove the 180-day provision. And with that, I encourage people to oppose the most recent amendment.
Thank you, Commissioner. Commissioner from West Virginia.
Thank you, Mr. President. I would rise also in opposition to this particular amendment to the proposal. The Commissioner from Arizona touched on the reason why. I'm not sure that she fully detailed that out, but essentially with this amendment on here, what would happen is it says that Congress, the Senate and the House of Representatives would have to vote to adopt or affirm that regulation, but without a time limit, they could just essentially stall the clock and let it run forever. It could die in committee, et cetera, et cetera. So by putting something in there, it causes Congress to be forced to act or the regulation dies. So I think this negates that purpose and should be rejected because of that.
Commissioner. Commissioner from Colorado.
Thank you, Mr. President. I also am in opposition to this amendment, and the way I would characterize it is this amendment puts the authority in the hands of the leadership of Congress rather than the members of Congress, because in fact they could simply forestall the vote or in some other way prevent it. With the original language that this amendment, of course, takes away, as I'm reading this, the regulation must be voted on by Congress. Hence, the regulation, if ever questioned by a sufficient number of members of Congress, must pass that test to become law. And that is what I see the sense and the reason for Proposal 3. I urge the rejection of the amendment, the adoption of the proposal as originally written.
Thank you, Commissioner. Commissioner from Florida.
Thank you, Mr. President. I, too, think this amendment is very ill-advised. One of the most obstructive afflictions present in the Congress today is their postponement of action. A former member even told me, he said, you can't get a resolution approving Mother's Day passed up there in less than 6 months. And I think that to delete these words from this very good proposal number 3 is a gross mistake. We need to hold their feet to the fire. And to the point of the sponsor, the sponsor of the amendment. No, never mind. I'll just hush.
Thank you, Commissioner. Commissioner from Mississippi, my apologies. I should have come back to you on the amendment. Did you wish to speak to the amendment?
Yes, I also rise in opposition to the amendment because it deletes the strength of the original proposal, and what we would have without that second language is that Congress could sit on a proposed regulation for untold amount of time that an agency is proposing, and business and industry in this country needs some stability. They do not need to be hanging in the balance, wondering if Congress is going to act or not act indefinitely on a regulation. They have to spend money and they have to make decisions, and we think 180 days is a timely way for a business and industry in this country to know what's going to happen to them. So I do rise in opposition to this amendment, and I urge proposal of the original.
Thank you, Commissioner. Let me come to the Commissioner from Arkansas. Motion is to call the question. Do I hear a second? Second from Georgia. Let me take a vote on whether or not to call the question. Chairs of your delegations to call the question. Oh. This is to call the question. Welcome back to the convention. I'll come back to you after that. Live simulation. My name is Ken. To call the question, before we take a vote on the motion, I'll come back to you. To call the question.
To whether or not, or what happened actually with the line item veto. And so that was a proposal that they were debating heavily on the floor, lots of different amendments, and the line item veto was killed. That amendment was killed on the floor of the Convention of States simulation. So I just wanted to come on real quick and let everybody know. I know we've been getting a ton of feedback on social media. Thank you for those of you that are watching us. I know that there are thousands of different watch parties going on throughout the country right now. It's a very exciting thing, and I'll tell you what, this is terrific to watch. But the line item veto proposal was killed on a roll call vote. Thank you for joining me. We'll be back in a little while.
I would like to make an amendment. The first part is I remove the word if, and it says Congress shall vote within 180 days. And then I would remove such regulations would be vacated, because my complaint was with a lot of other people, we don't want Congress sitting on something. So plain and simple, Congress shall vote within 180 days. If they fail to, such regulations would be placed in effect.
Okay, I'm sorry if you. I'm not following the motion. Okay. Did you get that, Mr. Secretary?
Congress shall vote within 180 days. If Congress fails, such regulation will be placed in effect. No. Or enacted.
So is it?
That's a poison pill.
Shall be or placed in effect, but shall be enacted.
No.
The word vacate would be removed. So this would be forcing Congress to vote up or down within 180 days. Like the gentlewoman over there stated, business needs to know what's going to go on. And you got 180 days to must vote, and it takes the power out of the House Speaker and the Majority Leader of the Senate to decide if they're going to take it out of drawer or not. Otherwise, the other way is two people can decide whether it's even going to come up for a vote in a 6-month period. So Congress shall vote within 180 days. If Congress fails, such regulation shall be placed in effect.
Okay, the motion is as it shows on the screen?
Yes.
Okay, so the motion is as it shows on the screen. Congress shall vote within 180 days. If Congress fails, such regulation shall be placed in effect. Is there a second to that motion? Second from Connecticut. So the motion to amend has been made and seconded. Discussion to the motion to amend. If you are standing, it is to speak to the motion to amend. Let me come back to the underlying maker of the motion for comment first.
Thank you, Mr. Chairman. This is an unfriendly amendment, and I believe that it negates the intent of the amendment of the proposal. We already have provision in there that if Congress fails to act, that the amendment is vacated. So if they fail to act, they're in essence acting already. So we think this is not necessary, and it is harmful to the final passage of this amendment. So I do not suggest we adopt. Move to call the question.
That's not in order. I will, let's see, gentleman from Florida. The motion's not in order after speaking. Gentleman from Florida is recognized.
Call the question.
Call the question. Do I hear a second? Second from Michigan. All in favor of calling the question, chairs please say aye. Aye. Opposed, nay? We will now place the question on the motion to amend. We've cut off debate. I'm going to take this by a voice vote. I'm sorry? This is to call the question on the motion to amend. Oh, I'm sorry. Let me go back to the sponsor of the motion to amend. The sponsor of the amendment, New Hampshire, would you like to speak briefly to the...
Yes, sir. Because what happens is 25% of the people go and say, I have a problem with this regulation. Then the regulation can't be placed in effect until the whole Congress acts on it. So if Congress doesn't act on it within 180 days, 25% of the people have taken the power away from the president. Instead, the majority vote of the House passed it. The president the president puts in a regulation. I know I'm repeating myself. 25% of the people complain. The regulation is not put in effect. And then if Congress doesn't act within 180 days, those 25 people have basically vacated the president or Congress's intent to put a regulation in.
Thank you, Commissioner. We'll now place the motion. This is the motion, the vote on the motion to amend. All in favor of the motion to amend, please say aye. Aye. Opposed to the motion to amend, nay. Nay. I'll rule the motion fails. We are back to the underlying...
Call the question.
Excuse me, I haven't recognized anyone. We're back to the underlying proposal of Commissioner from Arkansas, or I'm sorry, from Alaska.
Thank you, Mr. President. I know people are wanting to get out and stuff, but this, sometimes when we go too fast, we forget people are watching. So I just want to be concerned about that. But I keep hearing about this 25%, and we're so concerned, that 25% is going to have control. We have 5 or 10 people sometimes, maybe not that much in the EPA that's making decisions. And I'm telling you right now, they'd love to shut Alaska down. So 25% actually is more people than what we have going for regulations. But we need a check and balance. And we don't need to reward Congress for doing nothing. They already do nothing. That's the whole reason we're here. And Mr. President, I'm not going to make an amendment because I think 180 days is too long, but because I know we are short on time. I'm not going to do that. But, I just want to bring it back because I know everybody has worked hard, but what Congress is allowing to happen as they pass bills and allow regulations to be written on bills that were passed years and years and years ago that are literally shutting our states down. To me, this is one of the most important things, especially for us in Alaska, because we own less than 1% of the land in Alaska. Let me say it again, less than.
Well, the action continues on the floor. We have Professor Randy Barnett with us from Georgetown. He's a constitutional law professor. For a constitutional law professor, this has got to be like best vacation of your life or something. I mean,
it has been amazing.
Yeah,
it has been amazing, and I've taken away a lot from this. For one thing, I have a high regard for the skill set of state legislators who know how to comport themselves in a debate, the way they address each other, the way they chair things. They're professional legislators, and they know how to do this.
Well,
they're
statesmen. I think that is the word that we need to use to describe them, because there hasn't been, it's been done in a very professional manner.
Right. Well, professional is what I mean to stress, that there is a profession of lawmaking.
Right.
And they are showing the skill. I was a former trial lawyer. I pride myself on my ability to question witnesses. It's a skill set. And they have a different skill set, the skill set of being able to address each other with decorum and run a meeting with decorum. And I admire that.
And how about even just the analysis of even the language of what they're dealing with? What has struck you with regard to how deliberative they're being and how detailed they're being and making sure they get it right?
Well, look, I mean, 3 of the provisions that were approved are provisions that I proposed back in 2009 in the Bill of Federalism that I published in Forbes.com. But they've been rewritten since then. And they've been rewritten by the committees, and they've been rewritten on the floor. And I have to say they were improved. I mean, so, I did the best job I could in getting this idea across, but the finished product that was produced by both the committees and the floor debate was better than what I did.
That's interesting, because can you remember Mike Ferris said the same thing about some of the language that he had written? It's that iron sharpening iron, that deliberative body coming together and making it even better than you might have done on your own.
There were people that spotted problems in it that I hadn't seen.
Yeah.
And in response to that, I agreed with the changes that they decided to make to my own language.
Yeah.
And so I do admire that. And I know that in one of the committees that I was advising, I had actually strongly advocated a particular provision of one of the pieces that passed, and one of the delegates, one of the commissioners, objected to it. And I'll be darned if I wasn't persuaded by her objection.
No kidding.
I just withdrew my suggestion.
Well, and I think that speaks to the caliber of people that are in this room. And we've been asked on social media over and over again, who are these people and why are they here? And we've answered that over and over again. But we've got representatives, we've got commissioners from all 50 states. The majority of them are elected officials, so they run their own committees back in their own states.
Right.
And so these are statesmen, these are people that get it, and they understand that the Article 5 process is the way that we fight back against the federal government, the only way that we can do that. And that is ultimately why we're here. But Professor, I got to ask you, it's got to be surreal to see some of the things you wrote that long ago in 2009 now being debated.
It is surreal. It is surreal. I'm happy to say that the 3 of mine that got considered were approved, and then there were a couple that weren't approved.
You're batting 1,000, man.
Those were not mine. But I actually think, and I think Mark may have made this point earlier, the very fact that this body disapproved, tabled one and disapproved another, shows that it was a deliberative body who took this exercise seriously. It's a simulation.
Yeah.
But nobody on the floor is really acting like it's a simulation.
Right.
They're taking this very seriously.
And again, those were items they were philosophically aligned with.
Yes.
But they knew the language was not yet ready.
It was not yet ready, or it was going to create untoward opposition to the entire project. Considering the views of people outside this room, it's a deliberative body acting in a deliberative way.
Yeah.
Well, it was funny when they were talking about the repeal of the 16th Amendment, basically, and that amendment, which did, in fact, pass just a little while ago. After they passed it, I was all excited, and then I had to remember, this is a simulation. Yeah, it was really bumming me out. But that goes to the power of Article 5 and what we can, in fact, accomplish.
So
and
true.
if you want to save this country, you want to restore liberty and our beloved republic, this is the way to do it, Professor.
And not only that, but look, let's suppose you have a convention and it produces amendments like this. Now the country is going to be debating something.
That's right.
We're not going to be just debating personality and who's lying and who's not, who's lying about this and who's not lying about this, and the state of this person's health or that person's health. We're actually going to be debating the Constitution and structure of our form of government in the effort of trying to restore our American republic.
Yeah, I've thought for a long time, even if nothing actually got adopted and then sent to the states and actually ratified, the education for the American people of this being on the news every night. But coming back to the last question on the constitutionality itself, are we following the Constitution right now?
Absolutely. I mean, and for those of the people out there who think that there's some kind of sacrilege in having an amendments convention, you have to ask those people, did the founders make a mistake by giving us Article 5 power to have a convention? Were the founders wrong when they gave us an Article 5 convention power? And so maybe they're against the founders, actually.
Right. I don't think they were wrong. I think they got it right, and it's time for us to get it right.
We can thank George Mason for that, because he's the guy that got it in there.
As you can hear by the excitement going on behind us, there's a lot going on, so we're going to go back to the floor. Thank you for joining us. We will be back right after this.
Matter of business.
Thank you, Mr. President. Members, this is referring back to my previous statement earlier. I would like for us to adopt as an official statement of this convention the following. The convention submits these proposals to the American people, these proposals meaning the proposals that we've adopted today. We submit these proposals to the American people with the conviction that they are a sound beginning to a critically needed national discussion about restoring the balance of power between the federal government and the states. Further, it is the conviction of this body that the states must deliberate and adopt appropriate proposals for a balanced budget amendment and an amendment to provide the states a means to serve as a check on judicial overreach by the federal judiciary of these United States. I move the adoption of this statement, Mr. President.
Motion is to adopt. We have a motion to adopt the language as a statement from the convention, seconded by everybody. We'll go with New Mexico then. Seconded by New Mexico. Any discussion to the proposal? Seeing none. All in favor, please say aye. Any opposed?
No. Yes. No. Ohio votes no.
Ohio votes no.
Sorry you didn't recognize me. I wanted to offer a friendly amendment that included term limits in the resolution. I know the movement, perhaps that's not his favorite topic, but I think term limits was left out. Congressional term limits.
We passed that.
But it's not in the resolution.
We passed that.
Oh, okay. I'm sorry.
Okay.
Misunderstood.
Okay, so I'll rule that that passes. And Kansas, we have a motion from, yes, Kansas. Oh, excuse me, before we go to that, I'll come to you in just a second. I want to just tell you, it has been a distinct honor to sit up here. This is incredible to see what's happening from this vantage point. The energy, the conscientiousness in something that is a mere simulation that you brought to this project. It's been a distinct honor to be here to see. I wish you could see what I saw from here, to see your work and to see what you've done. I'm thrilled and honored that you're here and you put the attention that you've done. George Washington made this statement that he said in his farewell address. This was one of the 4 critical governing documents that used to be studied in schools. If in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be changed by an amendment in the way the Constitution designates. But let there be no change by usurpation. For though in one instance this may be the instrument of good, it is the customary weapon by which free governments are destroyed. That's the process that we're engaged in. We talked about the tires and the balance of the tires at the beginning of this and the air in the tires. We had an owner's manual for the amount of pressure that goes in those tires. And like a gas, like air in a tire, a gas will expand to fill the space that's given to it. And government, like that, expands to the limit that it's checked. Left unchecked, government expands limitlessly. That's what we're seeing. That's what we've been discussing. You've indulged me with my car wash rule. My father owned car washes. As I was growing up, I started working in car washes from the time that I was 8 years old in Arizona, washing and drying and folding towels from 8 years old. And my father then became a pilot. And as a pilot, we would fly from Utah to Arizona. He had businesses in both places. And every time we flew, every single time, I can't remember a single time that we flew that he did not say, "Your engine just went out. Where are you going to land?" And we would scout around. I mean, even flying over the Grand Canyon, "Your engine went out. Where are you going to land? You've got this much glide distance." And he said, "You know, pilots walk away from most crashes as long as they fly the plane until it stops. Pilots perish when they panic. Fly the plane until it stops. Keep your hand on the wheel until it stops, and pilots survive." Constitutionally, just like that bicycle is a vehicle, as an airplane, there's some mayday out there. You're here because your people in your states know that there's some mayday signals on many areas that we've discussed, many we didn't have time given the constraints that we have to discuss. Pilots perish when they panic, but thank you for keeping your hands on the wheel. Thank you for flying this plane. Hopefully it never stops. I submit it never will. But we have that instrument in Article 5 to deal with this. I'm so honored to serve with you. I'm so honored to have had this privilege to see this in action. Thank you for your good work. Thank you for what you take back. And now it's time for us to be leaders among leaders. To take this back, take this spirit that we felt, what many of you have discussed as, I asked the question to some of you, what went well in your committees? And it was fun to see the eyes light up and said, we started out, we didn't know where we were going, what we were doing, and then almost like magic, the process brought things together. And that is the beauty of self-governance. That's the beauty of here beginning to exercise again our self-governance muscles, and that's what our system is all about. So thank you, I applaud you, thank you for the work that you've done, and again, I'm honored to this. I will now go to Kansas for one final motion. We are going to have a motion here. I just want us to take a final moment as a body and recognize the tireless effort that has gone in from so many people, seen and unseen, to make this happen. I would like us to please thank our host, the Citizens for Self-Governance, the Convention of States Project. Let's please give them a hand. This is indeed a Herculean effort that is writing the history of this moment. We're in a historic place, and we see good people that have stepped up that are writing the history of what we're doing. Thank you so very, very much. I want to go to one final motion from the commissioner from Kansas.
I have never seen a motion to reconsider get a standing ovation before. So that's the wrong page, sorry. Mr. Speaker, I'd like to ask for a point of personal privilege for the president of the Citizens for Self-Governance, Mark Meckler, to make some comments to the body.
That is in order.
There are some people that it is extraordinarily important that I recognize that
that made this possible. And I would ask that you hold your applause, but I am going to specifically recognize some people. And first and foremost in this process, in bringing this body together, I have to recognize Michael Ferris. Mike, I literally don't know anybody else who would have attempted something so large. This is the man, if you don't know it, who made sure that he engaged in the fight that made homeschooling legal in America. And as if that weren't enough, right? As if that weren't enough, he then went and founded Patrick Henry College, a great Christian institution educating Christian warriors who go out and fight the fight across this country. And then at a time when most people would have retired and rested on their laurels, Mike Ferris decided that we needed to reform our entire system of governance through the Convention of States. Really extraordinary. Thank you, Michael. You know, so he conceived this idea years ago, brought it to our organization. It's been an incredible privilege to work with him. But what's most important is the team that came together around the idea. Mike couldn't have done this himself. I certainly couldn't have done it myself. And I have been privileged to work for the last 3 years and certainly leading into this event with the most extraordinary group of people I've ever worked with. And there's something especially extraordinary about them that I want you to know because it's a little odd. And it's something that you would notice, you might notice when I tell it to you, but you wouldn't notice otherwise. And that is that our organization begins from a very simple phrase, and that phrase is something that's quite unusual in our body politic today. And the phrase is 2 words, and those words are, be nice. It's odd in politics today, but when we founded our organization, we recognized that politics had become mean. It was always so mean-spirited, and people were vicious, and people were rude to each other, and it was combative and attacking. And we didn't believe that you had to do politics that way. We believe that you could engage in spirited debate without being mean. We believe that you didn't have to put the knife in behind people's backs to get things done. We believe you could look them in the eyes and have spirited debate and discussion and even dissent, but always be nice to the people around you. Always be kind to the people around you. So we have assembled a staff nationally that is extraordinary. 28 full-time staffers now, literally hundreds of state-level volunteers, thousands of field volunteers in the state. And the mantra remains in our organization, we don't even have to say it anymore. It's be nice. So there's a staff here that has done everything in their power to make your experience wonderful. And one of the leaders of that staff that I have to point out is Rita Dunaway. The structure and the substance of what you see here today, the way this convention operated so smoothly, there is really a single person who was responsible for that, and that is Rita Dunaway. I spend my time flying around the country, going to grassroots meetings, doing media, pretty much going wherever I'm told to go and be wherever I'm told to be. And there's somebody that makes sure that the trains run on time when I'm doing that the things that need to be done in our organization get done, that the hotels get booked, that the flights get scheduled. And if it weren't for him, none of this would happen. He's somebody that I've been privileged to know literally since I was 19 years old. We've been best friends for our entire lives. And I'd like to recognize Mike Ruthenberg. Mike? I would be greatly remiss if I didn't recognize the most important person in the room, because she's the one that makes sure everything in my life runs well. And that is my wife, Patty Meckler. And Patty not only is the person who makes sure my life runs well and is always there for me, but she is also the person who makes sure that everything that this organization does, including this conference, gets paid for. There is a reason that we were able to fly so many of you from around the country, to pay for hotel rooms, to pay for all of this. It takes somebody with vision and commitment and drive to be able to put this message out to donors. We now have roughly 70,000 donors across the country, largely because of her efforts. You have to know, if you've ever met her, that I'm married way up. So please thank my wife, Patty Meckler. I think you've had a couple of extraordinary gentlemen sitting here. People ask, where are the millennials? Here are the millennials. This thing ran smoothly because you have a parliamentarian who took the time to know Mason's manual, who spent the hours, the weeks, the months to know it. He's participated in other simulations. He is at the very senior level in his academic career of being a college freshman. So I'd like you to give Spencer, our parliamentarian, a big round of applause. Sitting next to Spencer is a young man who has a wisdom far beyond his years. I think you would agree this thing ran incredibly smoothly. The votes were perfect. Everything was calculated right. Things run on time. We were privileged to hire Robert Kelly straight out of law school. And he's been with us ever since he came out of law school. He is way better than most senior lawyers I know. He makes sure that I don't do anything that gets me in trouble. And it's really an incredible privilege to have him serving as our secretary today, Robert Kelly. So I could go through and recognize the whole staff, but that would take a long time, so I will save you that pain. But let me just tell you that without them, without every single one of them, what happened here today, what's happening all across the country right now would be impossible. So I'd ask that you thank the staff of Citizens for Self-Governance. They're in the blue shirts all over the room. God bless you guys. Thank you very much. So before I turn the convention back over to Ken, and I appreciate the point of personal privilege that allowed me to do this, I want to thank all of you. A lot of you have come up to me or to other members of our staff and thanked us. All we were able to do was set the table, right? To make it happen took you. It took your commitment. It took your diligence. It took your intelligence. It took your passion and your patriotism to travel across the country and to come here and to be here and to participate in this. And once the convention started, it was sort of like dropping your kid off at college. It was off on its own, right? There wasn't much we could do about it. We sat in the back of the room. We were in and out. We watched it on the live feed. But you guys were on your own. And you excelled. Beyond our wildest expectations, you excelled. Over and over from everybody I talked to, they were astounded by the performance of this body, by the statesmanship that they saw exhibited by this body, by the intelligence and the passion of the debate, the demeanor of every one of you in this room. You have proven beyond a shadow of a doubt to the country that the people of the United States of America are ready to hold the first Article 5 convention in the history of this country. I congratulate you, I salute you, and may God bless you. Thank you very much. The question facing us and facing our fellow countrymen is a two-word question, very simply, who decides? The American founders had a simple answer. We, the people, decide.